Good morning, good afternoon, and if you're replay crew, good evening, good night, happy whatever day it is, wherever you are watching this, whenever you are watching it. But for me, it is Thursday, it's April 10th. Today I was going to be covering the continued hearing in Idaho, but Judge H yesterday in Idaho was just like, we're getting it done, and blasted through 27 motions in an incredibly long court day. So today it opened up a little bit of time to cover a hearing from April 7th that I have not covered yet because things have been so busy. So we are going to go to Utah today and just back in time a little bit to Monday to cover the hearing in the Kouri Richins case. This hearing garnered a lot of headlines, so I appreciate no spoilers in the chat. However, at the end of the day, this hearing delayed the trial. So that's the punchline. At least we won't be spoiled on that. But it's important, I think, to get to why this trial got delayed, to see what happened in court. And we all love Judge M. Like we all love Judge M. Plus, my amazing producer, Miguelina and Team Baker, endeavored their best to clean up the audio from deep fried microphone to much better than deep fried microphone. And it's been a minute since we've checked in with this case, and I miss it, you miss it. And look, I had a supervisor at the DA's office, and I would go into her office, and my colleagues and I that came into the office around the same time all talk about this same supervisor who we just adored, but sometimes had all of the frustration with, and here's why. Would go flying into her office with my hair on fire and being like, but this and 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 all these things, and they're all colliding and everything's happening at once, and I can't possibly be 17 places at once, and sometimes this job feels like I need to be 17 places at once, and I literally can't. She would be like, take a breath and sit down. Okay. She's like, it's all gonna work out. I'm like, this is your advice. It's all gonna work out. She's like, it's all gonna work out. You can't be two places at once. You can't be all the places at once. You can't figure out how it's going to work out. You do the best you can, and it's all going to work out. And you know what? It always did. It always did. Something always happened. This case moved. That case moved. A judge was like, we need to put this over. A defense attorney was like, I'm going to be in another trial. It all worked out. It wasn't always pleasant in the squish bit before it all worked out. But it all worked out because you can only do what you can do. And it will work out. So I was getting a little bit stressed about the Karen Reed case and the Kouri Richins case going to trial at the same time. Why? Fucking FOMO. I am so deeply invested in the Kouri Richins case going forward. We've seen the Karen Reed case before. Yes, I am invested, but also I feel like we're in the last season of a show that we loved, and the last season is just not it. Why is my child calling me? Chat. Son, I am live streaming. Is everything okay? Just text me. It's all just, okay, I'll look at my text. It's all good. Just do it. You're all good. Yes. Yes, you're all good. Love you, buddy. Sorry if that is your alarm. Yes, it's all good. He's so conscientious. So he is we will finish the story in just a second of it will all work out and with the Kouri Richins case. But when my kid calls midday, I'm like, everything good? He has joined DCI. And there is some stuff he needed for their camp in the spring. And so he was like, I just wanted to make sure that this is fine. This is what I'm ordering. We're all good. So he's trying to get stuff done. And when you are in the ADHD role of getting stuff done, I don't want to slow his role. So I'm like, yes, go ahead. Go ahead. I don't even know where I was. But yes, how I answer the phone is, are you okay? Are you good? Is everything good? So everything will work out. Oh, FOMO. I am deeply invested in the Kouri Richins case going to trial. We have not seen this case go to trial yet. The Karen Read case I am also invested in. However, there are times I feel like we can't look away. And there are times that I am also fatigued. Brennan is fatiguing. The nonsense that is going on in that case at times is so frustrating. It is absolutely fatiguing. And I am tired. And a lot of you are tired, but we're invested now. It's like you can't turn off the last season, even though you're like, I need to get to the end, but it's not an enjoyable journey. But we're in it. We're in it till the end, even in the times that it's not easy. With the Kouri Richins case, there's way more dopamine for me. So I was really worried about those two things happening at the same time because my brain is just like, I want to run to Utah and Judge M. It's also hard to put aside the case with the judge that I prefer to listen to. So I was starting to get squished with the FOMO of these two things will be going on at the same time. So midway in, I was talking to my team and I'm like, we're going to have to figure out how to do this. But the judge is not allowing the Richins case to be streamed. So it's going to be on delay no matter what. And we can figure out what that looks like. But I also want to watch the testimony come in. I want to watch the verdict come in. I don't want to miss that case in as close to real time as we can get it. And then I'm talking to Judge Abby, and Judge Abby's like, it'll all work out. And guess what? We now have a delay in the Kouri Richins case, so it will all work out, which might give us more time to figure out if we can persuade this judge to live stream it. But based on some of the comments at the end of the hearing today, I think that is unlikely, but we'll see. So today we are watching the Kouri Richins hearing from Monday. There might be parts that we zoom a little bit. We'll talk about it. And we'll talk about it. So as the Karen Read case gets underway, it looks like next week, we'll go through the Karen Read case. I've seen many of you ask me to cover the Vallow case. I cannot. I'm not going to. I'm sure you guys are watching it. I know Peter is covering it. I'm sure others are covering it. I can't with her. And I didn't cover the case where her kids were involved. I'm not covering the subsequent cases. I can't with her. And so it's not helpful. And the only reason I would be covering Vallow at this point is to see if she did something dumb as her own attorney. And that's not really helpful legal commentary. It's just like joint schadenfreude. That's not helpful. At least here I feel like I can be helpful and explain. And Peter will pull up the highlights and other people will get you handled. But it's going to be slogging. And all of it is, I don't have a lot of objectivity there. And that is why I don't cover cases where kids are victims. It's why I didn't prosecute cases where kids are victims. It is very, it's hard for me to take a step back. So I cover cases where I can take a step back and give you the legal analysis. And so that's what I do. All right, let's roll the intro. And then let's give a road so far on this case because it's needed. And then we'll just hop into court, shall we? I think we shall. Lawnards, let me know where you're coming in from, what you're drinking. I've got some of a coffee and a lot of water. So that's where we're at today. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
But first, there is a super chat I would like to pull up and congratulate Kadora. Kadora, we have been on this journey, I feel like, as a law nerd community with you. Kadora said, might be one of my last lives before switching to Replay Crew. Voice court reporting exam is on the 25th. Thank you, law nerds and EDB, for all the encouragement during this craziness. Testing speed is 225 words per minute for testimony. EDB air goes to Missouri. Be on the lookout for a new law nerd. I think Missouri is MO. I hope I am accurate in that. But congratulations, Kadora. It's going to be amazing. My best testing remembrance is, and I don't think there are many tests where you can't redo it. Just, it's going to be fine. It's going to be fine. What did I tell my kid when he went into the ACTs? I'm like, you can take it again. It's going to be fine. If you put pressure on yourself, it will not be fine. You have to just let it flow. It's like when you are in anything that is high pressure, you have to find a way to reduce the pressure on yourself so you can just let it flow and try to enjoy the process. And that's how I went into the bar exam. I had, and I've told this story before, but not recently. I had surgery not very long before the California bar exam that was unexpected and unprepared for and necessary. And so as I was getting into the heaviest part of my studying for the California bar exam, I was instead having surgery. So my mindset shifted to, I can only do what I can do. I can only do what I can do. I needed to have surgery. I need to recover. I need to sit down for 3 days and take this exam. I can only do what I can do. And it's going to be fine. And the bar exam is pass fail. So we don't need to be a hero. We need to pass. Like, I don't need to win everything. I don't need to beat everybody. I just need to pass. It's going to be fine. And so I went into the bar exam. People are like, are you stressed? I'm like, it's going to be what it's going to be. But also, I had surgery. Like, it is what it is. This is where we're at. Hope we're prepared. We'll do our best. And that has helped, even when there are things that are really important to me, to say, it's going to be what it's going to be. I really want the thing to happen, but it's going to be what it's going to be. And just try to take the pressure off and enjoy the process. I never enjoy the process of test taking. I do get anxious, but also you have to sleep. The best advice I ever got when studying for the bar was from a mentor at the DA's office. You have to move, you have to eat, you have to sleep. You have to do those things. It doesn't matter how long you study. If you don't do those 3 things, your brain's not going to work. You have to move, you have to eat, you have to sleep. That's it. And that is how I went through part of law school and bar study. So when people were cramming 15 plus hours a day, which my brain's not going to retain anything. When people were cramming 15 plus hours a day on Fridays, my husband and I were going to the movies every single Friday when I studied for the bar. It was summer, and it was not summer. It was summer in the early 2000s when like there was a new summer blockbuster like every single week. So every Friday we're like 4 p.m. Let's go to the movies. And I took time off. I read whatever Harry Potter book came out. I took an entire like 3 days and was like, I'm picking up this book when it gets released at midnight. I'm going to sit down. I'm going to read the book. And it mattered so much because your brain cannot retain information if you do not take care of it. Rest, eat, which I still suck at doing in a normal and non-ADHD way of like, oh shit, I haven't eaten. Oh shit, let's eat all the things. Rest, food, move. That's it. That's it. You got to take care of yourselves, law nerds. Sometimes that means like moving while you're in the office. It's fine. It's fine. But if you do not sleep, your brain will not process information. Question, was that mentor Alan Jackson? No, it wasn't. And I also would be surprised if Alan Jackson's advice tended to go to, you need to sleep first. But if you look at how brains work, your brain will not retain if you do not sleep. So even if you feel like I need to get this done, you're not going to get it done well. You're not. Sometimes you just have to stop and get some sleep. You can only do what you can do. All right, you ready? Let's talk about Kouri Richins. For all of you that say I never remember to eat, I know. ADHD. I get it. I forget it too. Here's the thing. For now, these protein bars have been very helpful. Look, it's something. They're pretty good. They're the not sponsored, but the one peanut butter cup, they work for me. Obviously not if you're allergic to peanuts or whatever else is in them, but yeah, those work. So we got to find ways. Let's talk about Kouri Richins, shall we? Oh, Rachel, all the time. Rachel said, has anyone ever forgotten to go to the bathroom with AD? Yeah, all the time. And then you stand up and you're like, holy shit. Oh, all the time. And it gave me a lot of parenting gentleness when my kids were little, because it would happen to them too when they get hyperfixated. Oh, all the time. You're like, I can just plow through. If I get up, like if I break the thought stream to go pee, I'm never getting back to this task. Like I have to finish this task. I have to finish this task. And if I stop to get up, it's all going to crumble. No, I get it. I get it. It is I must finish. Or it's gone. I've started using voice notes. To try to get back into the task, but it's really hard. Also, you guys see what my bladder's like because I stream for quite a long time. So we are well trained. We are well trained over here. Kouri Richins, y'all. Kouri Richins. We should just fly. I just want to fly. Emily, are we going to be singing else? Look, man, it's concert season. The song drops are going to be fast and furious. Let's go to Utah, shall we? All right. Kouri Richins. For those of you that may not recognize this case, and I call cases by the defendant name, I do not try to give them nicknames. It doesn't sit well with me. I don't like it. There are humans in all of these cases. There are victims' families. In this case, there are surviving children. So I am not a cutesy nickname case kind of a thing. This is Utah versus Kouri Richins. She is accused of poisoning her husband in a Moscow Mule. She is also accused of the attempted murder of her husband, Valentine's Day. He ended up dying on March 3rd. So there's an attempted murder and a murder. You may remember the case from her walk the dog letter or her Google searches, because your phone will tell on you, and she was Googling luxury prisons for rich people. She was also trying to smuggle crushed white strips into the jail with her former attorney. This is Judge M with the glorious beard, who we all adore, who seems to hate the cameras, even though he literally, if Hollywood cast this man as a judge, people would be like, no, it's not believable enough. Nobody's going to believe he's the judge. So this case has, and I think once it starts trial, will garner more interest, has garnered a lot of local interest. Because when Kouri Richins was arrested, she had just gone out and started doing press for a children's book that she wrote about grief, about the loss of her husband. And the more that comes out in this case, the more that the word loss seems to not be a loss at all. Because the more we learn through these motions, and we have gone through the preliminary hearing, the very substantial detention hearing, a second detention hearing, Kouri Richins thought that if her husband died while they were still married, she would get the money from his half of his business. What she didn't realize is that he had some concerns and had taken her out of his trust. So his sister became the executor of the trust to take care of himself and the kids. She didn't know that. She was girl bossing way too close to the sun and trying to be I don't know. I think by all the facts that I've seen in this case, I think she was taking tips on how to run a real estate business from Selling Sunset and was like, this is what we're going to do. We're going to buy these houses that I can't afford. We're going to flip them. It's all going to be great. It's all going to be fine. We now know that immediately after the passing of Erik Richins, a year before Kouri Richins was arrested, she got into a fight with her sister-in-law who was in charge of the estate because Kouri Richins was trying to get into a locked safe. And the sister-in-law was like, that's not yours. You can't get into it. She throat punched her sister-in-law the day after her husband died. It took law enforcement quite a while to get into her digital devices, but once they got into her digital devices, that's when everything unraveled. That's when you have the Facebook messages of her trying to procure fentanyl, text messages of her trying to procure stronger fentanyl. Then you get the interview with the person who sold it to her is like, I'm not going down for her. I'll tell you what you need to know. And on and on and on. So this case has quite a lot of information. There are some discovery issues outstanding, like, will the walk the dog letter be admissible? Will the girl boss journal the orange journal be admissible. The journal seems to have her musings about things not working out on February 14th based on representations by the prosecutor. The prosecutor, by the way, Mr. Bloodworth, is just his own vibe. Also directly stated in court, any law nerd on the internet would know. I might need to put that on the soundboard. Docket 214, everybody. Any law nerd on the internet knows this is the walk the dog letter. Hi, Mr. Bloodworth. We appreciate you in this case. Appreciate this judge. The defense attorneys are doing their job. They, so far, I've not seen anyone stamp their foot in court and say, humanity. So we're doing better than maybe the hearing yesterday for Koberger. So, and everything that has come out, Carrie Holland said, let's not forget the paramour. Oh, I didn't even get into Kouri Richins' affair that she was having with her paramour. And on Valentine's Day, brought her husband, according to court documents, the allegations are that she brought her husband a laced breakfast sandwich. And when he was texting her that he felt really sick, she's like, you should just lay down. Emily, don't start singing Goodbye Earl. It's not the time. She's like, you should just lay down. You'll be fine. While she was at her boyfriend's house on Valentine's Day. And then texted the boyfriend that the issue of the husband would be resolved on like a Friday. Right. Guess which day Erik Richins passed on? The text to the boyfriend saying the issue of the husband is going to be resolved, and I am paraphrasing, is not a good look when he then dies on that day. I don't think the jury is going to look favorably upon those texts. I think they just explain what she was thinking. So I find from everything we've seen in court, the evidence in this case is very strong. The defense is doing their best to keep out some of the evidence. They're not going to get very far on that. And the defense is trying to change venue, which is why we're in court today. The court had originally said that he would expand the jury pool. And then the site judge was like, immediately no, Your Honor. Immediately no. You can't bring jurors in from Salt Lake County, and immediately no. So the judge had tried to expand the jury veneer. He also says veneer, but had tried to expand the pool of jurors. It was shut down by the courts above him. And there was an appeal on that. There is still some appellate stuff pending regarding that. And now we have the motion to change venue years after this case was brought to court. This was supposed to go to trial at the end of the month. We are on the precipice of trial. And now the motion for change of venue. And that's where we're going right now. This was from Monday. For those of you that have seen this hearing, no spoilers. We know that the trial gets delayed, but I'm not going to cover the rest of what happens. And look, man, this case is, I enjoy the parties in this case. I like watching the lawyers interact with each other. I like this judge. I like the way he runs his courtroom. The facts of this case are wild. Every time more comes out, I'm like, what? Red Sky said, will the judge rule on this motion today? Now you're asking for spoilers. This judge often rules from the bench. And I appreciate that. I appreciate that from Judge M. All right. It's time. Oh, I turned these down.
Bring the jury.
I'm kidding. There's no jury yet, but it feels like the way to start things, right? It feels like the way to go. Should we start court, y'all?
Do it.
We should just go to court. This is about a 3-hour hearing. There will be parts I will zoom over. You'll see why when we get there. But huge thank you to Miguelina and Team Baker for cleaning up the audio on this. Emily, put the audio in the right place. It still has its moments of deep fried, just so you know. All right. So the audio is bad. The audio in court is bad. We did the best we could. The camera work, also not good. Nothing we can do about it. Like it's not good. Just buckle up. It's not great. We did our best.
This is Kouri Richins.
It's so much better than it was.
The state make their appearance, please.
Good morning, Your Honor. Brad Bloodworth and Lindsay Sherbonack for the state.
And on behalf of Ms.
Brad.
Richins.
Wendy Mills, Catherine Nestor, and Alexander Ramos for Ms. Richins, who is present.
Very good. Good morning, Ms. Richins. We're here this morning on a motion for change of venue filed by the defendant. I've spent a lot of time
This is a very prepared
reading
judge as well.
published cases regarding motions to change venue. Spent a lot of time looking at the defendant's and the state's survey results. I have several questions.
He has a lot of questions, and I appreciate that about him. The state and the defense both did surveys. They both did surveys to figure out if a change of venue was needed. Yes, chat.
Survey says.
They both did surveys.
Ms. Lewis, are you arguing the motion?
Oh, there's captions.
Yes, Your Honor, but I have Dr. Edelman here, and I'd really like to start with his testimony, and
Sorry, Your Honor.
then, yes, I will be.
Let me ask you a
Oh,
question.
I'm just trying to get to a good pause phase. Your Honor, we have Dr. Edelman here. We saw an entire day of Dr. Edelman's surveys in the Koberger case. Same expert with regard to change of venue. So yes, for all of you that are like, Edelman, is that the person from Koberger? Yes, it is. And so the defense is like, we would love to bring in Edelman. And the judge is like, I have read everything in this case, and I have questions.
About that. If I assume that Dr. Edelman's survey results are sufficiently reliable to be admissible, I have a couple of clarifying questions about what questions he asked and what the range of responses.
It's like, I've read what you said.
Does he need to testify to anything else?
I said, I read what you
Yes, Your Honor,
said.
he does. I think he needs to testify about the methodology used by the state and why that survey is not reliable.
This is why I'm confused. Doesn't that survey weigh in the favor of your position?
Yes and no. I mean, the bottom line of the survey in terms of the number of people who are aware of the case
Sure.
is similar. But the state survey does not deal with the ultimate question regarding guilt or the perception of guilt in the community, which is really the point of a change of venue survey. And which Dr. Edelman can explain so much better than I can. But in terms
Defense counsel is saying, the judge said, I've read everything he has to say. Why do I need him to testify? And the defense is saying, you need Dr. Edelman to testify to explain to you why the state survey is less than ideal. And he goes, but doesn't the state survey lean in your favor anyway? Like, aren't they just both good for you?
of looking at the ultimate question of guilt and in terms of looking at what specific facts that are in the media that potential jurors are aware of, the state survey does not identify any of that.
Okay.
And the way the state survey is conducted is not within the methodology that is typically used for change of venue surveys. It's a different kind of survey. And Dr. Edelman, I think, though, can fully explain the results of the survey in detail that we have presented. He can answer your questions. He's got a PowerPoint presentation that goes through how this works and how.
Oh, yes, he does have a PowerPoint, chat.
All right, that's fine. All right. I may move that examination along to the issues that I think are most relevant, but that's fine.
Okay. Are we ready?
Mr. Bloodworth?
Your Honor, before that, the state has a motion that may impact this testimony.
Sure.
May I?
This is now the prosecutor speaking. This is Mr. Bloodworth. The readers have come off. The tea is hot. By the way, I love this mug. It looks like it's got a little handy hold, like a mitten there in the like. He always has this mug. I love the little, like, it looks like the fingers. You can just put the fingers around and just, it's so good. I love it. He uses it every single time. I need to know everything about it. But yes, for all of you saying it looks very Patagonia, I imagine that this judge is in a Patagonia vest, like hiking on the weekends with his kids who are adorable. Like that is my imagining. Don't go looking for this judge's kids online. He will hate the internet even more. That is just, that is just my imagining. But I love this mug so much. I just love it. Oh my God. Some of you in the chat are like, Sweet and Sounds, like, I have one of those mugs. They're the best. They look the best. Some of you are saying they're for lefties. I love that too. I stand this mug.
Your Honor, on December the 17th, 2024, the parties sought extraordinary relief from the Supreme Court, in part in connection with their compromise regarding jury selection. During the pendency of that interlocutory appeal, the defense informed the court that if the Supreme Court rejected the parties' compromise position, then the defense would file a change of venue motion.
I'm sorry, Bryan, I can't hear you very well. Can you? I apologize.
The defense is like, Brad, I can't hear you. Speak
The
up.
Supreme
Buddy.
Court issued its order that rejected the compromise on February the 18th, 2025. Rule 29 gives the defense 14 days from that date to file a change of venue motion. The defense did not file its change of venue motion within the rule's time period, but ultimately the court ordered that the defense file its change of venue motion on March the 17th. Presumably,
Hold on. Who ordered them to do that?
Your Honor, you did.
You, sir.
I remember saying something along the lines of, you keep mentioning a change of venue, but you keep not filing it. So I set a deadline by which we had to get this thing briefed.
Correct, and that deadline was for the opening brief from defense was March 17th.
Okay. Understood. Keep going.
He's saying it's not timely.
Presumably because of the time crunch that the defense's delay caused, the court order that the defense would not get a reply brief. Yesterday evening, a Sunday, the defense filed a 16-page expert affidavit styled as a supplement
Oh,
to
fucking
its
hell.
change of venue motion that is found at docket 978.
You all have opened up
Sorry,
a new session.
970. In reality, that affidavit is a poorly disguised reply brief. The state has not had sufficient opportunity to meaningfully review it, much less cooperatively consult with the defense's expert or discuss the affidavit with the state's expert. Accordingly, the state moves to strike that affidavit from the record.
So the
You're
state is saying, first of all, untimely. Second of all, it seems that we're allowing this to go forward, but they weren't going to get a reply. And then they tried to end run a reply brief through an expert affidavit. And I'm asking you to strike the affidavit, not consider it. They filed it last night. Also untimely. So someone in the chat was like, this is important and you're focusing on a mug. You have not met ADHD. My brain can focus on so many things at once, which is how I process court, give you legal explanation, focus on what the judge is doing, what the witnesses are doing, and read the chat. It's called multitasking.
The state's motion is denied. You can it's denied without prejudice. You can reassert it if you determine it's necessary, depending on whether I ever rely on that affidavit at all during this hearing.
Right. The court's like, I'm not striking
I
it.
have some
but it'll
concern
be
that you're
fine.
all missing the point. Why couldn't the court just accept both surveys and say they show a range and engage with the numbers in each survey?
Your Honor, the state prefers that the court proceed that way. I've seen the draft of the 100 slides that Dr. Edelman's fixing to testify to.
The court's like, you're missing the point. Why can't I just accept both and make a ruling from there? And the state's like, please fucking do, because I've seen the 100 slides that we're about to endeavor upon. And could we not?
I would prefer the court just ruled on the papers.
I mean, I do have some questions for Dr. Edelman about whether I'm understanding the other side of the numbers in his surveys correctly. So I'd like to hear from him to make sure I get some clarification on that. And if it turns out that I'm misunderstanding what the other 20.2% of the people that answered the survey said or didn't say, we may need to get deeper into it. But
Your Honor, you can't. The day that we've got this judge saying we might need to get deeper into it, we've got the deep fried microphones. Come on.
I was just saying, I think it's important that we make a complete and clear record on this issue. As you know, this issue is highly important to the defense.
understood.
And we want a complete record on this particular issue.
The hard drive that you submitted, does it make less than a complete record?
The hard drive.
Didn't they submit? Yeah. Isn't that thumb drive showing Dr. Edelman's complete survey and results and methodology in
I
writing?
think without the explanation, no, it does not, because someone who doesn't understand how these surveys work, it doesn't mean a lot. There's a lot of explanation behind how the survey was conducted, what those numbers mean, and how those have been applied to the reasonable likelihood standard in other cases, and how it should be applied in this case.
Wait a minute. He didn't disclose any of those opinions. Or why would I accept his opinions about whether there's a reasonable likelihood here? That's my determination.
No, he's not giving his opinion on that. He's explaining the standard and how it's been applied in other
Not a
cases.
chance.
He's not giving an opinion as to how it should
Other
be applied.
Utah cases?
Not gonna happen. Look at him. He's like,
No,
nope,
no,
nope,
but
nope,
the
nope.
law is the same.
Nope.
I mean, the reasonable likelihood standard is the same, whether it's in Utah or not. That's the standard for a motion to change venue.
With respect, I'm not sure that's true. In federal court, the standard is much more. The reason I think candidly that federal courts are upheld frequently with respect to denying motions to change venue is that the federal standard is very different. Here, I think it's in state court, looking at state cases, it's a lower standard, less than preponderance, the 4 James factors. I really care less about how we performed the survey versus what the results are.
Right.
I'm persuaded that the methodology is sufficiently reliable to be admissible under Utah's threshold for reliability. I do have some questions, though, about what the results mean. Can we start with that?
Yes,
Okay.
we can start with that.
Dr. Edelman.
What I appreciate about the judge is he's like, I have read all of your shit. I have a few questions, but why can't I just say, I accept your survey, I accept the state's survey, and then have you argue what we do next? He doesn't want a whole hearing about methodology surveys, but the defense wants to make a record that their methodology is proper and the state's not. So that's why we're now in the judge saying, can we focus on the shit I've got questions about? Because the standard here is pretty low and I've got some questions. Can we just answer my questions? Because ultimately I have to make the decision. The judge does not need a full day of hearings to explain what he already read. And I really appreciate that he wants to just cut to the chase.
May we swear you in, sir?
So they are putting Edelman on the stand. Yes, this is the same expert from the
Do you
Koberger
solemnly
hearing.
swear the testimony
That doesn't
you're about to
surprise
give in the
me.
matter before the court to be the truth, the whole truth, and nothing
When
but the truth, subject
People
to
do the
pains
thing
and
that you'll see them
penalties
do the
of
thing in numerous cases.
Thank you.
I'm a duck. She is the one who is accused of that. Yes.
Ms. Lewis, may I just start with some questions that are written in bold type on my
Ma'am, I have questions.
notes, and then you can fill in and make whatever record you think is appropriate.
Of course.
Doctor, good morning.
Morning.
Okay. I understand
So we just get the judge's questioning. I'm living.
that let's stay focused on Summit County for the moment. How many people responded to the telephone survey?
What do you mean by respond? Completed it?
Yes.
400.
Okay. So when we look at results saying they or someone they know has a connection to the Richins family, 26%, that's 26% of 400 responses.
No, it's 26% of those who have read, seen, or heard about the case.
Okay.
So even
yeah,
less.
So if somebody doesn't know about the case, and that's a fair point, they might know the family. That's true. But the skip pattern didn't do that. So,
Okay.
Yeah.
So maybe the better starting point is recognize the case. Is that correct?
Yeah.
Is that the first level?
Read, seen, or heard about the case. Yes.
And use that phrase for me again.
Read, seen, or heard
seen,
about the case.
or heard. So 400 people answered the survey. From that, they only go further with people who have read, seen, or heard
And
about the
so
case. So what's that number?
79.8% of respondents indicated that they had read, seen, or heard about the case, and that was based upon the
79%
summary provided
of 400.
in the survey. Correct.
Correct. So there's those two recognition questions, which were built off of the media coverage. So read all the newspaper coverage, watched all the coverage, and then identified the things that were most salient and most likely to trigger a memory without being overly biased.
And I recall, and I didn't copy and paste it into my notes, that the brief summary of the case that was used to provide context for whether someone had read, seen, or heard about the case was Erik Richins died on this date. Kouri Richins wrote a children's book and is alleged to have murdered her husband. Is that fairly stated?
Yeah. So there's no reference to poisoning or
Right.
any of that kind of stuff.
And
Okay.
a lot of people might not recognize this
So
case
if
without
79.8% indicated
fentanyl.
that they read, seen, or heard about the case, does that mean that 20.2% of the 400 that
He
completed the
mathed.
survey indicated they had not read, seen, or heard about the case?
he
Correct.
mathed in real
Okay.
time.
Okay, then we go another layer deeper, and there's a question about whether
I don't know if we just have the one lens today on the camera and that we cannot zoom out. I don't know if the wrong lens. I don't know if that's even how cameras by the pool camera work. But Edelman's on the stand. There's a plant, and we can no longer see the judge. Just get
of that 79.8% that had read, seen, or heard about the case, am I correct that your survey results show that of that group, 69.1% had formed a belief that the defendant is guilty?
Correct.
Okay.
That's, you notice it says prejudgment 1 and prejudgment 2. So prejudgment 1 is exactly what you just said. And then prejudgment 2 would be for the sample as a whole, for the population.
Explain prejudgment 2 for me.
So 70% believe she's guilty of those who recognize the case. But what does that mean if 100 jurors walk into the room?
Right.
Right. So, and that's that prejudgment 2. So I don't have it in front of me, but whatever that number is would be the prejudgment rate in the community as a whole. So that includes people who know about the case and don't know about the case.
And tell me why you can draw any conclusion about the prejudgment rate among those that know nothing about the case.
how do you
What do you mean by any
extrapolate it?
conclusion?
Well, if they don't know anything about the case, why would they have a prejudgment walking
Well,
in?
How do you
Yeah, and they don't.
extrapolate?
So it's only related to that know about the case. I don't think people who don't know about the case I would presume they don't think she's guilty because they don't know anything about
Okay, I appreciate that. So if we stay within the
Yes, when we get to this trial, I will be strongly advocating for only plant. I'm here for only plant. I'm here.
subgroup, the approximately 8% that have read, seen, or heard about the case, and we acknowledge that approximately 69 or 70% had formed an opinion that she is guilty, does it follow that 30% or 30.9, is it presume her innocent or have no opinion combined? Is that how it is?
Yes, but the presumed innocent is very low. It's like 1 or 2%.
Okay.
Yeah.
So practically speaking, it's have no opinion.
Yes.
Okay.
We would know if the court was making notes if
Okay.
we just had a view of the whole courtroom, but alas.
And then if we go another layer, not deeper, but just another layer of
Your
the
Honor.
79.8%, there is 50% who indicated that the defendant would have a difficult time convincing me that she is not guilty. Is that 50% of the 79.8 or 50%? I think it's 50% of the 69, correct?
Yes. Yes.
Okay.
And those rates change based on, like, if you know particularly prejudicial details, they go higher. So
Understood. Okay.
if you close
And
it,
would you, let me ask you this way, is 400, a sample of 400 sufficient to show statistical significance?
it's the generally accepted sample size for these, so it's plus or minus 5% margin of error.
So that's 2 standard deviations from the mean. All right. And that would say that it would,
Your Honor, did you just say 2 standard deviations from the mean? What? Was it a toss-up between med school and law school? Your Honor, I've got questions. What, you math suspiciously well for an attorney, Your Honor. I have questions. Did you work in plaintiff's work? How are you mathing so much? But yes, the judge is like, I've got this. I've got this. I'm going to ask. A fan of statistics, are we? We're going to ask all the questions. And I love the grasp of this information the judge has. He's like, I've got you.
would tend to
I'm here
scale
for it.
to the population as a whole of the county.
Yes, and a lot of that question kind of goes down to methodology too, right? All the things you do, like it's a random digit dial telephone survey. We do callbacks. We do like soft refusal conversions. So people who kind of are on the fence about taking the survey, the interviewers are trained to encourage them to take it. We call at night. We call in the morning. We call on weekdays, weekends. There's an introduction to encourage them to take the survey. They're told there's no right or wrong answers. They can always say no opinion, don't know. They can call back if they have questions. So all of these things to try to improve response rates. So you're not systematically missing an important group of people.
Let me spring some questions on you
Yeah.
that I don't know that you handled in your reporter affidavit. Assume for me that 1,100 people who are qualified as Summit County jurors.
Yesterday was long and my brain has no chill, but I'm going to need to let you guys know that Judge M got his bachelor's degree in sociology and biology, and he still sits on the board of directors for the Utah Avalanche Center. So, we're going to continue on among lots of other things that he does, but those were the 2 that I was going to highlight.
Have filled out a 20 some odd page case specific questionnaire. I have no idea what it says. I just know there's 1,100 of them.
Yeah.
Right? It explains the things.
Is it a reasonable application of your survey data to expect that 20% of those 1,100 have not read, seen, or heard about the case?
Well, the survey was finished, I'm trying to remember the date now, in early March.
Okay.
So those numbers could change based on, I know, for example, I ran across a 45-minute interview on court TV with the family's attorney representative,
Spokesman.
saying many prejudicial things. So those
Sure.
numbers could be higher.
Understood.
And it depends on how the questions are phrased in the questionnaire. Right? They're not, it just depends. I haven't seen the questionnaire, so I
Right.
don't know what it looks like.
I will say I'm on YouTube more than I would care to admit, both for work and as a viewer of YouTube. It is where I consume the majority of the things I consume that are not music. No, even then, music. I am on YouTube a lot. I had no idea that the victim's family had done an interview on court TV. And my algorithm on YouTube serves me 90% court stuff. It is mostly court stuff. I have multiple YouTube accounts to have different algorithms that serve different stuff, mostly court stuff. And I had no idea that there was an interview. For those of you asking, yes, Kouri is the defendant in black sitting between her two attorneys. Again, I don't know if there's a fixed lens. I don't know why we are not just zooming out on the whole courtroom. I don't know. But it seems to be that there is a court order to not show court staff. So when panning between the judge and the counsel tables, court staff is between the two. And it seems to be why we get that loop down. So a lot of you are saying I watch a lot of court TV and had no idea about the interview. Right. And so it's interesting to highlight that this expert is saying, look, and then there's this 45-minute interview and a lot was said. And this is an audience that spends a lot of time online looking at these cases and have never heard about it. So, you know, it's just everybody's adding it to their watch later list, but it's interesting the assumptions that are made and then what we are actually exposed to, even when we are looking for information on this case, that there's stuff we don't see.
I forget about what the questionnaire says, but when they sat down to take it,
Yes.
is it reasonable? When they sat down to complete it, is it reasonable to expect that 20% of those people at that moment had not read, seen, or heard about the case?
Yes, I would say.
Okay. Is it reasonable to expect that of those 1,100 people that had, of the 80% of those 1,100 that had read, seen, or heard about the case, 30% of them had not formed an opinion before they took the questionnaire as to the defendant's guilt?
Of those who've read, seen, or heard about it? Yeah, that's
Okay.
what I would say. So,
Okay.
yes, that kind of comes back to my, if 100 jurors walked in the room,
Right.
how many of them would have already prejudged the defendant is guilty?
Okay.
Not just Judge
All right,
M
I
is
think I
asking the
understand.
questions because he wanted to cut to the chase. And he has a list prepared of things he wanted
May I
answers
just
to. And he
add,
said,
sure, one thing. So,
may I?
from my perspective,
Yes, this hearing's for
I
him.
always caution because when we go down
I'll pause the deep fried microphones. The judge is the fact finder here. This motion is to present information to him that he needs to make the ruling on whether or not a change of venue is appropriate in this case or would be helpful in this case. And so instead of the defense attorney starting at the beginning and saying, so, sir, tell me your background. How many cases have you done? The judge is like, nah, I've read this. So we're at a 2% standard deviation. Now what? So the judge wants to just jump into the things he needs, and the record is already written. So the defense doesn't need to make much more of a argumentative record because it's all written. And so the judge wants the answers he wants.
this route, it turns into a
So
numbers.
hopefully that helps.
Now, and I don't think, from my experience, I've done a lot of these. I don't think the question is, can you find 12 people that who will say they can be fair and impartial? You can always find 12 people that can do that. And the biggest example would be if it was a numbers game. Let's say LA County, 10 million people. Remember the Rodney King?
Why
That was
the
the
plant?
Powell
Why the plant? Why the
So
plant?
everybody in LA County knew about the case, but let's say 90% believed the officers were guilty. Well, that still leaves 100,000 people somewhere. And if it was a numbers game, you would never have a change of venue because there's always some group of people in there that can, that don't know about the case. And that's not really the question about whether you can get a fair trial. And the other question is, what are those people who are left? So in a case like this, burden of proof might be very important. And you want really smart jurors that really understand beyond a reasonable doubt and are very inductive, analytical jurors. Those are the best jurors in this case. But they're also the jurors most likely to know about this case because they're most likely to follow what's going on in their community. So your best jurors are the ones that are most likely to be excluded because they've heard about it, have developed opinions. And the question is, well, who's left? And that is not necessarily ideally a fair trial in my mind. So I don't get into the numbers game where it's always, can you find 12 people? I mean, I've done enough jury selections. I'm sure you've done many, and you know what it's like when you're trying to, someone says they have an opinion. It's very easy to get them to say they can be fair and impartial. We do it all the time. It's an adversarial system. So I don't think at this point, that's not the question. The question is there a reasonable likelihood that she can't get a fair trial? So I focus on, is there a whole lot of bias out there? Do people know a whole bunch of detail? Do they know prejudicial detail? And the other problem is voir dire is, and the way memory works, it's very hard for people to recall everything they know. So if I say, tell me everything you know about this case or a movie, let's say Star Wars, I bet you all can tell me a bunch of good stuff. But you'll miss a whole bunch of important things. And if I ask recognition follow-up questions, you say, oh yeah, of course I knew Darth Vader was Luke Skywalker's father, right? In voir dire, you can't do that. You can't say, oh, well, have you read, seen, or heard if, she confessed? No, she didn't. I'm not saying that happened, but they don't mention a confession. That's happens in a lot of cases. You'd be poisoning that juror. Maybe they know it, maybe they don't. For example, in this case, only 10% of the people mentioned the walk the dog letter when asked, where have you read, seen, or heard about this case? But later, over 40%.
Docket 214.
So there's this group of people out there that know it. It's prejudicial. Maybe it comes into evidence. Maybe it doesn't. Let's say it doesn't. How do you identify who those people are?
Those people that were asked about the walk the dog letter, was it only the group that had read, seen, or heard about the case that were asked that, or was it everybody?
We don't ask if they don't know about the case. We don't then feed them information.
I understand.
So
We don't
that's the biggest
poison
thing.
the well, essentially.
It's not just like conjecture. I mean, so this whole thing for me came about. There was a case in Texas, John Fight, and he was a Catholic priest charged with murder. He killed a beauty queen in like the 1950s, and this case had gone to trial for 30 plus years. And then they charged.
Did you just say this case was a Catholic priest killed a beauty queen? Sir, I'm going to need more information.
Charged him with murder, brought him back, and all this. And in Texas, you actually have to bring people in the community, and they testify in the change of venue hearing about what they know and all these things. And we kind of treated it like a mock voir dire to prove that point. So they told us everything they knew, and we'd ask, "Well, is that everything you know?" And they said,
He's
"Yeah."
answering way more than the judge
have you
asked
read, seen, or
for.
heard of John Fight confessed to a priest in a monastery? Oh yeah, I knew that. Well, you didn't just mention. Sorry, too much coffee. I'm sorry. I'll slow down.
The court reporter's like, sir, you're on a roll. However, I don't blame Edelman for this because he's sitting there looking at Judge M, and Judge M, who's already asking about standard deviations, is interested in the same shit that Edelman is interested in. Edelman's whole point is, and this is what we saw in the Koberger case, when there is this much information in the media, you can get jurors that come in and say, yeah, I'll be fair. And his argument is that's not how brains work. So even though people might want to be fair, they might not actually be able to because they have information in their minds that they can't undo. So that is really his point of arguing that you need more information from jurors than you necessarily get in voir dire. And the court reporter's like, I understand that you are on a roll here, but literally slow down. And I also get that the expert is now in a full narrative with the court. And I get it, but we've heard he uses the same examples as experts do. So we heard a lot of this in the Koberger case.
And it triggered a memory. And then we'd say, do you know anything else? Say,
Thanks,
no.
Kat.
And then we'd say, well, did you hear that John Fight allegedly attacked another woman at a different church? Oh yeah, I knew that too. It was in Edinburgh. Okay, is that everything you know? Yeah, that's it. And then it's, well, have you read, seen, or heard if there was a cover-up? Oh yeah, the Catholic Church moved him around and blah, blah, blah. So that is the problem in these cases. In normal voir dire, none of that's an issue because people don't have case-specific attitudes towards the case. They just have general attitudes.
I appreciate your pushback to the idea that it's a numbers game, but I don't have an infinite number of options here.
The law says it's
The
a numbers
defendant
game.
has asked me to move the case in one way or another to Salt Lake County jurors.
Edelman
Those
wants the
folks
voir
are
dire
not
process to
blind
change.
to the media coverage of this case. If I understand your survey results, about 42.5% of them have read, seen, or heard about the case.
Yes.
And 57% of those folks have formed an opinion regarding that she's guilty.
Right.
Why don't all of the dynamics that you've just described
He's
apply with equal force in Salt Lake County?
He's like, same.
Well, good question. And I think, one, it's far fewer, but also more importantly, they are not as familiar with case-specific details. So the people in Salt Lake
But didn't you, and this is a genuine question, I'm not trying to
Yeah.
cross-examine you, didn't you just tell me that people are not good about recalling what they know?
Well, let me clarify. When I ask, have you read, seen, or heard if, those are
Yeah.
recognition questions. And that's where we identify
I like this
the
judge a
extent of
lot.
our case knowledge, compare it to
He's
the
like,
open. And
wait a sec.
they know much fewer case-specific details when we ask the closed-ended
Thanks,
question.
Chad. I'll take a look.
Which memory is much better. They also reported that they didn't follow the cases closely. so they're not as engaged. They don't have as many connections. So there's a lot of those factors that come in. And it's also a much larger community. So as you'd expect, there's so much more going on in Salt Lake that this case hasn't captured their attention. I also look at the fact
they're busy watching Real Housewives of Salt Lake City. I'm teasing Salt Lake. The rest of us are busy watching Real Housewives of Salt Lake City. Apparently in Salt Lake, they're busy lining up to go to Swig, because I also watched Secret Lives of Mormon Wives. But what the judge is trying to say is, but isn't it the same exposure in Salt Lake City that it is here? They aren't that far apart. And if the issue is people don't remember what they know, then can we ever have a survey? But I think, chat, you guys are a great example of this, because a lot of you, when I say Utah versus Kouri Richins, you're like, what case is that? And then we get into a children's book, and some of you are like, what case is that? And then we get into Moscow Mule, fentanyl, egg sandwich, and luxury prisons for rich people, and walk the dog letter. And you're like, that case. And that's kind of what he's getting at, is that if you just say, have you ever heard of the case with Kouri Richins and Erik Richins? A lot of people might say, I'm not sure what you're talking about. And then you get further into the details. It's like, oh, that one, that I remember. And then you might go, isn't it alleged that blah, 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 because now you remember that this is that. And so he makes a good point about memory, that people might have heard the headlines, especially with the way that the media names cases, that they might not know the defendant or the victim's name, but they know these little snippets about the case.
It's not very far away. It's not a huge inconvenience compared to some other cases. Like in Moscow, Idaho, the change of venue moved it to Boise. That's a big, that's really far.
It's a 300-mile difference.
And there, I'll give you an example. The recognition rate in Idaho, in Latah County, was 98%. It was about 97% or something like that in Ada County. Virtually no difference there. The differences that mattered were the connections, the personal connections. Did they go to the university? Had they been to the victim's house? Had they seen it? It's those things. And you see a lot of those unique factors here.
I disagree.
That's kind of the stuff that stood out to me.
I disagree in
as
Idaho.
Justification. And just looking at
one of the big things in Idaho was just the substantial difference in the size of population. So if this percentage of the population has heard of the case and you have a much larger population, it's going to be easier to do voir dire, because you're going to need a lot of jurors anyway. You're going to pull a bigger veneer to bring in jurors, and there are more people to choose from. That was one of the big things. Yes, whether or not people who drove past the crime scene was part of it, but I think the substantial and significant difference in population was one of the big things.
Again, at the severity of the crime and the fact that she's looking at, if convicted, many years in prison, it seems like a fairly reasonable, low inconvenience to move it to the largest county, since it's so close.
Imperial Girl, the
recognition's
state
lower,
did a survey too.
Prejudgment's lower, case-specific knowledge is lower.
Edelman uses a lot of leading
Recognition
questions.
of prejudicial details that really stood out are lower. So there's all that benefit.
Okay. Let me pause there.
Can we
Yeah,
not
that's-
look at
that's a
counsel's
lot.
computer?
Why don't you lay whatever other foundation? I appreciate you letting me get answers to my questions.
Oh, thank you.
There were a lot of
Excellent
issues with Moscow that might not apply here.
Can I just have a moment to
The defense is like, you've completely fucked up my
Sure.
questioning because you did all of it. So can
Sure.
I just take a minute to reset where I'm at? I'm gonna.
Yeah, I think we just went over a lot of this.
They're now trying to reset his 100-slide PowerPoint. I might put them on 1.25. We'll see.
a lot of it based on the questions you just asked.
Okay.
And just answered.
Sure.
And address what we have not done.
Y'all, I don't fucking know. Don't ask me about the
Brittany,
camera.
would you turn that television?
Do you want me to go through his background? I was planning on just,
No,
you're okay?
I know how to read.
All right. Well, then,
The judge. I know how to read.
Brittany, would you turn that television?
do you want me to go through his background? I was planning on just,
No,
you're okay?
I know how to read.
All right. Well, then why don't we just go ahead and start with that?
1 second. Let me get. Alex, is there a PowerPoint that you want published?
Do not sit here and go through background training and
Okay,
experience with
1
me, counsel.
second.
I read the hundreds of pages you submitted.
Do a little.
It takes a lot of time to do. I did it. Do not sit here and repeat it at me. There was no jury here. We are making a record. Your written motions are part of the record.
While he's pulling that up, Dr. Edelman, maybe we could just start with when you were initially hired to do a survey on a change of venue, you said that you follow a 3-part process, correct?
Yes.
And maybe let's start with explaining how that 3-part process, what it is.
All right.
Yeah.
We're gonna speed you
it's
up.
a 3-phase process.
We've heard this in the Koberger case. I'm gonna speed this part up a bit instead of skipping over it. But for those of you that are like, there were issues I had with this expert in Koberger, I find that a lot of the way that they ask questions in the survey are very suggestive. The state did their own survey in this case, so there are dueling surveys, and the court was like, can we just admit both surveys and I decide?
Process that was taught to me by Dr. Ed Bronson, who is one of the kind of forefathers of all this. He did like the Oklahoma City bombing case and Boston Marathon and Skilling and many of the big ones. And basically the first phase is to collect the media coverage and make an assessment if it contains any prejudicial, sensational content, the extent of the coverage, anything unique. If not, that's the end of it. So we don't do anymore. And that's capped. So that's capped at like 6 hours. If it looks like there's extensive coverage or prejudicial coverage or something that might be concerning, like maybe there's one specific item that stands out, like there was a trial, somebody was convicted, and then the conviction was thrown out years later. Well, that's pretty prejudicial to know that a jury already convicted them. That might justify going to phase 2, which would be a community attitude survey to assess the impact of the media coverage on prospective jurors. Because just because there's prejudicial coverage doesn't mean it automatically has an effect on people. I've had cases where we've done the survey where there's a lot of coverage and there's low recognition rate or not a high guilt rate. Once the survey is completed, there's a range of things that the data may support. Could be not a moderate issue where recognition is like 40, 50%, guilt's not very high. It's a big community. So maybe it's just like extended voir dire, a better questionnaire or individual sequestered voir dire, a lighter cause challenge standard.
Sophie in the chat said, quote, I know how to read. He low-key hates these lawyers. I don't think this is the judge snarking at the lawyers. I don't think he dislikes the lawyers. This judge does not love having media in his courtroom. So I think the court's limitation of things to the documents and what's in court is because the judge very much does not need a show for not him. He's the one making the finding. And I think this judge is incredibly mindful of not allowing stuff that is just for the at-home audience and cutting through that. So I really think he likes the lawyers in this case. His demeanor with them is great. He does not like the media. And he has made that clear quite a lot. He does not like the media at all.
Things like that.
So I think
all
it's
the way
about
down
that.
to like in federal, there's a lot of intra-district transfers we do within the district to state cases, change of venue. So it just depends. And then the last phase would be what
My
we're
hair
doing
is
now.
driving me nuts.
If both sides don't agree, we would get here. And sometimes they do. I just did one in Tennessee, the Tyree Nichols case, and both parties agreed to move it. So we didn't have a change of venue hearing. The judge moved it based on the survey data. So those are the 3 phases. So it's not just like, let's go spend a bunch of money on a survey. It's let's do it piece by piece. So you're not burning through county money. It's the deal.
I appreciate that.
All right.
I can't tell
Why
you
don't you just
about
go ahead and
the
judge
camera.
if you
Y'all,
want
I
us to
don't
move
know.
on something, that just why don't you let us know?
I know.
I think
Media loves the
really
judge.
more concerned about
Judge hates the media.
the results of the survey here and any nuances in it that you fear that I wouldn't appreciate by just reading the summary of the data.
Sure. I will say, just on this issue, we don't have to go through all this, but you can, if you want to skip to the media coverage itself and not so much. This is kind of the impact of pretrial publicity and how it works, the content process on juror decision making. But do you want me to offer this? Or?
I don't know if right now if this would be a good time to address how the pretrial publicity can be confused with evidence in the case. When we have a jury who has been exposed to a lot of pretrial publicity, how can that affect them when they're sitting as jurors in the case?
Yes, so there is research on that and how memory works. And there's one study, what they did was they read pretrial publicity and then 5 days later watched a murder trial. And then a couple of days later, they were asked whether the specific pieces of content were from the pretrial publicity or from the evidence they heard. And after just a few days, the source gets stripped, it's integrated into a general memory, and you can't remember if that was pretrial publicity, if it was trial evidence, or it was both. And that's just how memory works. Like
Dr. Edelman,
yes.
may I cut to the chase here a little bit? That would seem to counsel in favor of never impaneling a potential juror who had been exposed to pretrial publicity at all.
unless you're the party that likes the pretrial publicity and want it to stick in the jurors' minds. But I will say, this is an example of why you interview witnesses separately. Because if you try to interview witnesses together, they are not going to remember what they saw and heard and did and what the other person said, and they will start filling in the gaps of memory together because your brain is not trying to keep those separate. Your brain just needs the information. And so when we look at why it gets harped on so much in the Reed case about interviewing witnesses together, it's because there's really no way to parse it back out once the shit's out of the horse. And that's why it is such an important thing to interview people separately. And the same thing here. He's saying, look, there are these studies showing if you read something and then see a trial, at the end of the trial, you don't know if this was introduced in trial or if you read it. I understand memory, but the judge is like, so should we then never impanel a juror that's heard anything about the case? And we know that's not what happens. When you look at jury selection in the Karen Reed case, almost every juror that's coming in has heard of the case in some way. They're not impaneling jurors that have never heard of the case.
That I don't think is the law in any jurisdiction in the United States. How would you say, what's the through line there about the fact, especially in the modern media environment?
Well, I think the significance of that, again, like people's exposures on the spectrum. So if someone just said, well,
wait, there's a
you
wide
know
angle.
very little, I'd be less worried about it. If someone knew, for example, about a prior conviction, those are things that become significant. So if you can't remember if the prior conviction came into evidence or not, those are bigger things. So I don't think it's for everything, like you said. I think if you look at the types of pretrial publicity that are most impactful or what your biggest concerns are, this case had some things that were initially reported that maybe are not true, or maybe those theories have changed. So but you've already been exposed to it so much. One of the most common things is that you saw was that she was poisoned with a Moscow Mule. People spontaneously mention that. There's a big belief that's true. And if the theory has changed, well, that's very significant in this community in terms of people believing that. So you're starting from the point you already assume that's correct. And so if they hear something similar, for example, oh, it was a different drink or whatever, you're just triggering a memory. So you're not hearing evidence for the first.
The technology defense counsel, who is sitting at the end of counsel table, is also rocking his Remarkable, which I appreciate. I'm going to keep clocking them in court because I wish I had this thing when I was in court. God, I wish I had this when I was in court. It is so lovely. But also I feel for defense counsel, I hate that the camera shows their computers. I don't think it should.
First time. It's not like, oh, I'm looking at the probative value of this new evidence as a blank slate. I'm just recalling what I already know and integrating consistent information with what I've already read, seen, or heard.
Is see if I can summarize this correctly in my question.
Mr. Bloodworth is like, all right.
Is the percentage of respondents who identify familiarity with some of the more inflammatory facts of the case higher among the group who indicated that defendant would have a difficult time convincing me that she is not guilty? Or is there not that correlation?
There is. Okay, there is. So that's correlated with the number of details they know, which is consistent with the social science literature. That's an internal validity check. You see that relationship. It's consistent with how closely they followed the case, how many details they know, and specific details that are more prejudicial than others.
And on the flip side, if they indicated that...
Are we to count the defendant's eyelashes? Can we just, this is, we see this come up in the Koberger case when the defense complains about the focus on the defendant. If we just had a wide angle of court or a wide angle of counsel table and of the witness stand, we wouldn't have this issue. And we've seen a lot of evidence in this case. Kouri still should have some ability to sit in her case and pay attention and not worry that there is a camera literally trying to zoom into her pores.
Starting small, going larger in terms of group size. They have formed an opinion that defendant is guilty, but defendant would not have a difficult time convincing them that she's not guilty. Or they have read seen or heard about the case and have formed no opinion regarding
This is a
defendant's
pool
guilt.
camera.
Do
Don't
your
email.
survey results show that those groups of people, those subgroups,
This is a pool camera.
have less case-specific detail recollection, less exposure to pretrial publicity?
Yes. So it's when we say less, it doesn't mean it's not high. It
Sure.
depends. You have to look at it. And there's actually we have a chart on exactly
Okay.
what you're asking.
Can we go there?
That would be the only thing I'll say on the coverage. If you jump into the one slide, I just wanted to highlight was keep going. We can skip all these. This is just, it was with keep going. It was one more. No, just because there's one that was, this is what most concerned me. I just want to touch on this before we move on. So one of the things,
Before he goes any further, just in the chat, what we've got, well, their survey size was 400. We've got over 7,000 in here. I'm going to start a poll because I think our sample is a little skewed, because if you're here watching a live stream on YouTube, commenting on YouTube, you spend time on YouTube watching content about this case specifically, you are more likely to get information about this case because you've already engaged with information about this case. So my question is, have you seen the victim family interview on Court TV? This is the victim in this case's, yeah, I can't, regarding this case. Have you seen this interview? They're going to start talking about this interview. The fact that it wasn't served to me in the algorithm surprises me. So I'm going to put it up in a poll because I'm doing our own research. He's talking about this interview being inflammatory. I have never, I had no idea. So let's continue on. I'm going to let you guys do the poll. We're going to take our own numbers. I mean, I know we don't live in Utah, but a lot of us are paying attention to this case and spend time on YouTube watching content related to courts, law, and cases. So.
Is the imbalance of the coverage, where you have information that's supporting one side and not the other. So when you have Mr.
Kouri did an interview.
Skordas going on TV and espousing, not only repeating things, but speculating on motive and the psychology of the defendant. In this episode, this is a 45-minute long episode that appeared just a few days ago. And there's stuff in here about not only about the boyfriend, but about her. This woman is speculating on the defendant's mental state and so on without ever evaluating her. And then Mr. Skordas is supporting it and reinforcing it. So it's not like this stuff has stopped. It's still happening.
Edelman's mad. Like, he sounds actually mad. Also, I don't love it when people speculate on someone's mental health or any psychological conditions or anything like that. I don't think it is too far in this case to speculate on motive, because there's a lot of evidence in court about it so far. Finances seem to be a lot of that. To speculate on other things that are fact-based in the case. But yeah, I don't like some of that either. Like, I get it.
It's very prejudicial. It's only on one side. And that is one of my bigger concerns. Is all this pretrial publicity benefits one side. It's not balanced. And one side's not speaking to the media and the other has free reign to do stuff like this. So that's quite concerning. So I just want to highlight that before we move into the survey. I think it puts the defendant at an unfair advantage, and it helps the state quite a bit.
All right. We just acknowledge for the record that Mr. Skordas is a spokesperson for members of the Richins family, not for the state of Utah.
Yes.
Okay.
But it still helps them.
No, I
get the benefit of it.
I understand.
He's like, it still helps the state. It still helps the state. The family members have a right to talk about what's happened to them. And the family members have ongoing lawsuits with Kouri as well. There's a number of civil suits going on. Kouri also did jail call interviews to not only slam the victim's family, but say that the state is going after an innocent mother, and that his family is an issue. So she's also spoken to the media. The lawyers haven't. But at the beginning, Kouri's lawyer talked to the media quite a lot.
Yeah. Okay.
All right, go ahead, Alex. And Dr. Edelman, why don't you just stop us when you...
Okay.
Oh, come on. I kind of wanted to read the tea. Are we scooting by all of the screenshots of like social media commentary on the case? Damn it. That's actually, I find some of that actually interesting. I just wanted the tea. Uh-oh, I went too far. Emily, you have ruined it trying to find the tea, girl. This is not this is not what we should be doing. I know, but I just wanted to see the screenshots real quick. Let's see if we can find any of them. I don't know if I'll be able to. Oh, there's the walk the dog letter. Okay. The title of the slide is Unsubstantiated Claims. The walk the dog letter is verified to be from her. No, I'm not going to be able to screenshot those. I was curious. Sorry, chat, for dragging you along on my own curiosity. I'll have to see if the exhibits are filed on the docket, and I'll grab them.
It's not like this stuff has stopped. It's still happening. It's very
We've already been name dropped in this case. Well, the community has. Y'all have been name dropped in this case. But I just wanted to see what they were screenshotting.
prejudicial. It's only on one
Just
side.
wanted the chisme.
And that is one of my bigger concerns. Is all this pretrial publicity benefits one side. It's not balanced, and one side's not speaking to the media, and the other has free reign to do stuff like survey.
We just acknowledge for the record that Mr.
I'm still
Skordas
gonna
is
try to
a
pause it.
spokesperson for members of the Richins family,
I was
not
just
for the state
curious.
of Utah.
Yes.
Yes.
It won't
But it
go
still
frame by
helps.
frame easily.
No, I
Get the benefit of it.
I understand.
I'll go look for
Okay.
it on the
All right, go
docket.
ahead, Alex.
I don't know if his PowerPoint will be filed. Oh, it's animated slides. There's the walk the dog letter. All right. This is this is a timeline. Wait, is this a timeline with text from the paramour, February 15th, 2022? If I was divorced right now and asked you to marry me tomorrow, would you? These we've seen in court briefly from Kouri's phone. Oh, cringy texts with the paramour. Your Honor, really? Remember, the attempted murder is alleged to have happened on Valentine's Day, February 14th. The murder is alleged to have occurred on March 3rd. Erik Richins died on March 3rd. He died of a fentanyl overdose, but whether she administered it is part of it. February 15th, 2022, I just want to lay on the couch and cuddle you, watch a murder documentary, and snuggle. What? This is new. I'm glad I paused. This is new information. February 19th, I want you today, every day, not just sexually, but physically, mentally, every day when I wake up. I do want a future together. I do want you. Figure life out together. This starts leading up to the give me a few days that I was talking about earlier. February 23rd, 2022. These are texts presumably from Kouri. The murder documentary in Snuggle is a new one. Is there a Kouri Richins documentary yet? I bet there is. The If I Was Divorced Right Now has come into court, and then the March 2nd one has come in other hearings. February 23rd, I have a crazy dream. Are these more or less cringy than Bryan Higgins' texts? I have a crazy dream. You quit your job, I divorce, and come up with millions and millions. I guess it's not really speculation that this is about money, because we all know that her prenup said that if she divorced him, she didn't take any of Erik Richins' money. It was only if he died while they were married. I divorce and come up with millions and millions. We buy Midway. That's the house I think that they were talking about, and live in the guest house and rent out the huge house as a big event center. $15,000 a day, like they charge down the road, maybe $12,000. Who are you going to rent it to? Jody Hildebrand? Oh, wait. She's in prison. Maybe $12,000 to stay competitive, and we'll just run the event, quote unquote, center as our daily job and hang out every day, raise some kids, have a little farm. Deal?
Survey says
March 2nd, 2022. Tell me you're worth millions a year. I love that whoever typed these in made a note that spelling "you're" wrong is not their typo. I'm honored to be your friend, best friend, actually, lover, go-to. Ma'am, you're married. Go-to. Life is going to be different, I promise. You're one hell of a patient person. I hate your hard days. They didn't put the sick under after that one. Oh no, that's because it's the right one, Emily. Shut up. I wish I could be there to turn them around for you. Can I try Friday? Give me a few days. Hang in there until then, please. Erik Richins died March 3rd. That's why that March 2nd text has come in. Erik Richins died March 3rd. She is texting her boyfriend. Can I try Friday? Give me a few days. This trial is going to be so specific. Yep. So March 3rd, 2022. This is why this case wasn't charged until they got into her phone. Can you imagine being the detective that saw that text message first? Knowing the timeline here, seeing that text message first, what is the first thing you say? All right, let's continue. I'm so glad we paused. On this. Let's continue. Let's see. Kouri Richins vows to prove innocence as new attorney takes on murder case. They highlighted that it has 2,000 views. Adorable. Let's keep going.
Dr. Edelman.
Are those Facebook comments? Those look like Facebook comments. Okay, we'll continue on.
Just stop us when you.
Okay, read the survey now.
All right, I'm going to put this back to
So
1.25.
would you like to skip just to those tables?
I'd like
or-
to skip the methodology, please.
I understand what makes a juror eligible in Summit County. We can keep rolling.
It made us all
This is just the
ragey.
structure of it. Okay. So these are the high level. In most of these surveys are designed based off of 30 plus years of research and people doing these. So there's very clear standards of how you do a community attitude survey for change of venue. And a lot of those tests, those questions have been tested, validated. We do cognitive interviews before the survey goes out, where we read the survey question to people and ask them to interpret the question verbally, so we understand, to make sure they're processing it correctly and understand the answers, so that people answer the question and interpret it consistently, which goes to construct
Okay.
validity. So important. But yes, so this kind of just shows a high level
He talks
recognition rate,
fast and I
80 versus
sped him up.
43%. You can see half of those who know the case followed it somewhat or very closely. In contrast, Salt Lake was just 25%. You have a guilt
Also, at 99% who have never seen that interview that he was talking about, we have over 2,400 votes. I'm going to leave that poll up for a while so y'all can vote. Nobody has seen or heard of that interview. It's just not heavily populated.
rate of 69% versus 58. Definitely guilty, 18 versus 8. And that my surrogate for fixed opinion, the presumption of guilt instead of presumption of innocent, is 50%. And then negative opinions. You can see people who've been exposed to the media coverage have somewhat or very negative opinions of the defendant.
Let me ask you on the question that would you have a difficult time convincing them? Would Ms. Richins have a difficult time convincing them she's not guilty? Where did that question come from? You said that's the question you use to talk about burden of proof, really, but how did that question, where was it devised from?
Yeah.
And
So
I think it's
one of the more
a-
controversial questions is, can you set that aside and be a fair and impartial juror?
I think that this part of the surveying process is really leading, because they ask the question, it seems, what would the defendant have to do to prove to you that she's not guilty? And then they use that and say, see, these people can't stick to the presumption of innocence. There are some of these survey questions that are leading, I think. I'm slowing this
and
part down
There's
now.
a bunch of research and literature on it that it creates socially desirable responses, and you'll see inconsistencies. People will say 74% will say they could be a fair and impartial juror, like on remember the American Taliban John Walker Lynn case.
You're really fast.
Sorry.
We don't need examples.
American Taliban case. 74% said they could be fair and impartial, and that he deserved a fair trial, and so on. But 30 plus, I think it was 34%, gave inconsistent answers in the survey. Like, he's as bad as Osama bin Laden. He's definitely associated with the Taliban.
We've heard
he's definitely guilty.
this
So you're
before.
not seeing consistent responses. When we look at what's called internal validity, you want consistent relationships. So if somebody thinks someone's guilty, strongly believes that, they should say they cannot be fair and impartial at much higher rates than people that don't know anything about a case.
And I don't
You don't
disagree
find
with that.
And it's because there's a clear socially desirable response. I'm supposed to be fair.
People
want to
think that they
I
can
want to be
be.
a good citizen.
I
But
get
people
it.
don't know how evidence is going to impact them because they don't know what's going to happen. This question was
Actually, let me ask you a question. What order are the questions asked? What do they ask the fair and impartial question first, and then the other more specific questions regarding
Nope.
in which study?
the American Taliban case?
In the American Taliban case, it was after they are asked the guilt question, they're asked the fair and impartial question, and then later on in the survey, they're asked different questions.
Why aren't the questions asked in the reverse order? And are there surveys in which they're asked in the reverse order and internal validity goes up?
I would have to look at the exact.
Wait, Your Honor, are you asking for a control group to make sure that the order of the questions is not persuasive? Your Honor, that's not how that works. We're in a battle of the experts. What an astute question. Are there different surveys where they ask them in different orders to see if there needs to be a control group? The judge just being like, what is the internal validity of this? Oh, Your Honor. It's like you're asking questions about scientific process.
Instrument because it's probably 40 pages long. But I unfortunately I don't have that in front of me, so I'm not sure. I could say I've done research on this question.
The court has questions.
With I don't know if you remember the Robert Durst case. Yes, the
I
Jinx.
do.
So what we did was we recruited people from the Jinx Facebook page who publicly stated very sensational, inflammatory comments. Like,
Again, we heard this in Coburger, but going to a Facebook page dedicated to a case definitely opts you in to a group of people that are very involved in a case.
he's a sociopath. I'm so glad he was arrested. I'm physically ill. These are pretty strong statements.
Don't
If
let
a
other
juror
people's
said that
cases
in
make you
a
physically
courtroom,
ill.
They'd be excused for cause, even if they say they could be fair. And then in the survey, we asked what they knew. They knew about the confession. Remember, the cheeks, you have the microphone on. They knew
Wait, Your Honor, did you watch the Jinx? I think the court is nodding, so he'll move forward. I don't think court watched the Jinx. The Jinx was really well done.
about murders that were inadmissible in the new case. They reported that he's guilty. I think it was like 100% or something like that. And a very high rate said that he couldn't change their mind, the question we asked. Then we read them a standard instruction from a real case about the law requires you to be fair and impartial. Everybody deserves a fair trial. And then we ask them the follow-up, can you be fair and impartial and set it aside, and why?
This doesn't
And
address
all
the
those
order of the
jurors
questions.
are people who professed extraordinarily strong opinions in a public forum, magically say, oh, yep, I could be fair and impartial. And the woman who said he's a sociopath, physically ill, was, I can listen to the evidence. Everybody deserves a fair trial. So there's just no underlying support for the notion that that is a reliable question.
No, Chad, we're not talking about
There's
Fred
also
Durst.
published literature on it. I'm not going to go through all of it, but one study.
Chad's like, I got Nookie on the mind. We're thinking Fred. No, we're not talking about Limp Bizkit. Robert Durst, not Fred Durst. Also, of the variety of docu-series I have seen done of criminal cases, The Jinx is one of my favorite, and I think one of the most well done. So if you haven't watched it, and you are interested in that, it is one of the most well done, where I think it comes from the perspective of, hey, what's going on here? Also, I am incredibly biased because the judge that oversaw the Durst case is one of my IRL favorite judges. So I was excited to watch it for him. But I think it really came from a take a step back and look at the case and look at this story standpoint, where not all of them come across that way. I think it was really well done. I think it's on Netflix. So I'll Google. Chat has probably already Googled, but I think it was really well done. I probably watched it through Hulu because that's where I find most things.
Moran and Cutler, over 70% said they could be fair and impartial, but 34% said that they couldn't put the media out of their mind. Inconsistent. This question came from a judge in Tennessee in a murder trial, Nicholas Johnson.
Yeah, you can watch it on Hulu.
All of these jurors had a lot of detail, and the judge would ask them the magic question: "Can you be fair and impartial?" And they would kind of, "I think I can. I think I can try." Things we've all seen a lot. And then he asked them this question: "Well, would Nicholas Johnson have a difficult time convincing you that he's not guilty?" And they'd say, "Oh no, he can't change my mind." So it was like this clear epiphany. So when I saw that, I was working on the post-conviction stuff. I started using it in surveys and found that it's consistent, it's internally reliable, it correlates with things like case knowledge, how closely they follow the case, prejudicial items. So it has all those checks that you want to look for internal reliability and validity. So I started using it.
Okay.
Okay. And this kind of is an indicator of the difference when we talk about connection and impact. This is a relatively small community, and you can see 70% have talked about this case or heard people talking about it online.
70% of 400
versus just 25% in Salt Lake. And those are some of the things
that
really stand out when it comes to spreading rumors, misinformation, demonstrating that this case has captured the community's attention. It's just people talking about it. And seeing it on social media, and then the connections to the family.
Will you go back one slide, please?
Okay, so this comes back to case knowledge, or media items knowledge. Shouldn't call it case knowledge. But you can see that people in Summit County who have heard about the case recognize quite a few details that were widely reported in the media.
So chat, just by me Googling, the population of Summit County, as reported by the Google, is around almost 43,000. Salt Lake's going to be larger than that. So that's what he's talking about, relatively small, and then relatively small in contrast to Salt Lake, which is over 200,000. But depending on where you live, looking at 200,000, you're still like laughs in Los Angeles. So relatively small, but 40,000 is, I think, when you're looking at it, relatively small. But when you're looking at where do you move it to, Salt Lake, 200,000 is not massive.
So 60% of them knew at least 4 of the 8 items we tested, and 56% knew 5 or more. And you can see those numbers are much lower in Salt Lake, which just shows, again, that people in Salt Lake are not following it as closely. It's not as significant to them as it is here.
And there were 9, correct? 9 facts that you asked.
You're right, it's 9. Sorry.
And what were the 9 facts that?
Off the top of my head.
Do we have them in another
there's
slide?
The slide there. You'd have to go to all of them. This is the recognition question. This is
and you remember that in Koberger where they had
Let me
the
ask you a question about the 8 media items.
Yes.
In Koberger, one of the big things was that some of the questions were things that the media reported that were not true in the case. And that was one of the big fights on the surveys that Edelman was doing. And one of the concerns from the prosecution is like, well, if you're asking people if they know this and those aren't things that are going to be in the case, are you infecting the jury pool with bad information by asking them about those things? So there were items that Edelman had pulled from the media saying, well, these are the things that are in the media, regardless of whether they're true, whether jurors had heard of them is a problem. So I don't know what the 9 things are here, but we'll see.
The state's expert, whose name escapes me at the moment,
Dr. Monson.
Dr. Monson, talks about the use of a red herring question to identify which respondents are just agreeing.
Acquiescing.
Yes, indeed. What is your view on whether any of that's baked into the recognition of the media items?
Absolutely. So actually, if you wouldn't mind jumping to that slide that kind of goes into that, keep going. And I'll just keep going until you see the similar case that's similar to
It's
the
a great
bogus
question from the
story
court.
that he used. Just keep going to the end of all this. But typically, you don't use bogus items. They're called bogus items in the change of venue world, and there's research on this. And the problem with bogus items is you have to create an item that's believable.
Thank you, Chad.
Right?
Chad also corrected me and said, no, Salt Lake City's at 200,000. Salt Lake County's at a little over 1.1 million. Thank you, Chad. I appreciate it. So I did not accurately Google, but that is a much more vast difference when you're looking at the county of Salt Lake vis-a-vis Salt Lake City proper. Thank you.
If you create something that's so outlandish, it's obvious it's not a real item. But by using an item that's believable and close, it's not that people are acquiescing. It's that they've developed a cognitive schema about the case, and it's consistent with their strongly held beliefs. What you're supposed to use of what we did is we use items that have less reporting on it. They've only been mentioned a few times, once or twice or less. And you should see lower recognition rates for those items. And you do. We have an item that only has 11% recognition rate, which is our item. Rather than a bogus item, we use that. And I'll keep going. The example, one more kind of on the point of doing this is this. This is the bogus item that he used. A Washington County woman was arrested and charged with the kidnapping of a 9-year-old girl from Cedar City. Well, guess what? There's a bunch of real cases that are consistent with this within the time frame where they're doing the survey. And if you go to the next slide, these are all the stories. And jurors, if you look at the respondents in his open-ended about this case, keep going, they're not acquiescing. They're actually, this is a quote, this is an example of one person referring to this case. So it's not acquiescing because a desire to just say yes because an inclination. They're citing a real case that's similar to the items he created. And if you go to the next slide, there's a whole bunch of them that fit into that.
Did your survey use a bogus-ish, or sorry, not a bogus item, but
a lower recognition.
Yes. Item? And what were the results there?
Jump all the way back. The 2 surveys. And there's huge differences. So why would people acquiesce in one and not the other, right? You would see that similarly, and you'd see yes consistently. You wouldn't see variance across the items. You would just see really high recognition rates across everything. So this one only has 43%. This one has, keep going.
These are the different items. So they are going through the different items, but we can't see the PowerPoint. So this one looks like it's talking about the fentanyl sandwich.
Keep going with our listed.
Erik told a friend that he thought his wife was trying to poison him. That's the next one.
You can see it.
Kouri bought fentanyl during, it looks like the week leading up to Erik's death. So these are the recognition items. Kouri allegedly killed, I think, her husband by giving him a Moscow Mule laced with fentanyl. I'm glad I know this case well enough to try to parse these.
So you see the list of all the 8 items.
Kouri allegedly killed her husband for financial gain.
Those. Okay. So the last one, Kouri wanted to kill her husband.
So now we're trying to get to what might have been the red herring question.
Okay. So the last one, Kouri wanted to kill her husband so that she could start a new relationship with her boyfriend with as much money as possible. That only has a recognition rate of 12% in Summit County and 7% in Salt Lake.
Yeah, because that hasn't come in court in that way.
Okay.
I don't know where we are now. Do you want to go back to some of the
Go to the
survey
next one,
numbers?
because this kind of goes to that too.
I feel for the defense attorney. The defense attorney's like, I don't even know where the fuck we are because y'all keep jumping around. I feel for the defense because the judge is just jumping in, asking questions, and the expert's like, let's go through here. She's like, I don't even know.
Going until you hit this table. So
She's like, I'm just not in charge
this is
anymore.
how we check again internal
Just fuck it.
validity. Right? There's predictions of what we expect to find from the social science literature. People who know more information, have more case knowledge, are more likely to have bias. That's what we expect to find. That's how you check for construct validity. That's how you check for internal validity. And that's exactly what we find in our survey. We're finding consistent, predictive relationships that are based on 30 plus years of social science research. That's some of the ways we test for this. And this is part of why we do it this way and why we use the established questions and measures that have been used for decades and validated. Okay. And
So forgive me.
And the judge is like,
And I
can we move on?
acknowledge that your survey results may not either be this granular or this cumulative, but did you determine the
I like the
area
court's
under some
questions.
of these curves? Meaning, of the 400, what total percentage recognized between 0 and 2 or 3 facts? Does that make sense?
I'm sorry. What do you mean?
Who recognized
One more
just
time
a
for
few
me.
So
facts?
there's lots of small subgroups, right? And they're in each of these.
I
squares.
got you. This is only for people who have read, seen, or heard about the case.
Okay.
Because the other people aren't asked any of these questions.
So even among the people that have read, seen, or heard about the case, did you calculate what percentage of those recognize 3 facts or fewer?
Recognize which one?
3 facts total or fewer.
So you can see,
How can you not hear this, judge? We've got literally battered, deep fried microphones, and we're all on the same page. The judge wants to know, of the 400 people, 79-ish% had read, seen, or heard about the case. Of that 79-ish%, how many had only heard 0 to 2 things? Who had only heard just a little bit about, like, just the tip about the case? How many are those? Vis-a-vis how many knew everything about the case?
well, yeah. So if a couple interesting things. One, you can see like 0 facts, only 29% say guilty, right? 71% have.
Yeah, I know. I'm asking a
Yeah.
slightly
So
different question.
go back a couple of slides. It shows how many know this one here.
Thank you.
The court's like, no, the information I need is if you'd heard about the case, but only knew 0 to 2 things about the case. Do you have a predetermined bias about guilt or innocence?
Yeah.
Victoria, we are not in
I would
Coburger
have to
today.
look at
We
the
are
data itself
in,
to
So if I'm reading this
Summit County,
correctly,
Utah.
among the 80% of Summit County respondents
they want to move to,
that have
Salt Lake.
read, seen, or heard about the case, 34% recognize 3 facts or less.
Yes.
Okay, thank you.
Sure. And then, so if you jump ahead a little bit here, so this is just an
I know.
example of
At-
one.
Chad,
And
I
you see,
know.
again,
At
that-
some point, the Summit County HR department is just going to email me and be like, Miss Baker, we're going to need you to stop it. It's not my fault. The Amazon AI made me.
how knowing this detail, this was widely reported. Quite a few people know this fact, and it's correlated with perceptions of guilt and our fixed opinion question. So it's significantly related to that.
And do you have the percentage of people surveyed in Salt Lake who knew 0 to
I didn't-
3?
It should, in theory, be as well. This is just for Summit County.
Okay.
Okay. And then the next one, the Moscow Mule one. That's a big one. Very widely reported, very high recognition rates for this item.
The Moscow
And
Mule
you
is a
notice
thing.
77% who know it think she's guilty, and 57% reported that she'd have a difficult time changing their mind. This is one about buying fentanyl the weeks before. 64% know about that. And if you know it, very high guilt rate, 81%. And this kind of gets back to the voir dire.
right. If you've been watching this case in court and have heard time over time over time the testimony that in the weeks leading up to his death, she bought fentanyl and then he died by a 5x lethal dose of fentanyl. And then when law enforcement showed up, guess what they didn't find anywhere? Fentanyl. I can understand why people were like, well, if I know that, I have thoughts about the case, because generally when there's an overdose, when someone overdoses, there is indicia around them because they were just using the thing that they overdosed on. So it's normally right there. So yeah, I get it.
Problem of somebody, if you know this is a prejudicial item or the previous one, and they don't mention it in voir dire when you ask, what have you read, seen, or heard about the case? Well, there's a significant percentage that know it, but you can't ask this question, because if they don't, you're poisoning that juror. And that is the biggest unique thing about high profile cases versus your regular case when you're doing jury selection.
And how is that going to be better with the Salt Lake County jury?
That's the
Well,
question.
that's true everywhere. If it's a case where there's pervasive media coverage and a lot of people know facts, you'd have to look and see what that recognition rate is, but it's lower.
It's lower. And we have that, don't we, in the survey?
It's in here.
It's there. Okay. All right, go ahead, Alex.
I think I understand these dynamics.
George
Was there
says
anything else you
hello.
wanted to put on the record initially here, Ms. Lewis?
Right.
Yes.
Hi, buddy.
Let's go. Just go ahead and when we get there. Go ahead, Alex. Just.
Do you want to talk about this or?
I can't
Well,
get you.
I wanna
You're
talk
out of
about,
range.
Well, I do. I want to talk about the survey that was conducted by the state, and as the judge said, the recognition level is similar.
Mhm.
But why is the survey that you did more reliable and should be considered in terms of what we're going to actually see in the courtroom as compared to what they did?
Well,
know,
I think
know.
at a
I don't
high
know
level,
what
I would
to
ask, I'm not quite sure what the survey is trying to measure. So the survey I'm trying to measure is bias, prejudgment against the defendant, and whether a presumption of guilt is pervasive. There's no question in there about guilt or what their opinion is. What details, there's one question about details, which is just briefly described. So there's a number of issues there. The whole thing to me looks like it's a test. It's written, the cognitive effort to answer it. You've got, here's a list of 9 names. And then if you answer yes to each one, then there's a question about each name. And then here's a list of 6 random stories. Sorry. And then
This is him talking about the state
how
survey.
familiar you are with that. When we write surveys, one of the things you want to do is make it simple and easy to follow, because there's something called survey fatigue. And the more complex it is,
I'm fatigued.
the more likely you're to start getting bad data. So I don't think name is an appropriate identifier for case recognition. A lot of
I'm
people
sorry.
don't recognize names. I mean, I remember I did the change of venue for the Pittsburgh synagogue shooting. Robert Bowers was the defendant. I would not assume if somebody doesn't know the name Robert Bowers in that area that they don't know the case. I don't think that's appropriate measure. Names are much harder to recall. And then just some of
Okay.
I don't understand the definition of impartiality that he's using. No, don't recognize the name versus not recognize the name.
What?
Does that make you impartial? It's not about recognition of a name. It's about, do they think that she's guilty? I've never seen a definition of impartiality in a case where it was just based off of,
Do you know the case? Do you know the case?
if you say you know the case or don't know the case. That's not the criteria. The questionnaire design is another issue,
George's-
I think, in terms of,
I
like
am
I
not
said,
George's
the complexity of it.
Preferred human.
There's
I am
questions
his.
that I
you'll
still don't
do
understand
human.
the questions asking. And then when you do an online survey, there's something called satisficing. And
I'm sorry, called
satisficing.
satisfies.
And there's things you have to look at. So the way this was done was a text message to like 50-something thousand people. So you're getting it on a phone. You could be at a movie. You could be at dinner. Who knows where you are. And if you tap on it, you're given a survey, and you have to make sure people aren't quickly just.
Why are you tapping on a survey on your phone while you're at the movies? I'm so confused.
burning through it fast to answer questions. You don't know how closely they're reading a question. You don't know if they understand the question, which is why we do telephone surveys, because you can read the question to the person. You control the pace. You can try to do soft refusal conversions to encourage them to take the survey. You can answer questions. You can ask probes. There's all these things you can do that you can't do in an online survey. One person was Googling stuff as they took the survey and literally copied and pasted something from a newspaper article into the open-ended
Oh,
question.
I've stopped petting. I'm sorry.
You don't know if people
trying
are
to
taking
work.
the survey with friends. You don't know if they're giving the link to someone else. And there's all these things. Who takes online surveys when you were so used to spams and text messages? All of these
Who
issues.
takes online
I don't
surveys
know what
anyway?
the phone survey looked like because it was never provided to us. The other thing is you always tell them there's no right or wrong answer, and you can always answer with no opinion or don't know. That was not done here, and it wasn't given as an option. One of the big things with yes or no questions, first, they're used all the time. Go look at a Pew, Gallup. All of them use yes or no questions. They're not automatically.
Chad, I agree with you when he's like, "Who takes online surveys anyway?" It's like, don't talk to us and our BuzzFeed tests, sir. Who takes online surveys? Who answers phone calls? I am more likely to take an online poll than answer my phone. Just to be completely candid. What about the rest of you? Like I would answer something online way more than I would answer an unknown caller on my phone. Like 100%, if it's unknown on my phone, I'm not answering the phone. I'm covered in cat hair. I'm going to try to remedy that situation. We'll let him continue to talk. Who takes online surveys? Who answers an unknown number?
Affected by acquiescence. But you give a no opinion or don't know option, which reduces the pressure to answer yes. There's no option to use that here. So there's a host of things there. And again, there's 30 plus years of research on this. There's professional code from the American Society of Trial Consultants designed specifically to write change of venue surveys, which are based on
speed.
APOR, American Association of Public Opinion Research, and
notice he's
research
slowed down
methodology that have been
significantly.
published. That's why we do it.
Speeding
And the American Trial
Society of Trial Consultants.
They specifically in their code include the question about presumption of guilt.
Well, not a presumption of guilt, a measure of guilt.
A measure
You
of
have to
guilt.
measure guilt. That's the question to identify if you can get a fair trial, not how many people know the case. They could know the case and it could be nobody thinks she's guilty because the coverage was really favorable. Like,
well, if they don't know the case, they don't know the case.
And the other one
they don't have an
that is
opinion.
not in the state survey is checking specific facts of the case.
yes,
It's one of the standards used in these types of
you
surveys.
measure case knowledge. Even his question, if you go next to the case knowledge question, is not even a measure. Well, this is the one.
So
when we
this
talk
is
about
the defense
ambiguity
expert talking
and
about the
construct
state's
validity.
survey.
Construct validity is what are you trying to measure? So we're trying to measure bias. That's our construct validity. I don't know what this means. Thinking about your opinion of Kouri Richins or her case, how fully formed would you say your opinion is? I don't know anybody that understands what a completely unformed opinion is. And what happens is people interpret the question differently. Some people think it means uninformed. Some people might think it's not strong. And when people interpret the question differently, you have a problem with internal validity. If we all don't interpret the question the same way, it's not a reliable, valid measure.
So we need to use language that has a general understanding as opposed to something. We need to use language that people have a general understanding of what that means.
It's basic standard of survey design, which is why the questions we use are piloted.
And the court said, why can't I just accept both surveys? Also said, isn't the state survey favorable to you? That's what the court said to the defense. I don't think the court is going to fight over which survey to accept.
We do cognitive interviews to make sure they understand them when we add new questions. And it's based on people doing this for 30 or 40 years. We don't just manufacture questions and then throw them into the wilderness.
You can't just
even when
splash
he
it around
asks
like spaghetti.
What they know, he doesn't say, please tell me, first of all, please explain what you know. It's what have you read, seen, or heard, not explain. And the word briefly tells me, don't tell me everything you know. Be as brief and concise as possible, which is not what you want. You want a full explanation of everything. And then how certain would you say you are that your explanation is accurate? What does that mean? Does that mean that my explanation is accurate of what I know, or the explanation
is accurate of the description, or are we asking if the media coverage is accurate? I don't know, but it can be interpreted different ways, and that's the problem.
That makes sense.
And then population of interest. It only looks at registered voters, and I don't know if this is significant because the list here is made up of the DMV list and registered voters, and only 63% of Utah eligible voter population is registered to vote. It's actually ranked as 45th in the country. So there's a big number of people who are not registered to vote, but are eligible to serve as jurors because they have driver's license and they in this county. There was no question about that. There was no question to remove felons, all the basic things that you typically include. So yeah, that as well.
Go ahead, Alex. I do want to talk about, and you have touched on a lot of this already, but is there anything else about voir dire and why that isn't going to solve the difficulties in this case?
We've already heard him talk about it.
So one of the things that comes a lot when I do this is, well, why don't we just try to
interject? Sorry. I need you to highlight
The court's like, I'm going to stop you from rambling about that. And rambling's not meant in a judgmental way. He enjoys explaining what he knows. The court's like, I don't need you to explain this to me again. You've already talked about it. And a lot of you asked, or a number of you have asked in the chat, but if you can just get 12 jurors, does it matter? The position of Mr. Edelman is that if you have a substantially high population that knows about the case, them coming in and saying we can be fair doesn't mean that that's a fair jury for Kouri Richins, because the more people know about the case, the more likely they are to believe that she's guilty when surveyed. So if you have a large percentage of jurors coming in that know a lot about the case, even though they say they can be fair, their brains already have a unconscious bias, and that is the problem. So you want to move it to a place where less people know about it, because once you get them in the seat in front of a bunch of their peers and in front of this judge, who wouldn't want to say yes? The judge is like, can you be fair? And everybody's going to be like, 100, whatever you say, Your Honor. And then you've got the worry that the people who are going to say they can't be fair aren't really feeling that they can't be fair. They're really feeling like, I don't want to be here for a week or 2 or 3. Miss me. So there is concern that people will answer the question, yes, I can be fair, genuinely wanting to be fair, but brains don't always work that way. So that's the reason they're going through. Even though you can find 12 that'll say they can be fair, you want a higher population of jurors that have less information about the case. Let us continue. Also, thank you guys for no breaking news in the chat on other cases. This is the case that we are covering today. We will talk about scheduling at the end of the day, but I appreciate the mods. Remove it, and it's not because you did anything wrong. So it's not that. It's that we stick to no breaking news because we're trying to focus on this, and I don't want to sidetrack because I'll never stop streaming. Let us continue.
the challenges of voir dire that are specific to Summit County that would not be present in Salt Lake County, given your survey results showing the substantial.
So the court is asking for more specific information.
Exposure to the case in Salt Lake County.
Yeah. So the problem that exists here in terms of if people have a lot of detail, like there are people in Salt Lake that know this case. The benefit, again, is they don't know as many case-specific details. They haven't followed it as closely. So fewer people are likely to know specific things. That they know.
Can I ask you a very practical question? If you were advising the defense,
I like the judge.
would you advise them just strike everybody that recognizes the case?
Well, here's here or there?
Both.
Well, here's the problem in my mind. Let's say that's your gut reaction. So let's just get rid of everybody that knows about the case.
Yeah.
Here it's 80%.
Sure.
Let's say. Well, who are the 20% left? Well, what if your jury profile of when you're actually thinking about trying the case is like the best jurors for us are the most engaged in this community and they're most educated because they're most likely to stick to the jury instructions and most likely to hold the government to the beyond a reasonable doubt standard.
But with respect, you just pivoted to favorable jury, not fair and impartial jury.
Well,
So
if
ding,
the idea is
ding, ding, ding. Did you hear what the court caught? The court said But would you advise that for a fair and impartial jury, you want to kick everyone who has knowledge of the case? And then he gave his answer, and the court said, you just shifted from fair and impartial jury to favorable jury. And I think that's a part of it. So when y'all ask me, like, why didn't the Karen Reed case look for a change of venue? I have to wonder if the defense has estimated that those who know about the Karen Reed case in and around Canton are favorable jurors. So if you change venue, you might have jurors that know less about the case, but in that case, it might be favorable for Reed to have jurors who know more. But this motion is not about finding a favorable jury. It's about finding an impartial jury. And the court was just like, we're trying to find fair and impartial. So, let's continue. And I agree. The judge said, if you were advising the defense, but the motion here is not helping the defense find a favorable jury. The motion here is that Kouri Richins cannot get a fair trial in Summit County. That's the point.
Jury are just people who are disengaged in the community, are not highly educated, don't follow the news. Well, you got people that don't know about the case,
I think,
but
with respect, people that are
Hey,
relatively
Magdalena, will you just block the name of
disengaged,
that other case?
overwhelmed with their daily
Thank you.
activities, not engaged with the news, are fully capable of being fair and impartial jurors. So stick with the fair and impartial prong for me for a second.
So we can stay on topic.
so I mean, if
Thanks.
that's the premise, is it's okay to get rid of like highly educated jurors, or if that's your profile, then sure. One thing you can do is say, let's get rid of everybody who recognizes the case and see what's left. I mean, I've never seen the sides agree to that.
Why isn't that dynamic the same in Salt Lake County?
Well, in Salt Lake, there's fewer people that recognize the case, right?
Sure. So if you get rid of all of them, isn't the same dynamic of the people that recognize the case, in your view, are likely to be highly educated, highly engaged?
Mhm.
I don't know, I'm spinning a hypothetical here based upon
There'll
What
be
you're
more
telling me.
people that are highly engaged, highly educated that don't know about the case
where does that come out of your data?
because they haven't followed the cases closely. Like here over, what was it? The number of people in Summit County that are fascinated by this case, follow it closely, somewhat or very closely, are much lower than in
How
Salt Lake.
many facts indicate following closely versus not closely? What would be the break over there?
How many facts?
How many
How
media
many
facts
items
recognized
that they
Oh,
recognize?
there's a
would
table.
indicate following it closely versus not?
You'd have to jump. There is a cross tab on there.
The judge
Can we
remembers
go
his
back?
data
That's
better than he
You have
does at
any
this
idea
point.
where it is? Go back, Alex. Is it this one?
Go back. Well, I mean, this would kind of tell you, this is a theory of 100 jurors walk into the courtroom. Let's see if this answers that.
I can do that math.
Yeah.
I need to understand your.
So you can see that second.
The court's like, I can math and I can read. What I can't understand is that you are talking in circles when I am asking you a direct question. And the judge is like, why do I have a better grasp of the data that you've given me than you seem to have a grasp of the data? And I think that the defense and Edelman were probably going to just go through his PowerPoint in order. And the court's like, no, I can read. I need you to explain these specific questions. And the court is trying to figure out, why would moving this case from Summit County to Salt Lake County give Kouri Richins a better chance at a fair and impartial jury? That's what the court wants to know. And the court is trying to get to that information. He doesn't want the sales pitch. He wants the data. And the expert keeps going back to the sales pitch, which is, I'm sure, what a lot of courts allow. Just cue up the PowerPoint at the beginning and go.
Followed it somewhat or very closely. Summit County 40, Salt Lake only 11.
Okay, so let's stay there for a moment. Does it follow then that 60% of Summit County jurors do not follow the case somewhat or very closely.
Right. That's what the
Correct.
court wants to know.
Okay.
So 60% of potential jurors in Summit County have not followed the case closely. The answer was correct.
Trying to find that. If you go back, there's a cross tab that shows the relationship of, so this is case facts relationship, but go back one more. Keep going until you see it, a cross tab that shows.
George, if you knock that over, it's going to be real loud, Bubba.
This one. Okay. So this kind of gets to whether they fought it somewhat or very closely. And you can see the guilt rate's quite high. And that's just a measure of what you'd expect of engagement. So if they followed it very closely, it's probably mediated through case-specific knowledge.
Right.
Just high syndic guilt.
I'm trying to interpret the numbers at
Samantha,
the bottom
I'm gonna-
of this matrix.
We'll
Does
hold that question
mean
for a little
that
bit.
out
That's a
of
good question.
400 respondents, 462 have followed it not too closely or not at all.
Well, it's not out of 400. This is out of the people that have read, seen, or heard about the case.
Okay. So bear with me.
The court is
And one thing, just 'cause you
so
passed
on
it,
top of this
but just
data.
mentioning that the rumors that have spread in this community as well that are unique here. That
And so back to
the court was waiting to ask a question, and he's just throwing in more information. He's like, the rumors, the innuendo. You're not Meredith Marks. But I'm getting the sense that he's trying to get the defense attorney to jump in and ask a question, but the judge was saying, give me a moment. Let the judge have a moment.
Mrazek's point, in Salt Lake County, the fact that someone has not heard as many factors or hasn't heard of the case, does that translate as it does in Summit County, that those are just uninformed jurors? Or is it have to do with the fact that Salt Lake County has more of a news influx and it's a bigger county?
I always
That
look
might
at.
have been worded real
Yeah.
well, but I think you understand what I'm.
Well, I mean, let's take a step back. We started with Salt Lake County to see if recognition rate was lower because it's really close here and it's the largest county. Like that's always the first step. That was the primary county I looked at, or only because it's big, it's 30 plus miles away, and recognition rate looked lower. If we're high numbers, we would have looked at a different county. We would have kept going further away.
Let's talk about that just for one moment, because that comes up in the state's response. Why didn't you look at Washington County, for example?
Washington County? Well, we talked about that. So the plan was we had money in reserve to do 400 completes for
He's like,
comparison
we talked about that. Not in court, you haven't.
survey. We didn't want to do 400 in one county, and then it turns out there's no difference, and we spent all that money. So the idea was to start with 200, stop, look at the data. If the data in Salt Lake looked bad and recognition rate was high, we would have done Washington County as the next one. And that way we're not burning through the county's money. When we looked at the 200, the recognition rate was much lower. So rather than spending another $11,000 to do more, we stopped.
And can you address also, do we need to be concerned about that we looked at 400 in Summit and only 200 in Salt Lake, and how that might affect the numbers?
How it affects, what do you mean?
How it affects the percentages? Is 200 enough
The margin of
make
error?
these?
Yeah.
Thank you. The margin of error.
It's 7 plus or minus 7 at 200 instead of plus or minus 5. That's it. And again, the point isn't
Plus or
precision.
minus 7's the margin.
I'm
of
not
error?
trying to predict the outcome of the trial or the outcome of an election. I'm trying to weigh and assess if there's bias in the community. Reasonable likelihood, lower than the preponderance of evidence.
Small
So
sample.
that's the question. Is there bias? Not precision and exact measurement. That's not what I'm really going for.
And what's your conclusion on whether or not there's bias in the community in Summit County?
Based off of the survey data and the nature of the media coverage, I think there's a reasonable likelihood that she can't get a fair trial here. I think
And that's
the
his
example,
conclusion.
like I mentioned before, when we compare the open-ended, on average, I think people mentioned like 0.7 media items, details about the case,
I
but they
had to.
knew an average of about 4.3 additional items when we asked the closed-ended question. Only 10% mentioned the walk the dog letter, which is significantly related to prejudgment, but over 40% know about that. So those are the kind of things that come into play.
I just want to, I'm sorry, Doctor, I just want to clarify that. So when you asked the open-ended question, what do you know? 10%.
I don't think the
mentioned
judge
the walk
cares
the
about
dog.
any of
Yes.
this
But
information
then when
because
you
it's in
went
his
through and
report.
said, have you heard about the walk the dog letter? That
40.
jumped to 40.
Jumped over 40. Yeah.
But that's only among the 80% that recognize the case
Yes.
writ large.
Right. But it shows
Right.
you the problem, the pervasive problem of there's a group of people out there that know prejudicial, potentially inadmissible content. That's just one of the items, but you don't know who they are. And you can't say,
I appreciate that he said potentially inadmissible content, but I think that walk the dog letter is coming in.
hey, well,
judge hasn't
Ray,
ruled on
did
it
you know
yet.
this? Because they could say no, and then you just told them. Or they could say yes, and then you just, again, confirm that people know more than they know. So what are you supposed to do as the in voir dire if you're the defense? How do you exercise cause challenges if you don't know if that person could truly be fair? You have to weigh what they know versus what they say. If you look at all the court decisions, that's important. It's a totality of the circumstances, and you just don't know what they know. And that is, again, I harp on this because I've done over a lot of these. I've worked on over 70 of these. That is the problem with these cases relative to every other normal jury selection we do. General attitudes are not predictive of behavior. Specific.
That is a fair problem that voir dire doesn't well address. I agree with the problem. I don't know if I agree with the conclusion in each case and the some of the ways of surveying and illustrating that. But in every high profile case, this is a problem. However, that is also why we have juries of 12. I mean, in this case, it's less because it's Utah and they only do 12 on capital cases. But it's why there are other jurors, because if a juror brings it up in the jury room and says, well, what about, this? And the other jurors are like, that's not in evidence. It's why it's not one person. So there are more factors to that to try to find a fair and impartial jury, but it is difficult. And cases have not just faced this problem in the age of social media. Cases have always been able to garner significant, specific local interest. There's more interest outside of the jurisdiction for some of these cases that we might have not heard about if media didn't travel as broadly as it does now, but intense local interest has always been an issue.
Attitudes are. When we have well-developed attitudes, we look for information consistent with how we see the world. It's called confirmation bias. Information consistent with what I already know is given more weight. It's stored in long-term memory.
Humans.
It's easier to access. Information that's inconsistent is not stored into long-term memory. We make a cognitive effort to refute it. So all you're doing when you hear this evidence that's consistent with what I think about this case is confirming what I already know. You're triggering nodes in memory, which are all this stuff I saw in the media coverage, and becomes activated, and new information is processed based on that. So in voir dire, when you ask, tell me everything you know, people will not remember everything because that's the way memory works. Just like movies we saw as kids, we don't remember everything, but when you watch it with your kid today, it's like unlocking a vault. You watch 10 minutes of it and the whole
Core
story
memory
unfolds in front of you before you've seen
Darkwing
it.
Duck.
That's how memory works. And that's how it works for jurors too.
May I ask a question?
Yes.
You may.
Have you reviewed the questionnaire that went out? Not the responses, but the
It is a good
structure and
point.
form of it in this case.
The underlying premise, I don't disagree with. The underlying premise is, how do we acknowledge what humans know and how they see the world in the jury process? And one of the ways our system answers that is by having numerous people on a jury. And that is part of how the checks and balances work. And also having appellate review, and also having case law about bias in the jury room, and also having a voir dire process, and also having an adversarial system, because people can still change their mind. We saw this writ large in the Gwyneth Paltrow case. A lot of people came into the Gwyneth Paltrow case, and not on juries, but here in the chat saying, this is how I feel about the case. And we got through the case and people were like, damn, okay, well, my feelings are my feelings, but this case is also BS. And the plaintiff shouldn't win here. People are able to take in the information they are given, discuss it with their other jurors, and change their mind. So it is something that needs to be accounted for. And I think the Idaho case is very different because the communities are different, and it's a college community and you have 4 victims. It is a different case than this case. Randy said we saw that with Depp Heard too. We did. I went into the Depp case like, I don't even know why this is going to trial. I don't know how you win this defamation case. I mean, I went into the day that the Baldwin case got dismissed and was like, all right, well, the defense, here they go, doing their job, throwing spaghetti up against the wall. Midway through, I'm like, holy shit. You have to allow for the fact that we try to control for this within the jury system by not just having one person make the decision about.
I have not.
Okay, thank you.
So.
And I will say,
Well,
But I don't disagree with
That's
the
okay.
concern.
Or the answer is no. That's fine.
yeah,
I don't disagree
Okay.
with the concern.
Thank you.
he actually did review a draft of the questionnaire,
Oh, okay.
the first draft of the
I
questionnaire.
did see that.
All right.
Is there anything else that we haven't covered that you think we need to talk about?
No.
Not off the top of my head. The only thing I will say is,
But
one
if
of the
I
questions
say ham sandwich, will you then think of something?
we ask her what rumors.
Oh,
you've
no,
heard in
Melissa,
the
you don't have to
community
send me a mug.
And what you heard about the cause of his death.
That's very sweet, but
And
you don't have to send me
That's
a
where
mug.
you
Thank
see again, small community,
I
the spread
appreciate it.
of misinformation and speculation that about her, about whether she's a good mother, and drugs and all these different things that aren't in the media. And you can see a strong belief in terms of the cause of death being what's widely reported in the media. So just, if you look at the opens, there's quite a lot there as well.
And you didn't see that in Salt Lake on the rumor question.
There's a much higher, I don't know, no opinion when you look at those opens there.
I don't think I have anything further.
Need a brief break, Mr. Bloodworth? I don't know how much time you have with Doc.
I want to know what's in the thermos. Water, coffee? Probably coffee.
Your Honor, I do not need a break. I don't know, 15 minutes.
Mr. Bloodworth's like,
Okay,
can we
keep
just
going.
do this
I have
now?
a diaper on, so I think I'm good.
All right, very good.
Jesus Christ.
Mr. Blood.
I hope that didn't get put on the record.
The court looks dead ass to camera. Do we need a break? I have a diaper on. I hope that didn't get put on the record. Yes, it's on the record.
Your Honor, I do not need a break. I don't know, 15 minutes.
Okay. You okay to keep going?
I have a diaper on, so I think I'm good.
All right, very good. Mr. Blood.
You're on the witness stand.
I hope that didn't get put on the record.
In fact, it went out to all the people that you worried about.
Hi.
Good morning, Doctor. My name's Bryan.
Good morning.
How are you?
We're the people.
Um,
I have a diaper
Well,
on.
thank you. How are you? As I read your affidavit,
Lord.
kind of 2 parts. One is a style of media analysis.
Oh, yes, it will be on the
other
record.
style
The court
of
reporter 100%
survey.
took
Is
that
right?
down.
Yeah, I think that's fair.
And then there's also, is it fair to say there's some interrelationship between the two?
I think it's a kind of like 2-step. Like, is the media coverage prejudicial? And then has it had an impact on the jury? I would say, on prospective jurors.
Okay. And is it fair to say that the media analysis is more subjective and the telephone survey is more objective?
It's a qualitative analysis for sure. It's yes,
Qualitative versus quantitative then?
correct.
Let's begin, please, with the media analysis.
Let's begin,
portion.
please,
Okay.
with getting back to 1.25 speed.
In your media analysis,
Perfect.
You base it on a limited search of the park record. Is that accurately stated? It's page 10 of your affidavit. Do you have it there? I'm going to refer to it.
I try to be conservative with how I collect the coverage. So I looked at the park record. That's the local paper. I wasn't looking at things that don't have circulation in the community. So I would say it's an underestimate of the number of articles. I looked at the radio station stuff and things like that.
I'm actually interested in this part. So, and then I sped it up.
What sort is the park record circulation in Summit County?
Actually, can you?
This mic's not working for me apparently today.
Nobody can hear Mr. Bloodworth
lean
today.
into
I
it.
hear him. The
Thank you.
microphone is deep fried, Mr. Bloodworth.
What sort is the
It went to the state
circulation of the
fair.
park
It got
record in Summit
battered.
County?
It was with the Oreos, and now we've got deep fried microphone. But the how you collect the media is a question here. And he says, I stick to local media. We asked this question in Coburger too. It's like, okay, well, people in Utah watch YouTube.
I'm not sure. I know in this survey, over 50% of people who read the paper mention that paper as one of the newspapers they read.
And if they
I
read
take
it
it then
online,
that you don't know the park records circulation in Summit County vis-a-vis ABC4's viewership in Summit County or KLS TV's viewership in Summit County.
Is that the radio station or
It's a TV station.
the
out in
TV
Salt Lake.
station? Yeah. I was only looking at a conservative number of articles because I don't want to look at things, for example, in like the New York Times, because I don't know if people read the New York Times in Summit County. So it's a conservative estimate and a conservative approach to collecting the coverage and reviewing it.
do you know that people in Summit County read the local paper? Or do they go on their phone and pull whatever news from their news aggregator?
Write the survey. So I'm not looking at blogs. I'm not looking at things like that. I'm looking
And I'm
specifically
not
at
in
the
Summit County,
newspapers with
and I know
circulation in the
KLS from
community.
YouTube because
And
they covered
specifically only the park record.
Ruby Frankie.
But you will acknowledge that people in Summit County read the New York Times
Sure.
and they watch the 4 Salt Lake City local TV stations.
Yes. I might understand that's the only one here, right?
Right. It's the
You
same,
don't have a TV station that's
same media market. Salt Lake City and Summit County are same media market, which is different from Moscow to Boise, different media markets.
just Summit County.
No, you
Right.
do understand that the Summit County media market is the Salt Lake City media market?
Yes.
But you understand people in Summit County watch 48 Hours,
Sure.
Dateline,
Sure.
Good Morning America.
I'm assuming if people still watch TV these days.
Sure. And they read People
Right.
magazine as well, don't they?
Yes.
I mean, they don't read People magazine, they read people.com, but sure. I mean, or TikTok or Instagram or whatever.
Park record covered defense motions in this case. They didn't.
I'm sorry, defense motion?
The park record covered defense motions in this case.
I guess. Sure.
I don't know if that matters. But
On Q9 little I of your poll,
I don't know about the mics, guys. We did our best.
you, or rather of your survey, I've been corrected on that, of your survey, you mentioned, you asked people what is their source of local news coverage, and they're supposed to give you a response. Can you take a look at that?
Let me see. Q9.
Q9 Romanet 2.
Let's see. That's only asking the source of Q9I,
Yes.
not their source of
Can you
information.
just clarify what it's?
Yes.
Oh
the
my
reason I
God.
did that was back to the idea that the source of information gets stripped. People forget where they heard it.
Mhm.
So I used this low recognition item. Have you read, seen, or heard if Kouri wanted to kill her husband so that she could start a new relationship? That was something the family spokesperson had said. And I wanted to see if they remembered that it was him as opposed to like in your, state's papers or something like that. I just wanted to know if they remembered the source of that particular comment.
And 23 people provided the source. Is that right?
Yeah, I would have to go back and look.
And of those 23, 3 referenced the park record.
3 out of 20. Well, one, I don't have it in front of me. So was it 23 as opposed to 38?
Let's provide it for you.
Sure.
The judge is like, must we? I can't speed it up too much because the mic is so hard to hear that speeding it up makes it worse.
While Mr. Bloodworth is looking for that, can I just confirm that this thumb drive contains the written version of Dr. Edelman's declaration, survey results, and supporting exhibits and appendices? Is that correct?
It does not include the PowerPoint, which I can send you. It only includes what I was unable to file attached to our motion because it was too large.
Okay.
So it's his declaration and the survey, but it is not the PowerPoint.
I understand that the PowerPoint, the tables in the PowerPoint, though, come from the survey results that are on the thumb drive.
Yes.
It's okay. Very good.
The judge is like, are we ready? Are we ready? Are we ready?
Thank you.
Are we ready?
Sir, can you please again say what you're trying to measure there?
Well, what I wanted to measure was whether or not they remembered that some of these comments came from the state, or from this, I'm sorry, not you, from the family attorney who was speaking to the media, because I thought that was a significant source of bias.
And then you asked him,
He has pinned that interview that none of us have ever heard of as a significant source of bias, and is using that interview as a significant source of bias. And we're at over 5,000 votes. 98% of you have not seen that interview and like not been served that interview. So it's interesting that that is something that he is really leaning into in this case, because the media coverage of this case has really slowed down. There are stories like the day that it's in court, and that's about it.
what was the media source
Of that item
of that item?
only. Now, it could be two things because it was published in the newspaper, but the quote came from him.
And 23 people responded, and 3 of those 23 got their information from the park record, correct?
Yeah, which that's possible. I mean, it was published in the park record.
And 3 got that information from the defendant, her mother, and her boyfriend?
Her mother, boyfriend, and Kouri. Yep. And that's, again, I don't know. It's possible that that's was some connection to that in an article as well. They might have referenced that. I don't know.
Your media analysis, I'm right, you've already said it didn't include 48 Hours, Good Morning America, People Magazine. The defense filings, did it include the statements published in the media by the defendant, Ms. Richins' former counsel?
Yeah, there's articles obviously in the newspaper when she was the attorney. Is that what you're referencing? Or
Where, sir, do you cite those in your analysis?
cite them? I mean, they're part of the articles that we included in our, it should be an exhibit, the articles that I reviewed.
Where do you cite that in your where do you quote those articles in your affidavit? Where do you consider and analyze those articles in your affidavit?
I didn't quote them.
It seems that the prosecution is trying to get after the statements by this expert that the media coverage has been one-sided. And it seems to be that that's where he's saying, but what about if you're analyzing this and saying it's incredibly biased, one-sided coverage? Excuse me, what about all this other coverage? So I think that's where the state's going with these questions.
Where do you analyze them?
They're analyzing the qualitative review of, is the media coverage overly prejudicial or not?
But not analyzed in writing in your affidavit.
No.
You're familiar, of course, with the interviews that the defendant's family has given the media?
Yeah, that's part of, we didn't get to it, but that's part of the presentation I had, looking at some of the things that were positive things that she had put out. So there's negative media coverage, and then there's attempts to kind of balance it out. You can see the reaction, one, how few people viewed that stuff, and the negative reaction, the comments people made when that was done. So it certainly didn't balance it. And you can look at the survey data and see the overwhelming opinion of her is negative, not positive.
Where in your written affidavit do you discuss that and analyze that?
The it's in the survey report. What is your opinion of Kouri Richins from very negative to very positive, and then the 3 words you'd use to describe her?
Let me ask a better question. Where in your affidavit do you address in writing the defendant's family's interviews?
I don't. There's a lot of articles and things I don't address when I do that at this section. I don't write out every single article in every single TV episode and every radio story and every podcast and every episode of court TV that references the case.
He's
Well, more to the point,
asking
Doctor, you
if it's balanced.
analyze all media coverage or much of the media coverage that's negative about.
I didn't say,
The
well, I
defendant.
told you I did a conservative analysis. I believe there's another
Doctor, if you'd wait for the rest of the question.
Sure.
But it's true that in your written affidavit, you did not analyze in writing.
I want to see Mr. Bloodworth as well. So I am bummed that we do not have a broader view of the courtroom. I actually miss the Idaho 3 cameras set up in the courtroom. And I hope that maybe Utah would consider a similar setup to Idaho, because then they have control of the cameras. And it's been working really, really well in Idaho.
Any of the negative media, or rather any of the favorable media coverage.
Sure. Okay.
Mr. Bloodworth, we can move on.
The court's like, I get it.
Your Honor, I appreciate it. I will, because
He's
you're
trying to make a
me to,
record.
But
He
I
wanted to
think
make a
everyone
record.
here is where we're making a record, not only for this court, but others as well.
Yeah, I think the bigger point is that as between Dr. Edelman and me, I have a better recollection of the media coverage en masse of this case.
I don't dispute that, Your Honor. Thank you.
The court said, I have a grasp of the media coverage in this case. I get it.
You address in your media analysis defense or state filings, our filings in this matter, but not defense filings. Is that accurate?
I'm sorry, I'm not following you. What do you mean? I address it in
In your written affidavit,
the state's filing?
you address various states' filings in the case.
It really does seem, not only are the microphones deep fried, but it seems that in the courtroom, they are having a difficult time hearing Mr. Bloodworth, because even the defense attorney commented on it earlier. I don't know what in the Mercury retrograde is happening in this court, but the communication is all fucking over the place. And so the witness is, I think, struggling to hear Mr. Bloodworth, and then the microphones are, and our team cleaned up the audio. This is better than it was. So it's hard.
On the rec, yeah, absolutely.
But you don't address any defense filings, do you?
I didn't run across any defense filing that was balanced out what was in the state filing. I'm not quite sure. It seemed to me a lot of it was responding to what was out there on the state side.
So are you familiar that the defense has filed 3 times for sanctions against the state in this case?
To do what? I'm sorry.
Are you aware that the defense has filed 3 times against the state for sanctions in this case?
Sure. That's not,
Yes, sir.
yes.
But you did not include that, and you did not find that.
No, I don't think that's significant.
Are you aware that the defense has moved to disqualify the state in this case?
Again, I don't think that's significant. People don't mention it when you ask what they've read, seen, or heard about the case. That's not significant, and it doesn't balance out.
Mr. Bloodworth is like, but what about me? Have they talked about me? Have they talked about the state in this case? What about us? Mr. Bloodworth, we talk about you. Every law nerd on the internet talks about you. I mean, some of it is just the last name. Some of it is the very, very low-key snark that we appreciate. The writing that was snappy. The choice to include different portions of jail calls. We're here for it. So we talk about you, Mr. Bloodworth. Don't worry. We talk about it.
Specific details in terms of guilt.
We can keep moving.
He's like, the expert's like, that's not what I'm testing for. And Bloodworth is
So
like,
can we
wait,
turn briefly to the telephone survey?
Bloodworth is like, but you're only looking at negative media coverage, because that's the direction that this is going in.
Earlier that the the state in its survey judged recognition on Kouri Richins' name.
One of the questions, yes.
What was the other question?
Embedded in 6 other stories about the Olympics and so on was a question about this case.
Wasn't the screening question there was 2 screening questions, right? One, Kouri Richins' name, and then 2, a case involving a lady who allegedly murdered her husband and wrote a children's book about it.
Right.
Correct?
After, again, 9 names and then a blend of 6 stories that's in there.
So your survey was designed to assess case recognition, familiarity, and prejudicial media content and bias. Is that right?
Bias.
I would say it's designed to measure the impact of pretrial publicity on prospective jurors, case recognition, and the impact on the presumption of innocence.
So if on page 1 of your affidavit you wrote, surveys was designed to assess case recognition, familiarity with prejudicial media content and bias.
Okay.
Is that accurate?
I think that fits in what I just said. Yes.
Okay.
Am I right then that it was not designed to assess media content favorable to the defendant?
There's open-ended questions. What have you read, seen, or heard about the case? If somebody had favorable media coverage, they would have mentioned it if they remembered it. And there's research on this, and it shows that favorable pretrial publicity is not as impactful as negative pretrial publicity. Some of the most impactful pretrial publicity is negative character evidence.
I'm not pausing because he's wrong, but I think that is true in the media landscape with everything. You go back to if it bleeds, it leads. Like the negative, sensational, rage baity, clickbaity, that is what drives a lot of attention and thus now drives algorithms. But that's not just criminal cases. That's literally everything. And I think our brain has a whole lot of bias towards danger. And I'm sure there are tons of studies on how our brain has evolved and how humans have evolved, and, going all the way back to run away or not run away. We look at the negative first. So yeah, that is true about everything. We're trying to push back on it. We're look, it's what I do here. We're trying to bring the facts, not fuckery. We do not cutesy name the cases. We do not lead with sensational details of a case. In fact, a lot of the coverage, when there are cases with really graphic details, we downplay them out. But it's true for everything.
But you agree there is some impact of favorable
There is some.
publicity. And you agree that it does have an offsetting factor to prejudicial publicity.
I'm sorry, say it again?
You agree that to some measure it offsets prejudicial.
No, it doesn't.
Never, ever, ever.
I don't think the standard is never, ever, ever. I don't think any answer to any question is never, ever, ever.
We can keep moving.
This is fascinating. I'm also burnt out on the clickbait and the rage bait. I'm not on social a ton. I'm also exhausted by it, like you guys are. I hate it. I just want to know. Can you tell me what happened?
Significant amount of time addressing Mr. Scortis in your affidavit.
So that's where I'm at.
Yes.
Just tell me.
Why didn't you address any of the defendant's various spokespeople?
I did. It's in the presentation, but we didn't go through it.
But it's not in your affidavit?
Correct.
Originally,
You referenced the gag order in your affidavit?
I guarantee that someone in this courtroom has probably named the plant. I imagine the court staff have named the plant, and we'll get there. I'm sure someone has named the plant.
David, what is your understanding of the gag order?
From my experience, the gag order would be everything, you can't speak to the media.
Dr. Edelman, what is your understanding, if any, of the gag order in this case?
I'm assuming it's that you can't speak to the media.
Do you have a understanding of the gag order that was issued in this case?
Not at the moment. I'm sure I read about it.
The court's
time
like,
in the newspaper.
I'm not
coverage.
asking you to guess. Do you know about the gag order in this case? Yes or no?
You reference how the prosecution has not filed
The court doesn't want
documents
or need any of
very
this
often
information.
under seal.
The court's like, I get it. And the prosecution's like, I'm making a record because reasons. And the court's just like, bro, can we not?
Do you have an understanding of the rules in this case when the prosecution can file documents under seal?
Mr. Bloodworth, we can keep going. I understand the dynamics at play there.
Court's like, can we move it? Can we move it? I like to move it. The court's like, Mr. Bloodworth, I got you. I don't care
So
what this
you
expert
write,
said about the prosecution.
On the first
Move it
page of
along.
your written affidavit, based on my analysis, it is my opinion that the Summit County jury pool has been exposed to prejudicial publicity, right?
Absolutely.
Would you agree that based on your results showing that 300 of 1,500 summons have not heard about the case, it's not the entire Summit County jury pool, right?
I don't know because there's new media coverage since they filled out that questionnaire. So, like I told you, I already watched one that was a 46-minute long.
Not much.
I think, did I understand your answer earlier, that notwithstanding changes in the environment or additional
The judge is
coverage
like-
since you performed your survey, sure, that would be your expectation. Sure. Okay.
So you'll agree the math extrapolates out to approximately 6,400 of 32,000 approximate Summit County jurors who
Sure.
have not heard of the case.
Sure.
So I don't have anything further. Thank you.
Thank you, Mr.
I just
Bloodworth.
noticed. Any additional questions for Dr. Edelman?
Real briefly.
The judge is like, any other questions?
Do you
Just-
need to reconnect that, Mr. Ramos? Of course.
I appreciate
Yeah, no problem.
the court so much.
Once you're connected, Mr. Ramos will republish that.
Mr. Ramos is the defense kind of junior attorney, tech attorney. There was a day when the defense team is like, no, we don't feed Mr. Ramos. And I was like, what the fuck is happening? It was kind of fun to see the defense attorneys bantering amongst the defense team. I
just want to review one of the slides.
I don't want to review the PowerPoint.
I apologize for being slow.
Your Honor, you don't need to apologize for anything except these microphones.
Alex, would you do me a favor? Unplug that for a moment. I apologize.
Well, that's how you fix it. You unplug it and you plug it back in. Also, the microphones are not within the court's
Here's-
control.
Yeah, plug it in. It's not a glitch-free system. We lost table 2.
Everything in court.
Well, we haven't been on all day.
Oh, well,
It's
that's also
It's not a
important.
glitch-free system.
We're back.
Your
Okay.
Honor, I got you.
The slide earlier about the positive pretrial publicity in this case. You
Oh,
recall that slide?
Yes.
And what was it that you found?
yeah,
in
apparently
terms
his
of
mic
positive
wasn't on.
publicity?
There were two things.
I need to
One
Fix my
was
chat.
a-
Chatting.
I think she did like a interview or something she sent to a television station or news station. It was just a voiceover.
A statement.
That
Yep. Kouri gave an interview on the phone to some media outlet from jail.
in this story.
And that was the statement that was sent out between attorneys. Do you recall
No,
that?
Yes.
that's not the same, counsel.
And
There were
what was the
two.
other?
I think
I'm trying to
counsel
remember what the other
downplayed
one
that.
was without seeing it.
Ms. Lewis,
Kouri gave a statement.
notwithstanding Mr. Bloodworth's cross-examination, I don't think there is a credible argument that the media coverage in this case has been complete, wholly accurate, or balanced. I think we can move on.
All right.
We know how he feels about the media.
I've been on record with my concerns about it.
Correct. I don't know if I
Didn't
have
suddenly get religion.
Can I just make the point as
Is he talking about the media? I've been on the record about my concerns with the media coverage of this case. It didn't suddenly get religion. This judge is like, y'all need Jesus. What is I'm not mad at it. Your Honor, you and Judge H would get along chatting about the media and gumbo. I'm going to back him up because this judge is hilarious.
Without seeing it.
Ms. Lewis, notwithstanding Mr. Bloodworth's cross-examination, I don't think there is a credible argument that the media coverage in this case has been complete, wholly accurate, or balanced. I think we can move on.
all right.
I've been on record with my concerns about it.
Correct. I don't know if I
Didn't
have
suddenly get religion.
Can I just make the point as to just one more point on that? And I'll finish. How many on the slide, and I don't know if you recall, how many people viewed that story compared to
It was
all
like
the other stories?
2,000, 2.1 or something like that.
Viewed the positive coverage. All right. I don't think I have anything. Just one moment.
And again, I don't like characterizing it as positive versus negative coverage, but I'm not the one doing these surveys. I think accurate coverage is what we're going for. But again, I think they're looking at a scale of positive and negative about whether the coverage creates an impression that she's guilty versus creates an impression that she's not, or creates a negative impression of Kouri Richins as a person. I think that's what they're going with negative versus positive. But whenever somebody's on trial for murder, I think overwhelmingly, that fact causes a bit of concern because murder. So you don't often get a circumstance, and there are circumstances, but you don't often get a circumstance where it is overwhelmingly positive.
Yes, sir.
Thank you for your time, sir. You're welcome.
All right. And we're done with
Counsel, may we take a restroom break before proceeding?
Yes.
Okay.
The
We will
court-
take a 10-minute break back at 11:45.
I'm
Thank
so sad that the judge didn't say I don't have a diaper. Can we take a 10 to use the restroom, because apparently only the expert's wearing a diaper today. All right, let's get back onto the record after the break. There's going to be time for argument.
Lewis, any record in 2-3 back on the record?
All right.
Yes.
Okay. We're back on the record in 231-500-139. Ms. Lewis, any other evidence that you wanted to put into the record?
No. We don't need to
on the
super
motion
zoom.
to change venue?
I mean,
No,
we like
no.
this judge,
Okay.
but
Mr. Bloodworth, is the state calling any witnesses or admitting any evidence? In addition to the stuff that's been filed?
No, Your Honor.
I agree with y'all about the judge's
Ms.
posture.
Lewis, it's defendant's motion. You're
I am
entitled
jealous.
to the first and last word. Any argument that you want to
Yes.
put on the record?
So we have now moved to, the court has all the moving papers. We are now moving to argument on the change of venue motion. The court is taking in the surveys from both the state and the defense, and the attorneys will get to argue. This is the defense motion to change venue, so the attorneys will get to argue their motion to change venue. I'm going to just wait for counsel to start.
That's not what this is about.
All right.
A change of venue motion isn't a numbers game. That's not what this is about. All right. That's why when we're looking here at the standard, is there a reasonable likelihood that she can get a fair trial in Summit County? And the survey that the defendant has submitted shows that there is not a reasonable likelihood that she can get a fair trial. The number of people in this county that are aware of the case, the number of people who know prejudicial details that have been out in the media, and the number of people who indicated rumors and speculation about the case that are not accurate in any sense,
I'm trying not to cover up
is
the judge's face. There we go.
extremely high compared to Salt Lake County.
This
Where
is
would you say
defense
the,
argument.
the breakover point? This is something that I struggled with.
Well, I think we're talking about, when we're looking at the two counties, let me just say, we picked Salt Lake County because it's convenient. It's 28 miles. When we're talking about the gravity of what Ms. Richins is facing here, and to find a jury that does not have the knowledge of the case that Summit County has,
That's not even the lawyer that's talking.
taking that 28 miles is absolutely reasonable under the circumstances to avoid what potentially, and more than potentially, what based on the numbers, not the numbers, but based on the survey and the response to the survey, shows that there's a reasonable likelihood, which is not a very high standard, that she can't get a fair trial here.
The defense is arguing it's not a numbers game because it doesn't just go to the percentages in the survey. The defense is asking the court to consider things beyond that, like what is known, how much is known. Don't just look at the numbers and say, well, they're comparable, therefore it doesn't matter. She's asking the court to go beyond just what the numbers in the survey say.
Survey says.
Now, could we go to a different county? Yes. Could we go to Washington County? Maybe in Washington County, probably in Washington County, the recognition rates
Belinda,
could be
I'm
lower
going
than
to
Salt
answer
Lake
that in a
County.
bit. I'm holding on to
Probably,
that. That's a good
and we
question.
could do that. But in determining where to hold a trial, it makes sense to look at the convenience of everybody who's involved. And I'm going to segue a little bit, and I don't think I need to spend time on this because I'm sure you know this. You asked us what we wanted to do, move the county to Salt Lake or bring Salt Lake jurors here. It doesn't really matter as far as the defense is concerned. It was not our position that we want to bring it here because we don't want her to be in Salt Lake County Jail during the trial. If she's in Salt Lake County Jail during the trial, that's fine. But we have chosen all along to try and pick what is most convenient for everyone involved in this trial.
That's fair.
We did that when we had a stipulation with the
I think it's fair of the defense to say we are not necessarily looking at having to move the trial to a different courtroom in Salt Lake. We are happy to bring Salt Lake jurors here. And the defense and the prosecution had agreed on that earlier on. Early on in the case, when they were arguing over voir dire, both sides said, Your Honor, can we just expand the jury pool and pull jurors in from Salt Lake County? And the court said, I think that we are able to accommodate that. And then the site judges said, negative, Ghost Rider, the pattern is full. And then that went up to the state Supreme Court, and the state Supreme Court said, we're not helping you out with that. You need to pull jurors from the county where you are. And that's why the change of venue motion was then brought. But the attorneys had all agreed on expanding the jury pool beyond just Summit County. And it was the powers that be that said, we're not doing that. And I understand most states do have rules about how far you can bring jurors in from, like miles wise, not as the crow flies. But if there's a change of venue, there's two options: move the whole case down to Salt Lake or bring Salt Lake jurors up to Summit County. And that's what everyone had agreed to in the first place. So we might end up with the net same result.
The government or the state. And that is why we're going to Salt. That's why we're looking at Salt Lake County. I don't think there's a magic number. There's not a magic number in terms of where we can have a fair trial. For example, in the Coburger case that Dr. Edelman mentioned,
I don't think we've seen the attorney that's speaking yet today.
Between Ada County, which is where Boise is, and
I don't even know what she's wearing because we haven't seen her.
Leda County, I don't know, where Moscow is. The recognition.
Ma'am, I learned it's Latah County. Chat's got you. Chat's got you.
Was almost identical in terms of the number of people who recognized the case or
Koburger has entered the
case.
chat.
What we're looking at is we're looking at a large county, and Salt Lake County has 1.2, 1.3 million people. So out of those people, 42% recognize the case.
So she's arguing the
That
similarities
means that we
in
have a very
Idaho.
large number of people in Salt Lake County that did not recognize the case, as opposed to here, where we have a population of 42,000 people and 80% of them
sparkling
knew
rutabaga.
about the
This is
case.
my
And out
favorite
of those,
snack at the moment.
70% already believe she's
My
guilty.
favorite snack at the moment.
Let me engage with you on this for a minute. First, before I can get to the practicalities, I have to find
Give us
that
the
there's a
judge.
reasonable likelihood that Ms. Richins would not get a fair trial in Summit County.
Yes.
Among the there are 4 factors I am required to consider, and then I'm also required to consider the totality of the circumstances.
Yes.
One of the factors is the effect, nature, and extent of pretrial publicity. So let's discuss the numbers under that factor. Yes, there are 1.2 million people in Salt Lake County, but only 1,500 of them were summoned, and only 1,400 actually completed the questionnaire. So what we're really talking about is 1,400 people, and what percentage of those 1,400 have been exposed to information about the case. Is it the exposure or the nature of their connection or following of the media attention?
Well, I don't think we can look at one without the other. Exposure in and of itself is not a disqualifier. That's why the state survey is problematic, because they say, well, you could bring in 1,500 people, and conservatively, you're going to find 165 who haven't heard about the case.
Right.
That's not the point. We're not predicting.
If you can find 165 people that haven't heard about the case, then you can get a fair trial, because you can get between 12 and 18 out of, or less than that, because you don't get 12 on a non-capital case. So if you can find 165 people who've never heard of the case, theoretically, you could have an entire jury pool and an entire jury veneer. 140 would be a multi-day veneer of people who've never heard of the case.
This isn't a political poll. We're not predicting the number of jurors who know nothing about the case. And you can have jurors who have heard of the case. Yes, I've heard of that. Yeah, I'm aware she's charged with murder. That is not the same as having a large percent of the population who knows not just that, but also knows those specific factors about the case.
Right. So if we drill down there, in Summit County, it was only 1,100 out of the 15 summoned who completed the questionnaire. Okay. And if I understand Dr. Edelman's testimony and results correctly, 50% of the people who recognized the case followed the case not too closely or not at all.
Bing.
I don't think it was that high. But
I think if we add the two numbers together, it's exactly 50.1. 15%.
I don't think it's that number. He's like, let me correct myself. It was 50.1 when you add it all together. Do not mess with math, judge, because what he's saying is what we've learned is even if they heard of the case, 50% of the people that heard of the case, 50.1% of the people that heard of the case had heard very little about it and thus did not have an opinion.
1/5 of the 79.8 that are recognized the case followed it not at all. So there's 131 out of the 880 that follow it not at all.
So those numbers are the same.
About 440 of the 880 that follow it not too closely or not at all. Let's assume those numbers are roughly twice as large in Salt Lake County.
Does it matter?
In defendant's view, is that the signifier? Or is it other James factors that really matter here?
Well, I think it's all of them. That alone is not the signifier.
It's the feed,
it's
not me, not you, that's frozen.
I think what was important when we look at the other signifiers, particularly the standing of the victim in the community. In Salt Lake County, the familiarity with the Richins family was 3%.
Right. Up here, it's only 26, though.
26%
So they're looking at other
said
factors.
they were familiar with the family.
Right.
That's correct. But we also don't know here where our jury pool is going to come from. Now those numbers looked at all of Summit County. All right. Recognition in Park City is probably lower than recognition in the eastern part of the county.
You'd expect.
And so when we bring
Pull from Park City, bring in half of the housewives. That's all I'm saying. Unless Real Housewives of Salt Lake City is like Real Housewives of Beverly Hills, where they say they live in Beverly Hills, but they're really in Encino. But still, housewives on this jury. I'm just saying.
In these people, we don't know at this point what the balance of that is going to be. So if we get a large group of jurors from Camas and Colville and Hennifer, then we have concerns. We don't need to worry about that in Salt Lake County. In Salt Lake County, there's not going to be a stronger recognition in parts of the county as compared to other parts of the county, if that makes sense. So you could bring in a jury here. We know 26% of the county overall, based on the survey, said they had familiarity with the Richins.
Well, 26% of the 80%
Up
that
to
read,
about-
heard, or seen something
That's
about the
right.
case.
And we may have people who don't know about the case that
26%
likely
of the
do have people
80%
that don't
of
know
the-
about the case in Summit County that is familiar with the family, and we're going to get them in here. And those people are probably very likely there's going to be people disqualified who may not have known about the case, but may know about the family and then have concerns about being on the jury. And those numbers, I mean, we're looking at a picture here. We're looking at a picture with the survey. But when we bring in the actual jurors, if we have a large percentage from the parts of the county where the Richins are well known, those numbers are going to be higher. So we're taking a risk by having a Summit County jury that we're not going to be able to seat a fair and impartial jury. There's a reasonable likelihood that we can't, because we don't know exactly where those numbers are going to shake out. But we know in Summit County, they're going to be there. In Salt Lake County, we can get jurors from the east side, we can get jurors from the west side, we get jurors throughout the entire county, and we're not going to see, based on the numbers that we have right now, a huge difference, if any difference, for example, on that factor, the standing of the Richins in the community.
Do we have any evidence in the record that, but for the pretrial publicity, so put that aside,
Mhm.
that Kouri and Erik Richins, or Erik's side of the family, is any more well known in the county at large than,
Meredith Marks.
geez, we've done a lot of gnarly cases in this courtroom involving crimes against children, first
I'm
degree
not
felonies,
smiling
sexual
because
assault
he
cases,
did crimes against
all their
children. I'm
murder
smiling
cases.
at the use of gnarly in the courtroom because my West Coast cannot not. But he's like, we've done a lot of cases.
I'm not entirely sure what you're getting at, but
I guess what I'm saying is, I'm not sure these people have a standing in the community that is as great as you suggest. Wouldn't the number be substantially higher than 26%?
the Richins family are the biggest landowners in.
They're talking about whether other factors than pretrial publicity come into play here, including the societal standing or how well known the victim's family is. What's really interesting is that after watching the Murdaugh case, it's interesting watching them try to argue this. And the judge is pushing back, saying, I think you are over insinuating the prominence or how well known this particular family is in Summit County, vis-a-vis like the Murdaugh case, where I don't think there was a lot of argument about how well known the Murdaugh family was generationally where they were. So she's going to start to push back on what their land holdings might be, but I don't know if that connects to how known they are vis-a-vis like the Murdaugh case. And so this is going to the family that Kouri married into. I just have to wonder if the perceived standing of the Richins family by Kouri is something that she is pushing at her defense attorneys. Like, no, but we're like, first of all, this is the family you married into, but I wonder if some of this is coming from the defendant. That is just my curiosity on this.
The southeastern part of the county.
So I'm gonna back up. She is saying the Richins family are massive landowners, and yes, Danita said Murdaugh had to take his grandfather's picture down in the courthouse, and I think just to be regionally appropriate, his granddaddy was in the courthouse. Photos of his granddaddy, and I think his great granddaddy were in the courthouse. It's not the same. It's not the same. And that's no shade to the Richins family. It's just the defense is trying to make it more than it is to move this out of Summit County, which might negatively impact the Richins family from being able to attend court. So Grandpappy, I think that's fair too. Tony said Murdaugh's Grandpappy was on the wall. Yep. It's not the same.
You suggest, wouldn't the number be substantially higher than 26%?
The Richins family are the biggest landowners in the southeastern part of the county.
Well, one of the Summit County Council members owes like an entire chunk of Echo Canyon, but like I'm not sure he's that well known outside from his former Summit County Council members.
Well, we don't know.
I mean,
all we need
here, we'll take it outside the Richins family.
The court's like, people own shit. Weird.
If an Osgothorpe was
Utah folks, what's he talking about? Utahians, I need some help. What did the court just say? I'm going to back it up. What did he say?
Well, we don't know.
I need help translating Utah shit.
Here, we'll take it outside the Richins family. If an Osgothorpe was either a victim or not, I mean, there's a barn named after them on 224, but that doesn't mean that people know the family in a way that would disqualify them.
I don't
right?
think he said Osmond.
I don't know.
I think he said Osgothorpe.
Okay, I appreciate it.
Oscorp. We just take it back into pop culture. Oscorp. It's just Oscorp. I have no idea what he's talking about, but there's a barn on 224. So what barn are we talking about? Help.
That was really my question is, do we know one way or the other? And
we do know that the Richins have part of the library named after them. We do know that
we know all Richins does.
Well, there was no denial that it was this Richins family in the affidavit. I feel pretty confident if it were a different Richins family, that would have been included.
Okay, but I mean, geez, whatever. I understand your position, but
okay.
More generally, I spent hours upon hours trying to figure out the through line through the change of venue cases.
Thanks, Jay.
And determine where district courts go wrong in denying a motion to change venue. And let me ask you about this. It seems that there needs to be an inflammatory plus factor that goes beyond adverse pretrial publicity. In James, it was the 45 days of community involvement searching for the missing infant.
That's fair.
And during that time that occurs immediately after the infant goes missing, the media coverage starts to turn on the defendant before he's even charged.
That's fair. Because in Kohberger, when the court's talking about a plus factor, in Kohberger, and the expert talked about this, in Kohberger, part of that factor is how many people are connected to the university, are connected to the 4 victims, are connected to the location of the crime, past the location of the crime daily. That was part of it. And I think one of the bigger factors that the expert didn't mention that was argued quite a lot that I thought was a very good point in the Kohberger case was the relative fear and stress of the community in the 6 weeks between the crime and somebody being arrested. And that visceral feeling in the community adds that plus factor. And the court's talking about a different case where the community was involved in searching for the victim leading up to it. That can be a visceral remembrance of the community. So when he's looking at the kind of plus, what is the plus in this case vis-a-vis some of the other cases we've seen? I appreciate the court's thoroughness, but what is the through line here?
A case that whose name I can't remember, the crime was alleged to have occurred in the courthouse. And so there the judge was concerned that we can't have potential jurors or impaneled jurors interacting with the crime scene every day of the trial. In Stubbs, for whatever reason, the judge only summoned 16 jurors for a venire, and 9 of them knew the
What?
family. So that
Veneer. I don't care if I'm wrong. I will die on this hill. Veneer. Who only summons 16 juries? Who summons 16? That's wild.
is an outlier. But then we look at
I love doing case review with the court right now.
Care, Lafferty, Bishop. In Bishop, they had a
This is
survey.
a case law.
71% of those people that, pardon me, 80% of the respondents said they believed the defendant to be guilty. No abuse of discretion. What do you see as the through line or the place where a district court commits a reversible error?
Let me first address. There are almost no cases that are using the reasonable likelihood standard because all of these cases, Bishop, Lafferty, they weren't interlocutory appeals. The standard had changed. By that time, that
That's a good
wasn't the
argument for the
standard
defense.
anymore. And the court has to look at it from was there
That's a
actual
good
prejudice at
distinguishing
that point.
argument.
James is the only case I came across.
Stubbs, right?
And no, Stubbs was post-conviction and it said they applied the wrong standard.
Yeah, I think the Court of Appeals, though, says we're going to apply the James factors. And then the Supreme Court says, well, you did it wrong, but even though you did it wrong, your result was correct.
In the middle of the
But
sentence.
so if we look at the Court of Appeals decision in Stubbs, they applied the James factors afterwards. Your point is well taken.
Well,
I think it
that's
is a
major
fair
difference.
distinction.
We don't have a lot of data out there, but changes of venue occur constantly, and not all of them are, the O.J. Simpson case. They're not all, the level.
Missy, Eric, we will talk about where things are in the Reed case in a bit. But summoning 16 as you are looking for alternates is not wild because hundreds of jurors have been summoned in the Reed case. Summoning 16 total period for a full jury is bananas. But if you look at the Reed case, hundreds of jurors have been summoned to fill out the panel. So day over day, you are getting summonses. So hopefully that helps with the difference there.
Of prejudice that maybe was in the James case. There's nothing that says that the media coverage, the negative coverage has to be at a certain level. It only has to be at a level that there's a reasonable likelihood that the defendant cannot get a fair trial. So I don't think there's a magic cutoff. There's not a point where it has to be this
Well, the
extreme where
court
you
said
don't
there's a
get
plus
it. Where we
and
have
is asking for the
a
plus.
number of factors out there in the media that some of them may not even be admissible once we get to trial, but they are in people's heads. We've got the walk the dog letter. We've got the financial motive.
Docket
We have
214.
the paramour, which was something that was a term that was Greg Skordas put out there. And we have
No, it's not.
we
The paramour term was put out there in filings in court. It wasn't that someone else latched onto that term and started saying paramour because they missed the prominence of music in the 90s and early 2000s. It's because that's what was referenced in court filings. It's a great use of word.
we can't ignore Mr. Skordas. We can't, because he is respected in the community. He is a spokesperson for KSL, which is the #1 watched news station in the entire state. And we have someone out there who's a commentator who now is out speaking against our client. Now, the difference between that and Salt Lake is in Salt Lake, people don't care as much. They're not paying as much attention.
Right.
And that's why Salt Lake is an appropriate place to have this. We're not saying that there has to be zero knowledge of the case. We're not saying that. What we're saying
The
is,
defense is real
is
upset
the
with
jury
somebody.
so connected to the case? Is there such a community awareness or a community concern that they are paying attention to all of these negative factors? And here, it's clear from the survey that they are, that at least to a much larger degree than they are in Salt Lake County. You keep going back to the numbers. Well, there's still this many that haven't, this many that hasn't. That doesn't matter. We could always say that. There's always a number of people, a sufficient number that you could probably find 12 people who could be fair. That's not
24.
that's not what the standard is here. It's not. And under a reasonable likelihood standard, and the fact that it is so easy to avoid this issue in this case, so easy.
I can't consider that though until I make the first decision, right?
Right.
Because if I make the first decision, it doesn't matter how easy or difficult it is.
Right.
It's required.
Right.
That is correct.
There are two steps.
You're right. It's just, you're right. It's hard to separate those out because we are in a situation where this is an easy fix. And I
think
do.
it's one of the judges, it wasn't in James, was it Stubbs, that the judge commented it would be super easy for me to just grant the motion.
To bring another jury into the county.
Yeah.
Yes.
It's easier
Which we still think you can do, but
to do
it's
that.
neither here nor there because either way works.
Yes, I'm singing two-step.
And I lost my train of thought.
I apologize for interrupting.
That's okay.
That's the feed frozen, not you.
So I understand your position regarding standing in the community.
Okay.
I mean, the size number is what it is.
It is what it is, and it's small.
Yeah. No,
It's a small-
you're right.
It's a small community. And the gravity of the offense, all right, it's not
Julia, I did a summary earlier on in stream after the intro, and we do have a playlist about it, and I do have some quick bits about it, but I did an intro at the beginning of stream, and then in the description, there is a very, 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 very brief overview about the case. So those are there for you, but this is a motion to change venue, so we're pretty far down the road.
death penalty case. But other than that, it's they're
You'd acknowledge doesn't include a child victim, no sexual violence, right? That seems to be notwithstanding the distinction you made on the reasonable likelihood standard, that seems to be a dividing line between cases. Adult victims.
in James. It is. That's
It's-
true. I don't think
And in
that's
Stubbs.
true in
Well, the James factors are what the court's
Stubbs, though,
applying.
they really focused on other issues. But
Yeah, but it means 17-year-old high school student, rape victim.
Different. It's different.
I mean, I have a hard time addressing that because I do think a homicide is equally as prejudicial and the gravity of
It
the
should
offense
be.
as a
Victims are
17-year-old rape
victims,
victim. I don't
however.
really balance that factor out. I think one is as serious as the other.
Communities sometimes
I-
see younger victims differently.
That is a good faith position that the Utah Court of Appeals seems to differ on, but I agree. I understand.
I think, and honestly, would you say, and of course this is just speculation, most of these really high publicity cases deal with children victims. That's very common.
Right.
That's what gets the high publicity. That's just not the situation.
And it enrages people.
And then we come
Differently.
to the fourth factor, the nature and extent of the publicity. Okay.
Which I think we've spent a lot of time talking
Nature and
about.
extent of
It's
the publicity, the
permeated
court's like,
every single hearing in this courtroom.
Fuck the media.
It's been out there since day one. I talk about in my motion the number of stories that came out the week she was arrested. Now, it's different than James because the community didn't know that this was being looked at as a murder until the arrest. So it makes sense that the publicity didn't start until her arrest. But if you look at the articles that came out within the first 3 to 5 days, I think is what I've listed, maybe it's the first 7 days, it was immediate, it was prejudicial, and it was all over the news. I think the fact that Dr. Edelman focused on a conservative focus on the Park record is meaningless because we know it's all over the news. We know that there's national media, but the national media, the point is 48 hours, or I think it was 48 hours,
She was
People
arrested.
magazine. Yes, it's
2 years
everywhere,
ago
but
now.
it's people in this community that are the most interested in this story. So
With most
those are the
cases.
people that are the most focused.
With most cases, the most intense interest in the case is local. If something happens in the community, in locations that with people that or you might know, or your kids might play soccer, the same with the victims' kids. It's different. Local communities are always the most invested, even if other people are invested. I think maybe the only time the local community wasn't as invested is maybe Depp Heard, because that was legal maneuvering to have that case in Virginia, not in Los Angeles. And it wasn't a criminal case, it was a civil case. But when you're dealing with crimes that happen in the community, the regional interest is high, very high. So,
Or a greater percentage of people in this
Yeah.
county follow it closely.
I mean, yeah, it's the same thing. I mean, you can say it either way, but there's a much greater interest here
My chair
than there
smiling.
is 30 miles from here. It's just the nature of the beast when you're dealing with this small of community. So I think the 4 factors in James are very, very clearly met here. Are they, is it a sensational story where a child was, found dead outside the courthouse? No, it's not that story, but it doesn't have to be that story for there to be a reasonable likelihood that she cannot get a fair trial here.
I
Okay.
understand your position.
I
You'll
don't
get
think
the
I have
last
anything
word.
else, but let me just double check. I think just in closing, and maybe I've said this, but there's not a perfect answer here. There's not a perfect jury pool. That's true no matter in any case. No, we're not looking for a perfect jury pool. We're looking for a jury pool where
Well, you're
she
never gonna
has a
find
chance of
A
having
perfect jury
a
pool.
fair trial. And in this
Humans.
county, there's a reasonable chance that that's just not going to happen.
I appreciate that. Mr. Blood.
Mr. Bloodworth. Mr. Bloodworth is the prosecutor in this case, or the lead prosecutor in this case.
Your Honor, can we start as a matter of law? It's my understanding, and I've seen no writing that says otherwise, that the request for relief, the relief requested, is to bring a Salt Lake County jury into Summit County.
That was the flag in the sand made by Mr. Ramos following my frustration with the ambiguity in the motion filed by defense. I'm happy to give you a ruling about my authority to do that.
Your Honor, as the state has briefed, the state doesn't think you have the authority to
You
do
were
that.
quite clear about that in writing.
Okay.
Do you want to address that now?
Yes, sir. Seems like a good place to start.
Anything you want to add on that?
I love the back and forth between the prosecutor and the judge. The prosecutor's like, I don't think the court has the authority for that. He's like, you've made that perfectly clear. But should we start there? He's like, well, sir, maybe we should start there. Can you, in fact, do that? Or can you not, in fact, do that? And it's just so collegial. It's like, you've made very clear you don't think that I can. I think that I can. I just enjoy the courtroom decorum so much. Your Honor, I apologize for that pause. That's
I'm happy to give you a ruling about my authority to
that's
do that.
my bad. The court.
Your Honor, as
I
the
sure
state
the
has
fuck can.
briefed, the state doesn't think you have the authority.
You were quite clear about that in writing.
Okay.
Do you want to address that now?
Should we just hash it
Yes,
out?
sir. Seems like a good place to start.
Anything you want to add on that?
I want to answer your questions to the extent you have them.
I understand the state's position. I'm just not persuaded by it as a matter of law for reasons that I can explain in a moment.
Court, Ipsy Dixit. Yes, I can. Haha.
Notwithstanding
Wait.
that the court may summon jurors from only one county.
Where? Oh, it didn't say. Wait, no.
Respect my authority!
You're welcome, Chad. Tony said it before I could find my new button. Chat, we're on the same page.
If the court determines a fair and impartial trial cannot be had in the county where the action is pending, and that's an if that is as yet unresolved, the court may summon a jury from another county. You're on record. You've created a record. I don't know if there's anything you want to add on that.
No, Your Honor, I don't have anything to add to the written record. I appreciate that you are citing a conflict in the jury and witness, in the language of the Jury and Witness Act.
Yeah, let's just do this now, recognizing that I'm not sure it's relevant yet.
Okay, we're doing this. Do it.
Should it become relevant? Do it. The court determines that it does have the authority to pull jurors from another county following the granting of a motion to change venue under Rule of Criminal Procedure 29. Granted, under Utah Code 78B 7-107 subsection 2, quote, prospective jurors shall be randomly selected from the county in which the trial will be held, end quote. That language was added in 2017 by State Bill 169. Senate Bill, 169. Senator Hilliard and Rick Schwirmer, the state court administrator at the time, spoke to the bill during committee hearings and stated this bill does not do anything substantive. It's just cleanup and technical changes, no policy changes. Then Utah Rule of Criminal Procedure 29C1A states, if a party believes that a fair and impartial trial cannot be had in the court location or in the county where the action is pending, that party may move to have the trial of the case take place with a jury from another county or the case transferred to a court location in a county where a fair trial may be held. That rule was last amended by the Utah Supreme Court in 2018. That is after the language in section 107 subsection 2 was added. And the provision regarding, quote, a jury from another county, end quote, was left in place by the Utah Supreme Court. This circumstance indicates that the Utah Supreme Court did not consider Rule 29C1A to be in conflict with section 107 subsection 2. Moreover, in 2023, the legislature repealed 78B 3309, which was a statute providing that the court may on motion change the place of trial in the following cases, among other circumstances, when there is reason to believe that an impartial trial cannot be had in the county, city, or precinct designated in the complaint. Currently, 78B 3A 103 speaks to venue for civil actions, as stating that a court may transfer venue in accordance with Rule 42 of the Utah Rules of Civil Procedure. But the 2023 repeal of 78B 3309 left Utah Rule of Criminal Procedure 29 as the standard for transfer of venue in criminal actions. Right. Considering the foregoing as a whole, the court rules that Utah Code 78B 107 subsection 2, Utah Rule of Criminal Procedure 29C, and the Utah Supreme Court's recent memorandum decision in this matter, upholding the court's determination that it can pull a jury from only one county. Those three things do not conflict.
And that's the difference.
Therefore, the court rules as a matter of law that notwithstanding that the court may summon jurors from only one county, if the court determines a fair and impartial trial cannot be had in the county where the action is pending, the court may summon a jury from another county. I'm more concerned with the if at the moment.
He's so happy. He's like, anything else? For all of you in the chat that are like, ooh, I am now fascinated by people reading me Utah code sections. No, you're not. No, you're not. It's just this judge. It's just this judge. You are not that fascinated. It's just him. I get it. But he's just like, we've answered that. We're done. I can do it. Here's the distinction that is important from what happened earlier in the case. Earlier in the case, the prosecution and defense agreed to try to expand the jury pool and pull them from Utah County in addition to Summit County. And the Supreme Court said, as the court just said, you can't mix them. You can pull from one county, but that doesn't prevent the judge, if a change of venue is granted, from bringing a jury pool from the new venue to the courthouse in Summit County. So grabbing a jury pool from Salt Lake City and bringing them to Summit versus shipping the defendant and all the witnesses and attorneys and everybody down to Salt Lake County. Does that make sense? So the judge is just like, we good. Anything else? Hold on, one more time.
Respect my authority!
That is settled.
Talk to me about that part.
Your Honor,
Talk to me,
the
Goose.
analysis is James. It's not whether or not there's publicity. I think everybody acknowledges to varying degrees that there is publicity. And well, I guess everybody acknowledges there's publicity, and everybody acknowledges to varying degrees the harm that that publicity may have upon a jury pool.
Brad,
The defense is like, Brad, I still can't hear you.
it's really hard to hear from behind you.
I'm sorry. I don't know why it's quieter today.
I don't know either, Brad. The mics
I
were
can-
deep fried over the weekend.
Would you
I'll
like
get a lapel.
the sure? Yeah.
I
One
can
more.
hear you if you're right there in the mic.
Nobody can hear Mr. Bloodworth today. And the rest of the mics
In all
are just
fairness, I think I'm kind of deaf in one ear, so that's fine.
defense
We
counsel's
have
like,
technology.
the judge is somebody, we have the technology. We can do it. Your Honor, could you get the technology to just have the cameras in the courtroom that you can control so you can stop fighting with the pool cameras? We would love that. Call Judge H
Wendy, does that work better?
or the court administrator.
Does the lapel mic work better? Wendy, does that?
The defense attorney who is saying, I can't hear Mr. Bloodworth, said, I might be kind of deaf in one ear. And the court said, Wendy, does that work better? Her response was, what?
Okay, is this better?
Wendy, does that work better?
Sorry, what?
Does the lapel mic work better?
It's fine.
Okay.
Go ahead, Brad. I was sorry. I was listening.
Will you put it on your tie? Tricks of the trade. There you go.
Okay.
Can you hear me now?
Please proceed.
So, Your Honor, it is all four of the James factors. It is not simply whether or not there's publicity and whether or not the publicity is on balance prejudicial. And the state acknowledges that, perhaps on balance it is prejudicial, but I think in fairness to, or, as the court evaluates Dr. Edelman's testimony, I think there is some offset. I think former defense counsel's presentation on 48 hours, the family interviews on 48 hours, the defendant's statements that got extraordinary media coverage nationally. I do think it does offset the otherwise predominantly
The court disagrees with you.
prejudicial coverage.
The court disagrees with you on that, but that's all right.
And I mentioned that here because, and we may discuss this later, I think the court should in some measure discount Dr. Edelman's testimony because he does bring to it a bias. I'm not saying it's a
We're just not going to see the attorney that's speaking today at all. But we do get to see counsel that's been speaking most of the day in her more camel-colored suit taking notes. But I feel like we've just been clocked. I don't know what happened, but the camera is moving. This is a TV camera in court, so there is a person sitting there moving the camera, which is why we've been clocked immediately. So I'll let it roll.
he does bring to it a bias. I'm not saying it's a dishonest bias or an intellectually dishonest bias, but he is an advocate. And his testimony from the affidavit through to today only really analyzed half of the media coverage. And I think that bias is probably reflected in his polling as well. And the court saw it, I think, acutely today when the court would ask a question and Dr. Edelman would pivot
Mr. Bloodworth makes a good point.
whatever he wanted to talk about in advocacy of the defendant. All right, back to James, I guess.
I hate that they're zoomed in on defense table while
Um,
counsel's talking.
And the point that publicity is only part of the analysis. It is, to some part, a numbers game. Not exclusively a numbers game, of course not. But I think we kind of start with the numbers. And if you look at the defense's polling out of 1,100 Summit County jurors that returned the questionnaire, approximately 2 of them have not 200 of them have not heard the case. And if you take that same measure with the state's polling data, it's approximately 400. So I think the court then needs to kind of look at whether or not, given somewhere between 200 and 400 summons jurors to fill 8+4 seats, whether or not through voir dire, we can select a fair and impartial jury.
Would you acknowledge, Mr. Bloodworth, that in some cases there seems to be an overriding concern that notwithstanding the potential numbers game, there's some inflammatory plus factor, the formation of an angry mob at some point in the pretrial period, community involvement
Like
was
a
heavily
literal
referenced
angry
in
mob.
James.
Wow.
You would acknowledge that there are cases where it's not a numbers game, it's the inflammatory plus factor that determines the issue.
Your Honor, I do acknowledge that, and that does not exist here. This case had no media coverage until the defendant went on a book tour on local media.
Your Honor, I know it's an argument, but he's stating things that aren't accurate. It had no coverage until she was arrested. That's when the media coverage started.
There was media coverage of the death of Erik Richins when she wrote a book about it. However, that's not media coverage of this case. It's media coverage of the defendant. But the defendant brought the media coverage of her when she went on local TV to promote a book about grief because she had lost her husband and sold the story about being a widowed mother to 2 young children and how she was navigating grief with her children. When she got arrested, part of the "are you fucking kidding me" is because she had been in the media talking about being a widowed mother to 2 young children and how she was navigating the grief with the children. It's part of why the media coverage when she got arrested was like, oh, fuck. What? So it's both. The children's book author was the lead line of most of those stories when she got arrested. That lead line wouldn't be there had she not sought out the media when she was promoting her book. So there's 2 parts of that. The media coverage of this case started when she was arrested because there was no case before she was arrested. There was an investigation. But the media of her was because of the book tour. And people still call it like the children's book author case, which I think is a disservice to children's book authors everywhere. So, and it also downplays the significance of what she's been accused of. So,
I'll get to that in a moment. I understand your objection.
Okay.
Your Honor, I point to the ABC article that
Maybe we can just
We'll say-
acknowledge that we've considered lots of murder cases in this courtroom, probably many more than the Summit County electorate realizes, because for some reason they did not get covered while this one did.
Your Honor, I'm not being clear. I mean, prior to arrest, the death of Erik Richins was not covered. And it wasn't covered because there's not that plus factor.
Or it was covered minimally and factually.
I mean,
In the
with what?
sense of an obituary
An
type of presentation, sure. But
Until the children's book
the
story.
community had no interest in Erik Richins' death until arrest.
It was an unfortunate death. And then she wrote a
that
book.
is an indicator that there isn't that plus factor that exists here. There wasn't a search, there wasn't a child, there wasn't something remarkably horrific that grabbed the community's attention.
I understand your position.
For those asking in the chat, the children are elementary school aged and they are with the victim's sister. I don't know their exact ages, and I'm not going to go look it up. I don't encourage it. I think the victim's family probably needs the least amount of attention that is possible
Anything
while
yet?
going through this case. So
I looked like you had a
elementary school age,
question a minute ago.
young children.
No. I mean, synthesizing the cases, the best I can do is to say pretrial publicity is a factor, but it's not the one that determines where the cases turn.
No, you're not. I think, no, it's not. I think you're accurate, Your Honor. I think the first James factor breaks in favor of the state. I think they were the defendant and Erik Richins had similar community standing. I think that.
Would you state, it seems that they had similar community standing to each other and to a bunch of other young parents who run small businesses in Eastern Summit County.
Your Honor, right. In our paper, we used the word common standing there. And it really is. If you were to, objectively look at that family for.
Chad, I don't know. For those of you listening in the background, all we have is a shot of the judge's nameplate at this point. It is at least well in focus, but nothing else. We know that this is Judge M. We know his first name is Richard. We have gone above and beyond to let that go. The chat has been so incredibly responsible and kind, and the cameraman is just teasing the law nerds at this point and is like, come on, no.
Erik Richins' death, they were Summit County.
Right. Okay.
Your Honor, as it relates to the nature and gravity of the offense, the gravity is undeniable. It's the defendant's facing life in prison, but the nature
it's a serious case.
Horrific compared with James, but I'm blanking on Brinkley and the other cases.
Bishop, yeah.
All of them. And at bottom, I'm not sure that even the publicity, given all the prophylactic measures that the court has
Mr.
put in place,
Bloodworth.
Something 1,500, even if it's 1,100 post questionnaire, employment of the questionnaire, which was developed with extensive input from the parties, and
I can't.
Also the seating of alternates, and allowing the parties to question during voir dire. Voir dire works, and given the analysis under James,
I think at this point, Mr. Bloodworth is just fucking with us on purpose. So yes, when he goes from at bottom, the prophylactic measures taken by this court are sufficient, I really think that at some point he's just like, the law nerds on the internet will giggle. Yes, Mr. Bloodworth, we will giggle. We will. We're trying our best. It is a serious case. It deserves our serious attention. Mr. Bloodworth, we're trying so hard to be responsible adults. We had a very long day in court yesterday, Mr. Bloodworth. Can't. You know us too well.
The extensive prophylactic measures and the forthcoming voir dire. With the numbers available, we can seat 8+4 fair and impartial jurors.
Okay. I understand the state's position.
Thank you.
Ms. Lewis, you're entitled to the last word.
Your Honor, the court is going to consider the state's argument that Dr. Edelman is an advocate, not an expert, and should be disregarded.
I'm not.
The court's like, I heard them. They made their point.
That, but we didn't based on the court's
No,
question.
I appreciate his admirably candid answers.
Mr. Bloodworth, we appreciate your snark, but Miss Lewis has made the judge smile more today. So she's going to be winning a lot of law nerd points for making the judge smile. That's just what's going to happen.
Not an expert and should be disregarded.
I'm not.
Okay. We were going to cover that, but we didn't based on the court's
No,
question.
I appreciate his admirably candid answers to my questions.
I like that the court said they were admirably
For the
candid
state to
answers.
stand up here and say the offset of publicity takes care of the problem doesn't even pass the smile test.
Yeah, I don't think that's really their argument.
Well, I mean, they stated that. They said, oh, there's been positive publicity, so it all washes out. We know that's not the case. There has been a minuscule amount of positive publicity that nobody cited to in the summary when asked what they knew about the case. No one. No one said anything positive that they heard in the news or read in the paper.
You don't need to convince me of this. I've been concerned about the amount and nature of the media coverage writ large of this case since it caught court staff by surprise when the case was filed. I understand your concern.
And interestingly, when we talk about the gravity of the offense, and Dr. Edelman could probably speak to this, but
What did the media do to the court staff? What did the media do to the court staff? What did the media do to the court staff? Do not fuck with the court staff. Leave the court staff alone. Court staff is lovely. Court staff is busy. Court staff is bae. Media, what did you do? What did you do? I have questions. It might have just been an overwhelming amount of calls and inquiries trying to find court documents. Like, that's possible, but I have questions. The court is, I think that's why the court is so cognizant of keeping court staff off camera, which is why we get some of the funky camera stuff. The judge really does not like the media coverage of this case.
The case was filed.
And he has said it
I understand
many times today and on other
interestingly,
days.
when we talk about the gravity of the offense, and Dr. Edelman could probably speak to this, but
Oh, it's not us, Chad.
the
But
nature of case that
I don't know what the
typically
media
gets
did.
a lot of publicity is
at the
when a
beginning.
woman is accused of killing a husband or a boyfriend. That is not unusual. That rises up to the level in many ways of when we have a child victim. Look at the Karen Reed case right now. Cases where women are accused.
How the fuck did we get Koberger and Karen Reed into the same hearing in Utah in the Kouri Richins case today? It's trial inception. It's just trial inception at this point.
A nature of case that typically gets a lot of publicity is when a woman is accused of killing a husband or a boyfriend. That is not unusual. That rises up to the level in many ways of when we have a child victim. Look at the Karen Reed case right now. Cases where women are accused of murder tend to have a higher rate of publicity than other murder cases, especially an attractive white woman. Let's be honest.
Yeah.
It's different. And that's why this case probably has garnished the amount of publicity it has. And it's extreme. Publicity in this case has been extreme. I don't think anyone can stand up here and try and downplay that or deny it.
I agree with everything you said, but then it begs the question, that publicity does not stop at
Yeah, we're going to
Harley
let the
Summit.
subjective
It's
attractive
coming
defendant
from the Salt Lake
just-
media market, national media, and new media. Why is a change to Salt Lake going to change anything?
That's the point.
Again, I think the survey makes that clear because people in Salt Lake County aren't as invested in the outcome of this case as they are here. They aren't following every detail of this case, whereas a huge percentage of people in this county are. And we don't know where those jurors are going to come from. We know that a huge percentage of the county as a whole is following the case. If we get a disproportionate number of jurors from the eastern part of the county, then that's going to be even worse. We don't need to worry about that in a different county, be it Salt Lake or really any other county in this state.
Or worry about it less. I mean, all the dynamics that are present in
Right.
Summit County are present in Salt Lake County, just not to the same
Right.
percentage levels.
And that's all we need. It's a reasonable likelihood. It is a low standard for the court to determine that she can't get a fair trial in this
I
county.
don't think the court
It's
agrees with
low.
that.
So yes, that is absolutely correct. But voir dire, and I'm segueing a little, is that voir dire is not going to solve the problem. Voir dire is not terribly useful in a high profile case. And in Summit County, where we've got people who know about the case, 80% of people know about the case. And we are asking them to say, can you put that all aside and be fair? We know that jurors say yes. We know that.
Why would we do that at all? I guess what I'm saying is, why wouldn't we focus on the 200 that don't recognize it to start?
So we're going to strike every single person who said they've heard of the case.
The court's like,
Well, that's your decision,
yeet
not
immediately.
mine. You're going to have to make those motions, but I imagine you're going to.
It actually is your decision because we
I'm
don't make
not-
the
he's like, I'm not telling you what motions to make, but my eyebrows strongly believe that you will probably make those motions. Right? The court's like, I am not going to do it sua sponte, but I imagine you would. So the court's like, I am inclined to yeet. Just yeet. Heard about the case? Yeet. I'll take the time. Fine. But those are your motions, counsel. What does it look like when the court strongly indicates to counsel what they should or should not argue? This.
We focus on the 200 that don't recognize it to start.
So we're going to strike every single person who said they've heard of the case.
Well, that's your decision, not mine. You're going to have to make those motions, but I imagine you're going to.
It actually is your decision because we
I'm
don't make
not
the
going to
motions.
strike people
I'm not
for cause sua
prejudging.
sponte. I'm going to rely on counsel to identify those that need to be struck and make motions. You're going to have to do that. You're telling me you're not within your range of options in either county would be to choose to move to strike someone that recognizes the case or not, right?
All right, well, let's say we do that. According to their survey, we'll have about 165 people left. In
The
Summit
right
County.
always means
In
agree
Salt
with
Lake,
me.
we're still going to have a large jury pool if we were to strike every single person who said they knew about the case. And that
Doesn't it bear noting that we're only going to do attorney conducted voir dire, not only of 180?
That's should be more than sufficient.
But how is that relevant in terms of who we're left with in the type of jurors that we have left?
Let me, being absolutely transparent, right? 180 people
It's more than
are
sufficient to
going
see
to
the jury.
be questioned carefully by counsel over the course of 3 days, right? You
Yes.
with me? Okay. So, whether there are 1,000, 800, 600, or 400
We're still
people
questioning about
in
180.
either county that either don't know anything about the case or have read, seen, or heard about it, but
That's the
don't
feed.
follow it at all, does it matter which county they're coming from? As long as you have a sufficient headroom above the 180 to be sure you're actually going to get 180 that either haven't heard about it or heard about it but don't follow it at all.
And chat, to
And I'm
answer your questions, it would be 180 to find 12 total. It's a jury of 8 plus 4 alternates. So they are looking, in this case, they will be looking for 12 total. That includes alternates. They already did motions regarding the 12 jurors. In Utah, you do not get a jury of 12 unless it's a capital case. This is not a capital case. 8 deliberating jurors plus alternates.
Relying entirely on Dr. Edelman's survey for this this question.
But again, you're turning it into just a numbers game, and that's not the standard.
Well, if it's not a numbers game in part, then the survey doesn't matter at all.
But based on your analysis,
Your Honor, pay attention to the survey. I mean, but
we
not
would
in that way.
Never have a change of venue granted ever.
That's not true.
Why
If
is
there
that?
was an inflammatory plus factor, it wouldn't matter.
Wait, say that. You lost me.
If there was an inflammatory plus factor in Summit County, it wouldn't matter at all.
The numbers.
If an angry mob had formed outside the jail when Kouri Richins was arrested, if the crime had occurred at the courthouse,
Don't angry mom.
if, for example, there had been, as in James, community involvement in a candlelight vigil for Erik Richins after
Like
his passing in a search
Utah.
for the
No,
cause of his death
Idaho.
for 45 days
Like
after
in
his
Idaho.
passing.
Right.
That'd be different.
The James factors don't say there has to be an inflammatory plus argument. It says we look at those factors.
The
And
court
those
said
4
that that's the
factors
through
apply
line.
here.
I guess what I'm trying to get is, why do you think it's reasonably likely she's not going to get a fair trial
The court
if
said
there's
that's the big through
enough
line.
jurors to go around that don't know anything about the case? For example, in Stubbs, there weren't enough to go around. It was a big problem. In Iron County, these survey results would predict not enough to go around. Summit County's small, but it's not that small. This is what I'm struggling with.
But is that the standard? If you can-
Reasonable likelihood's the standard.
Oh, right.
Right.
So that doesn't mean that you might be able to get a fair jury here. We might. That's true. We might. There's a reasonable likelihood that we can't. That's the standard.
But why do you say that? I guess this is, why do you see it's reasonably likely that she won't? Other than, is it a concern that the survey results do not accurately show the pervasiveness of the effect of the pretrial publicity? Because otherwise,
Then
We
why
do a
do
lot
we
of these
rely on the
cases.
survey?
we do a lot of murder cases involving normal people. We do a lot of sexual assault, first-degree felony cases involving normal people.
Sir, if you sit there and call Kouri Richins a normal person, she's going to roll her eyes right at you. You do not understand that is not how she sees herself, sir. But he's like, this is a case truly with citizens of the community. That's it. Period. Like the other cases.
We do cases involving gruesome photographs.
How many murder cases have had over 150 news stories
This is what I'm asking you about.
in Summit County? I would say none.
Over
that you've tried.
150
Have you
news
ever read a
cases.
case with this many stories?
Over 150 news stories since the crime in 2022 and the arrest in 2023. It's 2025. You're saying there's been 150 news stories in 2 years? That is some, but that is not all.
Can that
Negative
reduce the
publicity.
James factors just to the pretrial publicity, though?
It satisfies that factor. It doesn't reduce it to just that factor, but it satisfies that factor.
I appreciate that.
And I do think we meet all the other factors also.
Tell me why that is.
Well, nature and gravity offense.
I don't know if 250
Clearly,
over
we
that
meet
period of
that
time
one.
is pervasive
It's a
media.
small community. We meet that one. The closest call is the standing of the victim. I don't, and I do think that's an issue here. And I've talked about it. I've explained it. I don't know. Maybe I'm not making myself clear, but that
he
is
just
going to
disagrees.
vary depending on where most of our jurors come from.
Correct.
So we know it's an issue here. We know it's a family that's well known. We know that, but it is. I mean, when you look at and you drive down the street and you see a library named after them, when they're the biggest landowner in the county, when they're extremely wealthy,
Is there evidence of that in the record? I mean, I got to go off the affidavits that were filed, right?
I don't know. I thought I got that from the record.
The court is not taking this argument well. Also, I don't know about all of y'all, but the Richins family doesn't strike me as Murdaugh level. I think I've made that point abundantly clear. Also, I don't know how common the last name Richins is in the area, but there's lots of communities that have shit named for people, and there's a lot of people with that last name, and they're like, I don't know, this one, that one, whatever. I'm just not, I'm not persuaded.
Before we got in the case, but I'm not going to swear to that.
I mean, I can take judicial notice that there's a building called the Sheldon's Richins building. That's a government building over at Kimball Junction, but Mr. Bloodred.
Your Honor, there's no evidence of that in the record, and I don't think it's an accurate statement either.
Okay. I'm going to go with the first part that I don't think there's an affidavit to that effect, but keep going.
The judge said, keep going. I would like to, Your Honor.
We know at least 26% in the county
The feed
as a
cut
whole
out.
recognized the name.
We push you just a little bit, make sure we're working for the same numbers. 26% of the 80 that recognize the case. We don't know what percentage of the other 20 recognize
We
it.
don't because they weren't asked.
Right.
But I'm going to guess it's not zero,
Probably along the lines of 26%.
probably.
Yeah.
At least. So I think on that particular question, that 80% number is not as relevant as on some of the other questions, because people who know nothing about the case probably don't know anything about the walk the dog letter either, but people who know nothing about the case may very well know the
Docket
Richins
number
family or be
214.
connected to the Richins family.
We know all about the
So that number, I think, if anything, is probably underrepresented, the 26%. I think it's big enough. It's big enough. It doesn't, not each of the 4 factors has to be the biggest ever. It doesn't have to be that every single person in the county knows him. It's the standing of the victim in the community is definitely something to be considered. This is not a nobody. This isn't a gang murder where nobody knows or nobody cares, sadly, who the victim might be. That's not the case we have here. We have a young man, a young, attractive man, a father whose family is very embedded in this community. And the fact of the matter is, Kouri Richins was only embedded in this community due to her marriage to him.
Oh, she's an outsider.
Without him, her standard in this community.
They are really watching the Karen Reed case closely, aren't they? Ma'am, these cases aren't the same. These cases aren't the same. These cases aren't the same. She is really trying to pull in the Karen Reed playbook. She's an outsider. She married in. He's embedded in the community, not her. I imagine that Kouri Richins is watching the coverage of the Karen Reed case. 100%. The cases are not comparable.
Drops significantly.
Didn't he grow up on the Wasatch Front and move here in 2012?
I don't know what the
Oh,
Wasatch Front is. All right, I'm going to back up because now we're talking about geography I know nothing about, but oh boy.
Sadly, who the victim might be. That's not the case we have here. We have a young man, a young, attractive man, a father whose family is very embedded in this community. And the fact of the matter is, Kouri Richins was only embedded in this community due to her marriage to him. Without him, her standard in this community drops significantly.
Didn't he grow up on the Wasatch Front and move here in 2012?
Who?
Erik.
He grew up in Davis County, I understand.
Okay.
But the family has had my understanding is, and I don't know if this is in the record, but the hunting land here is well known.
How many members of the family are there? Like, if there's a whole bunch of Richinses, there might be a whole bunch of family members. The court knows a lot about this case, and it is clear that they are trying to leverage victim standing in the community as a way to move this case.
All right.
And least out for people to hunt on. And that actually, I do know, goes back to, and I think that's in the record, goes back to Erik Richins' grandfather. So the Richins family has been known in Summit County because his grandparents were here, even though he specifically did not
Are there
grow
pictures
up
in the courthouse?
in Summit County.
Are there pictures in the
family
courthouse?
has been a long-standing founding member of this community.
Okay.
So I think it meets it. Is it a closer call than the other 3 factors? I admit it probably is, but it's enough. It's enough to meet the standard, the low standard of reasonable likelihood that she cannot get a fair trial. She can get a fair trial in Salt Lake County. We believe she can. We believe the numbers show that. We believe the survey shows that.
There's a bit of a reach
We're
at the end
dealing
here.
with a huge county comparatively. So, and in terms of voir dire, I just want to say, telling people to put it out of their heads. And when we get people in here who maybe are going to know more than you say, okay, we'll just get rid of all of them. I have no idea if that's going to be plausible, if that's going to
Shell,
work.
I was waiting for her to go there.
Speculating. But when you tell someone who has a
100.
preconceived notion to just put it out of their head, let's be honest, it's just not realistic when there's a lot of publicity on a case. And there is a lot of publicity in this case. There's a lot of publicity in Summit County. There's a lot of publicity.
Of all of the cases I cover, this case has some of the least publicity, and the least ingrained interest. I think interest in this case will grow as trial starts, but of all the cases, this one has, by the numbers, the least interest. And I don't care, because I'm interested in this case. And those of you that are interested in cases or like watching me cover cases are interested in this case. Honestly, Emily, how much does that have to do with the judge? Some. We like this judge. We like these attorneys. This is an interesting case. But it really does have even a lower level of publicity than the Ruby Frankie case, which was in Utah as well. So it's not on the level of the other high profile cases happening in the country at the moment. So that's where I'm at. It's an interesting case, but even the interest from our community in this case is low compared to the other cases.
Nationally. And again, I think it's really important that the national publicity does not have the same effect outside this county as it does in this county. So that's not a reason to say, oh, it's going to be the same anywhere else. It's just not true. It's like in the Koberger case. The knowledge of the case is just as high in Boise, but the connection to the case was not.
That was the plus factor.
And
though.
that was enough to change venue to Boise. This is very similar. The county sizes here are very similar.
It's
We're
different.
looking at a very similar situation. And again, the Supreme Court hasn't looked at very many cases on the reasonable likelihood standard. So we don't have a lot of law that we can rely on.
It's a weird
and point to.
standard. What
We
does
really only
reasonable
have one
likelihood even
case.
mean?
And
Yeah,
I don't think
Koberger
anything in the
case is
James
different.
case indicates it has to be this. It has to be this exact thing.
I think
That's not
that
how
6-week
case law
fear
works, so we know
factor in Koberger persuaded
I
Judge
believe
Judge a
we've met
lot.
the standard. I think we've more than met the standard.
Also,
And if we're going to ensure her a fair and reasonable trial, a fair jury, moving the trial out of Summit County is the only way to do that. And we would ask the court grant the motion to change venue.
Okay. We take a 5-minute break. Can't delay in a ruling here. Clock is ticking.
accurate.
I'll be back in 5 minutes. Thank you.
I appreciate the jump cut. On our polling, we're at over 7,000 votes for the publicity that the defense relied on quite a lot, that interview on Court TV. Before this stream today, 98% of you had not seen it. And most of you said you had not even heard that that interview was happening. So I have ended our poll as we're going to get to the judge. Look at this, y'all. Ruling from the bench. I'm here for it.
Under Utah Rule of Criminal Procedure 29, C1A, if a party believes that a fair and impartial trial cannot be had in the court location or in the county where the action is pending, that party may move to have the trial of the case take place with a jury from another county, or the case transferred to a court location in a county where a fair trial may be held. The trial court must evaluate a pre-trial motion for change of venue based on demographic, geographic, and cultural evidence unrelated to the identity and potential for bias of an actual jury venire. A judge should grant the motion whenever he or she finds a reasonable likelihood that a fair trial cannot be had unless the motion is granted. And bearing in mind that the court must take the totality of circumstances into account, the factors to be considered include the standing of the victim and the accused in the community, the size of the community, the nature and gravity of the offense, and the nature and extent of publicity regarding the case. Here, regarding the standing and victim of the accused in the community, the court finds the declaration of Kouri Richins Benson, docket 945, to be credible and relevant to the standing of Erik Richins and the defendant in Summit County. In short, Erik and Kouri both grew up outside of Summit County. They moved here in 2012, and they subsequently began raising a family and running small businesses in Camas. Prior to Erik's death and the events alleged in this case,
So 10 years.
They had a standing in their community in Summit County that was roughly equal to each other and roughly similar, equal to Summit County at large, given that they occupy the statuses of young parents involved in small businesses in their respective communities. Regarding the size of the community, approximately 43 residents are in Summit County based on census.gov data and estimates as of July 1, 2024. Of those 43,000, 1,500 were summoned as jurors in this case, and of those 1,500, 1,100 completed questionnaires. As noted, the court cannot and has not reviewed those questionnaires in any way prior to today.
Because it hasn't started yet.
Notwithstanding its relatively small size, Summit County is not homogeneous. Based on this judge's experience serving in this county for the last 5+ years, there are material differences among county residents related to income, lifestyle, family structure, and religious and civic affiliations. And these differences express themselves, at least in part, between what locals refer to as the East Side, communities of Henneford, Colville, Oakley, Camas, and Francis on the one hand, and the population living in the Snyderville Basin and Park City on the other. With respect to the nature and gravity of the offense, defendant is charged with, among other crimes, 2 first-degree felonies, including 1 for aggravated murder involving pecuniary gain and administration of poison. These charges are very serious.
They are.
While the state has declined to seek the death penalty, defendant nonetheless faces the risk of a life sentence. Notwithstanding the seriousness of the charges, this case does not involve some particularly inflammatory elements that are involved in other cases, such as the involvement of a child victim or sexual violence.
We can see where this is going.
And the fourth factor, the nature and extent of publicity.
He's
Court
going through.
finds that there has been
He's
an
going through
extreme
each
level
element
of media attention on this case. And that coverage has been incomplete and therefore misleading. It has involved inaccurate summaries of evidence that may be admissible. It has involved discussion of evidence that the court has ruled is not admissible. It has included speculation by commentators who have no personal knowledge of the facts of this case. The nature and extent of the media coverage of this case is an indictment of those media outlets and our current media culture.
Yeah, he's not happy.
But on the other hand, that coverage has been spread out over the 2 years during which this case has been pending, and there have been substantial periods of media quiescence between court hearings and between significant court filings. But even this level of media attention
I don't think the court considers us
has
media.
not affected significant swaths of the community, according to defendant's community survey, which the court finds reliable.
Also,
For example,
when he's talking about incomplete media coverage, I don't think anyone can say our media coverage is incomplete, because we have covered every minute of every hearing that has happened in this case and the court filings. We don't speculate on the defendant. We don't speculate on the defendant's motives. We cover what's in court. We talk about what's in court. And it is not incomplete. If there is incomplete coverage here, it is because it is not yet in the public record. And we know that, which is why we're waiting for this case to go to trial, because we want to know more about the case. And this case has been pretty locked down. So, yeah, again, facts and full court days. But he was talking about particular media outlets, and I'm curious as to what he means. But I do not think the court is upset with the law nerds. But you know how salacious media coverage of cases that spark the interest of true crime can get, but we don't do the slimy true crimey over here. So we're just going to continue on. And look, again, we know how the court feels about the media. This court has not made it easy for media access to this case at all.
20% of Summit County residents have no familiarity with this case, or stated more precisely, Dr. Edelman's survey results would predict that 20% of Summit County residents have no familiarity with this case. That is, they have not read, seen, or heard about this case at the time that they were surveyed. Of the 80% of Summit County residents that are likely to have read, seen, or heard about the case, 30% of that 80 have not formed an opinion as to defendant's guilt.
And that's a pretty big swath.
50% of the people who recognize the case indicated that they follow the case not too closely.
He's saying most
or
people,
not at all.
most,
And 15%
most
of
don't know about
those
this case.
that indicated they recognized the case indicated that they followed the case not at all. Using the 1,100 potential jurors that have completed questionnaires in Summit County as a base to apply these percentages against, the court finds that approximately 220 have not read, seen, or heard about the case. Approximately 644 identified or would identify that they do not have a connection to the Richins family. Of the 878-ish that are likely to recognize the case, 270 are likely to respond that they have not formed an opinion about the defendant's guilt, and 131 of the 878 that are likely to have read, seen, or heard about the case are likely to indicate that they have not followed the case at all in the public media. Given that attorney-conducted voir dire of 180 jurors is contemplated over the course of 3 days, these numbers, approximately 220 that are likely to not recognize the case at all, another 270 that have formed no opinion on top of that about Ms. Richins' guilt, another 131 that have read, seen, or heard about the case but don't follow it at all.
It's going to be fine.
They provide an ample pool from which
there's enough people, it's going to be fine.
Parties can exercise for cause and peremptory challenges regarding other factors and nonetheless clear 24 jurors for cause in an effort to identify 12 8-seated jurors plus 4 alternates that are undeniably fair and impartial.
Right. The numbers.
And while the numbers are
say
not
there's
the
enough.
only factor that must be considered by the courts,
He's saying the
they
other
are a relevant
factors.
factor.
The other
And
factors.
they
lean the same
militate
way.
against a determination that the size of the community or the nature and the gravity of the offense or any concerns regarding the standing of the victim or accused in the community makes it reasonably likely that defendant will not get a fair trial. Moreover, and more broadly, as stated by the Utah Supreme Court in State versus Lafferty, pretrial publicity, even persuasive adverse publicity, does not inevitably lead to an unfair trial. Here,
Right.
considering the James factors as a whole,
And those are the 4 factors from earlier.
the court does not find a reasonable likelihood that a fair trial cannot be had unless defendant's motion to change venue is granted.
So motion denied.
Therefore,
That was all in the negative.
based on the totality of the circumstances discussed, the findings and conclusions made by the court on the record today, defendant's motion to change venue is respectfully denied. Now, defendant may choose to seek appellate review on an interlocutory
Another
basis of this ruling.
Interlocutory appeal in this case.
And we'll talk about that in a second, Ms. Lewis. If they do, if she does, and if an appellate court determines that this court has abused its discretion in denying the motion to change venue and that the motion
Which I
should be
doubt.
granted, the court rules as a matter of law for the reasons already stated on the record that the court has the authority to pull jurors from another county and that the proper result, if the motion to change venue were to be granted, would be to pull jurors from Salt Lake County for a host of practical reasons. First, it's just not that far away. It would take jurors from Murray, Holiday, or the zip code that I live in, barely more than 10 to 15
Your Honor,
minutes.
please don't dox yourself on the internet.
To get to this courthouse. Second, in consultation with the Summit County Sheriff's Office regarding security concerns related to a high-profile trial, transporting a defendant back and forth from Summit County to Salt Lake County each day is not a good security plan. And third, with respect to housing Ms. Richins in ADC, there's no guarantee she would take her. They would take her. It's a Summit County case. She would likely have to be housed in Summit County. The witnesses are in Summit County. This is a Summit County case. It is not an abuse of this court's discretion to pull jurors from Salt Lake County for a Summit County case if defendant had shown or if an appellate court determines that defendant cannot find a reasonable likelihood or cannot, there's a reasonable likelihood that defendant cannot get a fair trial in Summit County.
Fred's drooling.
In short, if this case goes up on appeal, I want to make sure the parties get an opportunity to get guidance on that issue as well.
I think that's incredibly considered of the court.
Let me pause for a minute.
So what the court did is say, look, I'm denying the motion. If this motion were granted, I think the proper procedure would be to bring jurors from Salt Lake City to the courthouse in Summit, or from Salt Lake County to Summit County to serve jury duty, not the other way around. So the court said, look, if you're taking an interlocutory appeal, which I think you probably will, which they do, if you're taking an interlocutory appeal, which means in the middle of the case, not when the case is complete, then I want the appellate court to review all of the steps. And if you're reviewing all of the steps, I want the court to be able to give us an answer, because if the court says I should have granted this, then I want to bring the jurors here. And I want the court to rule on that so that that doesn't have to then be appealed next and you keep spacing this out. So the court's like, look, if this, then that, decide all of it at once. If you're going to take an appeal, I understand that you might. And the court doesn't have any snark to it. We've seen other courts say, I understand that you might appeal this, and it comes across differently. This court's like, I understand that this is what might happen. This is my ruling. I'm going to make the record as thorough as I can so I can do my job. You can do your job. Let's continue on. This case was set to start jury selection in 2 weeks.
Procedural questions. Mr. Bloodworth, do you need any clarification of the court's ruling?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Ms. Lewis, the
The
parties
court's
will receive
very thoughtful.
the 1,100 questionnaires probably by Wednesday, maybe Thursday morning. In the meantime, if defendant determines that she's going to seek an interlocutory appeal of this ruling, and if you're going to make a motion to continue the trial to allow that position for interlocutory appeal to be considered and decided, sooner the better.
We'll do that now.
Go ahead.
We're making a motion to stay the proceedings and to continue the trial while we seek an interlocutory appeal.
And there we go.
And is it your intention? Oh man, I got to ask you some very pointed questions here. Do you mind? And if you don't know the answers yet, that's fine.
The court's like, okay.
Have you discussed with Ms. Richins
Yes.
the certainty that she will remain in custody while that process plays out?
Well, we would move to reopen the matter of detention, but we've discussed with her that that is possible.
That's not going to happen.
I am disinclined to reopen the matter of detention. So let's be very clear here. There are no material changes in circumstances since the last time I considered the issue that I'm aware of.
Right.
Well, a change in the trial date
That's
is
not a
material change in circumstance.
But
which
you're the
is-
one asking for it.
Bing. Bing, bing. Bing, 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 bing.
Well, we just want to make a record. We believe that is a material change in circumstance, that the trial date is going to now need to be moved. She's been in custody for almost 2 years. And there are certainly circumstances, there's a set of conditions under which she could be released and not be a flight risk and not be a danger to the community.
Nope. Let's assume that she's not going to be released and that I find that there has not been a material change in circumstances based upon defendant's request to continue the trial. Have you discussed with Ms. Richins the fact that that interlocutory appeal process may take years?
Well, we'll take an emergency appeal. I don't think it will take years, but we know it will take a minimum of months.
Okay. I
And we
understand.
have discussed that with her, yes.
Okay.
Your Honor, to that point, can we get maybe more complete speedy trial waiver?
Yeah.
Yeah. Fred has now taken up my entire desk. The nope was on my soundboard. That's me.
We're not waiving. If
But
you want to interpret that
you're
by
ask-
a motion, but we're not specifically.
You're asking for a stay. I guess you could say that if you're asking for a stay, you're not waiving speedy trial, and that once the stay is lifted, the timing would pick up right from there.
Waiving speedy trial.
The stay would just pause everything.
Mr. Bloodworth, any speedy trial concerns are addressed at least during the period from this point forward by defendant's motion to continue. Any speedy trial concerns that have been baked in prior to today are what they are. I think that's true as a matter of law. Do you see it differently? Sir? Why don't we
Nobody's at the microphone
all take
anymore.
5 minutes and make sure that you want to
The court's like, let's take a look at law.
just forget 5 minutes. Okay, I understand your position. We'll come back in 5 minutes.
Your Honor,
Yes.
before the break.
Any change in position?
I don't know what happened, but Mr. Bloodworth put something on the record or the feed jumped. But the defense is asking for a stay of proceedings, a continuation of the trial date so that they can file an appeal regarding the court's denial of their motion to change venue. Jury selection was supposed to start in just about 2 weeks at the end of April. So the defense is asking to stay proceedings, continue the trial so they can take the appeal. The stay would not be lifted until the appeal process is done. But then it stops everything going on in this case. It stops discovery, it stops motion, everything gets stayed. So,
Position. Okay. Let's go one step at a time.
Fred,
The defendant is making a motion to continue the trial, correct?
Correct.
Any objection, Mr. Bloodworth? Sure. Among the requests, but the only one we're discussing at this very moment is defendant's motion to continue the trial so they may file a petition for interlocutory appeal. Any objection?
the state said they were ready for
Understood.
trial, but there's no
Ms.
objection.
Lewis, I heard you also say that you're moving to stay the case. I understand that to be a motion to stay pre-trial proceedings, jury selection trial. Is that correct? Okay. Mr. Bloodworth, any objection?
Just a point of clarification, Your Honor, does that include a staying of all deadlines set by the
Yeah, it would be a stay of all deadlines.
I think
For
it.
example, tomorrow would be exhibit.
That's what I understand is that as of 1:30 p.m. on April 7, while the court would retain jurisdiction of the case, no further pretrial proceedings would occur absent a specific request by a party.
Yeah, that's a full stay.
All right.
The state said they're prepared to go to trial.
Other than needing a written ruling, which I should be able to provide by I'll say Wednesday morning, but it'll
I
probably
really
be
wish
earlier
they
than
would
that.
stop zooming in on the defendant. She is uncuffed. She has Kleenex available to her and has chosen to just do the most. So, look, it's just, you're not getting out for an interlocutory appeal. It's just not happening. So, again, has Kleenex, choosing not.
We'll say Wednesday morning.
But at
Any
least she's
other
allowed
requests for
mascara. Sarah Boone
clarification
wasn't even
today,
allowed
Ms.
that.
Lewis?
So
We also moved to expand the gag order in this case. So that no parties are charged.
the defense wants to expand the gag order. Fred, get off the remote.
Is that inconsistent?
Oh my goodness.
Certainly more briefly
Oh my God.
stated than the
Cat.
current order.
Code
Let me call
Fred.
that one up.
My cat is causing chaos.
That was referred to as a protection order. Is that correct, Mr. Bloodworth?
Oh yes, Fred is the orangest of orange cats.
No, I've got it. It's 204.
Your Honor, it just makes the rule more.
I'm looking at the wrong order.
The defense has asked
Forgive me.
for
It does,
the
but let's look at it together.
expansion of the gag order in this case. I'd really like to see what the judge is doing, but if the defendant is crying, the focus is going to be on the defendant. But with the judge's frustration with the media,
Yeah, it's,
that's not going to help. Like, it's just not going to help. It's not going to help to continue to zoom in
Docket
on the defendant.
68,
It's not going to.
protection.
The judge isn't going to find affinity for the media.
An order.
I would like to be in charge. Just put stationary cameras. That's it. And leave it be.
All right, Ms. Lewis, the current order states, consistent with Rule 3.6 of the Utah Rules of Professional Conduct, that lawyers who have participated, who are now participating, or who will participate in the investigation or litigation of this case shall not intentionally, knowingly, or recklessly permit a witness, investigator, consultant, staff member, or other member of the lawyer's agency, firm, or team to make extrajudicial statements which,
Right.
if made by the lawyer,
Those are the rules.
would violate Rule 0.6. That rule prohibits
Those are the rules everywhere.
extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. What is the clarification you're seeking?
Stop the press release going out. It's a violation of rules of professional
What press release?
You'll need to be more specific. My apologies.
State's witnesses all testified.
What press release? I follow this case as closely as I follow most of the other cases. What press release? I am missing a bunch of shit.
One second. My apologies.
Defense counsel is saying that a press release.
Would you say the last sentence again?
That the press
Violated.
release stating that
The microphone found itself. The microphone found religion today.
officers were all testifying truthfully violates the rules of professional conduct. Yet that particular protective order did not protect the defendant in that case, in that situation.
Without the court making any finding about whether any press release to date has violated the order, is strict compliance with the order going forward sufficient?
Yes, I guess we'll address it if something comes up.
What press release?
And I obviously need to make the record.
I'm not sure you do. There's no motion.
Did you see defense counsel's face? She's like, no, you don't. But Mr. Bloodworth's like, yeah, you rang my bell and now I need to respond.
Obviously need to make the record.
Look at defense counsel's face.
I'm not sure.
I'm going to rewind that one more time. She didn't just roll her eyes. She rolled her entire soul at Mr. Bloodworth. Oh boy. One more time. I had to move the closed captions.
And I obviously need to make the record.
I'm not sure you do.
Don't.
There's no motion. We can just move on.
I'm not sure
Okay.
you do.
Your Honor, and can I just state for the record that the defense was ready to proceed to trial. The point of this is not to delay the proceedings. It's not to give the defense additional time to prepare. We were prepared to go forward. The point of this motion, for the record, is only because we believe that she cannot receive a fair and impartial trial in Summit County.
I find that representation to be genuine.
Thank you.
Okay. Ms. Lewis, anything else on the record?
No, Your Honor.
Mr. Bloodworth,
I appreciate that the court just
moving it along here.
The
shut
court
down
said
the
nope.
discussion.
Yeah.
The defense counsel just alleged an ethical violation by the state.
Yeah, we're
We
going to
already
stop.
alleged that. That wasn't a new allegation.
Folks,
Your Honor,
Oh shit.
OPC's ruled on it.
please stop. I'm not joking. Have a seat.
Respect my authority!
Oh
Ms.
shit.
Lewis, anything else on the record?
No, Your Honor.
Other than what you were about to say.
The court's like, seriously? Stop it. Sit down. I am not kidding. Stop it and sit down. Stop it and sit down. Mr. Bloodworth, look at Mr. Bloodworth's face. He's just like, okay, fine, Your Honor. Bloodworth, either that or Bloodworth heard my sound bites in court and is laughing at us, which is probably it. The judge is like, I am done. I am done. I am done. I am done.
I'm not joking. Have a seat.
Sit down. Mr. Bloodworth's like, okay.
Ms. Lewis, anything else on the record?
No, Your Honor.
Other than what you were about to say, Mr. Bloodworth. Anything else on the record?
No, Your Honor.
All right.
Well, that's what Mr. Bloodworth was laughing at. Other than what you wanted to say that I told you not to say, is there anything else? The judge is like, seriously, I'm so fucking done. I'm not fighting with you over a press release.
Motion to continue the trial is granted as unopposed. Defendant's motion to stay pre-trial proceedings, in this case from this point forward, is granted as unopposed. The court will issue a written ruling that incorporates its ruling from the bench regarding the motion to change venue so that there are no impediments to defendant's ability to seek appellate review on the motion to change venue. Ms. Richins, I wish you the best of luck. The court is in recess.
I still don't know what press release they're talking about. But at the end there, the judge is like, you're going to let me finish, and I am going to finish now. And all of you are going to sit down, and we are done. And
Respect my authority!
that's it. That's it. I'm done. I'm not fighting over whatever fucking press release. I have no idea what they're even talking about, but I'll go look for it. Because I don't know what press release they're talking about. There is a gag order in this case that follows the rules of the model rules of professional conduct, which is similar to what we've seen in every other case, because the national model rules are really pretty instructive on what the attorney rules are and the statements that can be made in court, not made in court. And the court has a gag order in this case. I don't remember when the gag order came into play because the previous defense counsel was giving media interviews early on and is not doing that any longer. Let's do a summary of the court hearing today. Then I'm going to answer some questions and then we are going to wrap because it was a long day yesterday and it's been a long day today. And yeah, I'm tired. I'm sure the mods are tired. I'm sure y'all are tired. Let's see if we can summarize today's hearing because it was a lot. At the end of the day, in the Kouri Richins case, the court denied one defense motion and granted two others, which will substantially change the pacing of this case. After a thorough hearing, and we saw the same expert on the change of venue motion that the defense used in the Kohberger case, the court denied the change of venue motion and made a really thorough record that if the appellate court disagrees with the court's findings here, that the court believes that the proper procedure going forward would be to allow the court to bring a jury from Salt Lake County up to Summit County versus sending the entire case from Summit County to Salt Lake County. Different than what happened in the Kohberger case, where the entire case was moved from Latah County, near where the crime happened, more than 300 miles away to Boise. Here, Summit County and Salt Lake County, where Salt Lake City is, are much closer together. They share the same media market, etc. So the court denied that motion for change of venue. Earlier in the case, all the attorneys had asked that the court expand the jury pool and pull jurors from both Salt Lake County and Summit County. And the court had said, yes, we can do that. And then the site judge or the presiding judge said, no, you can't. And then the defense took an interlocutory appeal, and that went up on appeal. And the Supreme Court in Utah said, you cannot pull jurors from two counties, and findings have to be made on this type of motion to change venue before you can grab jurors from another county. And the court denied that motion from the defense today. The defense indicated immediately that they are going to take another interlocutory appeal, which means an appeal while the case is ongoing versus a conclusion has happened and then an appeal is made. So the defense is taking another interlocutory appeal on the issue of change of venue. And they then immediately made a motion to continue the trial and stay the proceedings. A jury was supposed to be selected at the end of April in this case, with evidence starting the first week of May. But that's not going to happen now that the court has stayed the proceedings and is allowing the defense that interlocutory appeal, which they have to, and has continued the trial. If you're going to ask me, continue the trial till when? We don't know. It depends on how quickly that interlocutory appeal moves along. It could be months. It could be into next year. Hey, T. It's okay. Fred's fine. He's just Fredding. He's already caused all the chaos he's going to cause. I appreciate you. We were just summarizing today. I'll be out in a few. Good to see you, buddy. So we don't know when this trial will start. It's all going to depend on how quickly the Court of Appeals rules on this, or the Supreme Court and the state rules on this. But what we do know is that Kouri Richins seemed pretty upset with the delay, or the fact that the court immediately said that the court would not reconsider the status of Kouri Richins' detention. The court said that he did not find the defense request for stay and a continuance of trial to be a change of circumstance outside the defense control. And the defense made a record saying, we were prepared for trial. We are not doing this to delay this case. We are not doing this to gain more time. We as the defense team believe that Kouri Richins' best chance for a fair trial is with a Salt Lake County jury, not a Summit County jury. The court said, yes, I agree with you. And then the defense asked again for an expanded gag order and talked about the media in this case. And the court talked about the media coverage of this case multiple times during this hearing. This judge made it very clear that he is incredibly displeased with the media coverage of this case, which he said was incomplete and was speculative. He said there are commentators on this case talking about it with no knowledge of the case, that the facts of the case had not been, well, completely vetted out, and that he found the coverage of this case to be, I think the direct quote from the court was, an indictment on those media outlets and the media culture in general. It is very clear throughout the court's comments on the record today that this court does not believe that the media coverage in this case has been accurate, complete, or fair. I don't know exactly what media coverage he's talking about. Most of the media coverage I've seen of this case have been clips of what's happened in court. It has not had the pervasive media that we've seen in other courts. Not other courts. It has not had the pervasive media that we've seen in other cases. However, do you know what came up in court today? A whole lot of arguments mirroring the Karen Reed case. And in fact, the Karen Reed case got a name drop in court today, as did the Koberger case. And they talked about the fact that when you look at the standing in the community of the victim, Erik Richins, vis-a-vis Kouri Richins, that Erik Richins' family has a long-time connection to the community and has hunting land and a library or something, but that Kouri Richins was essentially an outsider. And the court corrected the record and said it seems that Erik Richins and Kouri Richins both moved to the area in 2012 after they were married and built their lives in the community together. But you can see the defense attorneys trying to make similar arguments to the Karen Reed case when these cases could not be more different. The coverage of the cases could not be more different. And the coverage of the Richins case pales in comparison to the vociferous media coverage of the Karen Reed case. And that's been true since the beginning of the case. I think the most attention the Kouri Richins case is going to get is midway through trial when people start hearing about it. It will pick up attention as it is underway, but it has not had attention outside of updates on the court dates very often. And not streaming, I think, might be a part of that because it takes a couple days from a hearing before we even see coverage of what happened in court. So I don't think this case has the type of media coverage we've seen in other cases, but there is a lot of local interest, like there are in many cases. So let me know what you think. We're not going to see a trial on this case yet. I don't know if we're going to see a trial on this case this year, but I'm going to keep in the loop on this case because I want to know. All right. And I really like this judge, even though he hates the media. And the prosecutor did say, you know, that all the law nerds on the internet do call the walk the dog letter, even though it's docket 214. So, yeah, I'm invested. Let's get to questions because you've got them. I've got them. We've got them. All right. Touche in the chat is the first question I saw. And Touche in the chat asked if I covered the hearing about the phone. I did. We have covered all of the court hearings in this case. Sometimes they're a few days behind, but we've covered all the hearings in this case. Oh, my weather's going to get sketchy real quick here, folks. So we're going to cover as much as we can. And then I'm going to go because we're getting into some weather that is just is well warned. All right. Goodness. We've gone from a severe thunderstorm watch to a severe thunderstorm warning. So no swirly weather, but I think hail is reasonable. All right. Miss Megs 31 said, Lord, give me the glee of EDB with a new soundboard. I am delighted. Look, man, we're running directly towards the dopamine as we're getting into a very long stretch of trial coverage. So, you know, with the sounds, I'm just like, do it. I'm just here for it. Do it. I'm delighted. And if I can amuse myself, then that's what matters. Megan says Fred is innocent. 100% no. 100% no. That cat deadass looked at me and stepped on the remote for the monitor where I put up the things I'm streaming. Like 100% just was like, what? Fred was fretting. Fred was 100% fretting. But we love him anyway. Belinda said, why are the defense bringing this now so close to the start of trial? Do they benefit from it being closer versus doing this months ago? They were waiting on other answers because this is the more time-consuming option. And everyone had agreed that it would be great to just pull jurors from Salt Lake City. That was the easiest option. So the defense attorneys can focus on this case, their other cases and other things, and not writing these motions and not doing surveys. So why did they bring it now is because they had other options. Once those other options were cut off, then they needed to do this. And from the time that the court ruled on that in February to bringing these motions in April is actually a pretty quick turnaround, with surveys getting done in March and the motions getting written up. So it really has to do with the timing of the other court. And that's really the main point. Josh H said, if I was a betting man, I would bet motion denied. Based on the court's questions, you can kind of see where he's going with that. The court made it fairly clear what he thought. Loch Nessie, good to see you. Said, thank you for such great coverage on this case. I'm in Utah. Only thing I've seen is any updates in the trial is the usual front page on local news, local, not national. Thanks for a great week of court. It's been a fun week of court. Cheers, and cheers to you. It doesn't have, not to downplay the impact of media coverage to this defendant and how this defendant feels about the media coverage and how their attorneys might feel. It's just on the scale of cases I cover, it is, it might feel significant to the parties involved in this case. It's just, we see a sliding scale of involvement in cases. And the Kouri Richins case doesn't have any of the indicia of fuckery that a lot of the other cases do. And it does not have the wide attention of the internet and the media the way some other cases do. It feels to me that a lot of the coverage of this case, and I will go look for other coverage, but a lot of it seems to be this happened, that happened. But also, I don't click on media that I just look at and go obviously wrong and obviously no. So I also don't see everything that comes up in that way because everything is now algorithmic. And I tend to look at local media for their coverage, and I lean very heavily into coverage that says in court today, this thing happened. So I don't know what the court has seen that they're frustrated about, but they're frustrated about something. So I'll have to look deeper on that. Samantha Jean asked, EDB, do you think the lawyers get bothered when a judge interjects as much as this one does? Just curious. From my own experience in motions like this, where the judge is the person deciding the motion, if the judge has specific questions they want answered, I rather have them ask than play, a guessing game with, hope I hit all the points you're curious about. If you want information, ask me the question and I'll give you the information. And that's much easier. If it's in trial, that's a whole different thing. I hated it when judges interjected in trial. If I'm doing a direct examination or cross-examination, and the judge starts interjecting, it can throw off the rhythm of my questions. It can throw off the rhythm of the answers. It can bring up things I might not have wanted to bring up yet because we were going a different direction. It can disrupt the witness in the way that they're telling their story. So in a hearing like this, no. In front of a jury, it bothered me a lot. And I think a lot of attorneys are the same way because you've made my train of thought jump the track. If all of a sudden I'm chugging along and the court's like, this way, and you're like, what the fuck just happened? No, don't do that to me. So in front of a jury, it bothered me more. Because also in front of a jury, the period it takes to recover after you've gone off a different direction is different than in a hearing like this. So in a hearing like this, no, I rather have the court just be direct. But there was a judge I very much liked, but did that all the time. And I was just like, I'll get there. Let me be. I promise I have a plan. Bernie Cat said, EDB, I love my I Have Questions hoodie. It's the most comfortable. Love it. Thank you for having cool merch. You are welcome. We are working on what merch in the year of our Lord 2025 looks like. So don't get the Law Nerd app so we can keep you in the loop as we navigate the intricacies of that for you guys in a reasonable way. Leslie's nefarious incisors, the nefarious incisors says, Mini-Me is officially 17 today. I know. Somehow 17 hit me totally different than when T turned 16. Where did time go? We are in full Aries season when our household is 3 females. Others are Taurus and Scorpio. Fun. Oh. You know what? life's not boring. Life's not boring. And yeah, my kiddo, 17 was harder. Like 17 was just harder. Celeste said, will they have to throw out the 1,100 surveys and start over if they stay in Summit County? Yes. Because of the delay, they would have to, and this is speculation, I think they would have to pull another panel because they were qualifying jurors for a May trial, and that's not going to happen. So they would need to send them back out again. And things do change. RD said, thank you for translating lawyer faces for us. You're welcome. The defense attorney was just like, oh, I'm sorry. It's Elise. Elise's incisors. Nefarious incisors. I'm sorry. The whole thing is a Brennanism. You guys have asked, and thank you for everyone with the patience of no breaking news in the chat, no updates on other cases. We're trying to just focus on this case, and we don't need to go running down rabbit holes in other directions. But there is no court tomorrow in the Karen Reed case. The court is looking for additional alternates. I think that's wise. The court had originally said they were going to look for 16. It seems they are looking for 18. I think that is smart. When they started jury selection, I said, I think the court will want 18 jurors. Jury selection has gone faster than the court allowed for. If I was the court, I would want 18. I would want one per week in the Karen Reed case. And so I think 18 is the appropriate response. So the court has 16 selected and they want 18. Remember, the weekends you can lose people. So the jurors that come in on Monday, you might not still have 16 because people go home and are like, crap, we're still in trial. But it looks like opening statements might start on Tuesday if they get those additional alternates on Monday. I don't think they will finish getting those alternates and then start jury selection because as they are bringing in new veneers of jurors, the other jurors aren't in court. So when they get the rest of the alternates, they will need to call all the jurors and bring them in the next day or later that day. But I think the court will do it the next day. The court's ahead of schedule. So I think Tuesday is reasonable. All of you are saying Marathon Monday here in Boston. Well, it's interesting that they will have court on Monday, but they're going to have court on Monday. No court tomorrow, though. And I don't know if the marathon will throw things off, but I really don't think we will see opening before Tuesday or Wednesday. But I will be covering it when we get to opening, and I will be keeping you in the loop on the Law Nerd app first. So if you want and are ready for the Karen Reed case to start, I will be covering it then. So we'll see if it starts Tuesday or Wednesday. I don't know. We'll see. And then next week, let me take a look at the calendar real quick. If trial starts, we'll start when trial starts. If it looks like trial is going to start Wednesday and go Wednesday, Thursday, Friday, then I will probably start streaming on Wednesday. Again, I'll let you know in the app. However, that is going into Easter week. So the court might also be closed Friday. So I could see the court running next week, just Tuesday, Wednesday, Thursday, but we'll see. And then we'll go from there. So I'm going to answer a few more questions. Make sure if you are new and you like live trial coverage with commentary, and sounds.
Do it.
You need to get the Law Nerd app because that's how I can keep you in the loop. It's free, iOS, Android. We made it for you so that you can stay in the loop with these cases when it works best for you. It is the easiest way for us to keep you in the loop. All of you are saying the marathon's the 21st. Okay, well, that's helpful. So if the marathon's the 21st, then you probably will have a break on court from the 18th to the 21st. I can see them taking off Good Friday through that Monday and resuming on the 22nd. We'll just play it by ear. So with all of that, I'm going to answer a few more questions and then we are going to zoom because, hey, yesterday was a long day. I did not get nearly enough food yesterday. I am tired. I'm sure y'all are tired. And I want to see what the weather does. So let's see. Maddie in the chat said, which is better, Karen Reed 2, Electric Boogaloo, or 2 Karen 2 Reed? I'm just still frustrated that the Karen Reed case is going to trial again. Like, what are we... What are we doing? I have no say in it at all. I'm just frustrated. Tracy said, does the appellate court have to take this case? Well, if they're not going to take the appeal, then the appellate case would say we're not taking the interlocutory appeal. But this is the type of ruling where they are entitled to an interlocutory appeal. So yes, and they've already ruled on this case with regard to jury selection. I don't see the court denying that appeal. I don't see them choosing not to take it. Whether or not the Supreme Court will take the Karen Reed case is a different matter entirely, because the Supreme Court, they have petitioned. I'll put that on the Emily Show podcast on Monday. We'll talk about it more, but they have petitioned to the Supreme Court, and the Supreme Court is not going to stay the case. They already denied that stay, and they are going to decide if they're going to take it. They might not. So I don't know if they said no today. They said no to the stay, but they also had put it for the 25th for their conference. So I can't imagine they would decide it before the 25th, but they're not staying the case. They haven't decided if they're going to take the case. Hopefully that makes sense. It's a different thing. So I haven't seen anything that the Supremes have decided not to take it. I don't think we'll hear that until the 25th. Let's see. I see a lot of you have said and have shared thoughts about their appreciation for the judge today, the judge yesterday. There are judicial demeanors that I like and judicial demeanors that rub me the wrong way. It is much easier for me with judges who I can follow. And when judges have control of their case in their courtroom, it is easier. There are times when Judge Summer frustrated the ever-loving shit out of me because there was no control of the courtroom, and she was just sitting there and the lawyers were just wilding out. I'm like, you're like an exhausted parent that's just like, whatever, let them fight. Like, I am so tired. Judge M and Judge H clearly have the respect of the lawyers in their courtroom and maintain decorum in their courtroom and get to the fucking point. They just get to the point. And I appreciate it. There are times Judge Cannoni just lets the attorneys just go on and on and on. And I'm like, you already know. Why are we just, it's all in their writing. They're just reiterating their writings. And then there's times when she cuts off the defense and refuses to cut off the prosecution that I'm like, what are we doing? Can we just straightforward? Everybody gets the same treatment. So much easier. How did everyone go to the judge's mug is very Patagonia? That's not what I'm getting at all. I'm seeing early adapter, refined yet traditional, smart as fuck, bespeckled Judge Dumbledore. Fair enough. It was giving Utah outdoorsy. And then I Googled, and the judge is also on the Utah Avalanche Center board. So being concerned about avalanches is also giving outdoorsy and snow. And Utah. It's giving Utah. Oh, can you guys hear the thunder yet through the mic? Can you hear the thunder yet through the mic? But I kind of love that the mug has a hand element. I don't think the mug has a heating element. I bet he has a little heating disc on his bench. I would imagine that he did. Let's see. Since Diddy's trial won't be streamed, will you go over the court transcripts? I don't know. We'll see. Yeah, I don't know. We'll see. So I cannot confirm whether or not I will. We'll see. I still think the Diddy case isn't going to start in May, especially with that additional indictment with new charges. I just don't see that case starting in May. That case is going to get right up to the precipice of trial and bounce. Yeah, I don't see that case starting next month. I just don't. Cheryl Ray said, 1 more month till my red gavel. Congratulations. Lisi said, children, quiet, behave yourselves. Yes, it was very much like, no, I am done. The judge was so done. The judge was so done. So done. All right. With all of that, Law Nerds, I'm glad we got to go to court today. I'm glad we got to check in with what's going on in the Kouri Richins case. The Kouri Richins case is now docketed for keeping an eye on what the appellate court's going to do. And it's going to take time for that even to get filed. So we will check back in with the Kouri Richins case when we are done with the Karen Reed trial. Yes, having two KR defendants is confusing. We will try to keep them separate, but it seems like we'll be in trial next week on the Karen Reed case, and that's what we'll be covering until that case is done. Remember, on Monday, I put out the Emily Show podcast on all of your favorite podcasting apps and on my second channel, which is currently called Quick Bits, but it feels like it doesn't really fit all the way anymore. That's also where we put the clip downs from the stream. So again, in the Law Nerd app, whenever there's a new episode, we just push it to you. But that drops on Monday, and we'll update you on everything outside of the trial. And then as we get into trial coverage, there will be day-by-day clips of the trial if you need to stay in the loop, or if you missed a day, or just like, okay, just tell me what happened today, give me the high points. That all lives on the Emily D. Baker second channel, the Quick Bits channel. So if you have the app, you won't miss a thing. But if you're looking for those shorter summaries, that's where they will live. Law Nerds, maybe call it the Extras channel. I don't know, something, because it's not really Quick Bits, because the podcast lives there now, and it started as Quick Bits, and then there was a Quick Bits podcast, and that's now just the Emily Show. I don't know. We're working on it so it's clear for y'all and for me. But the podcast drops on Monday. The clips drop when there is shit that's important to clip. And the app keeps you in the loop with all of it. So it's like, fine. Mods, thank you so much for the long court days today. It's time for me to go and keep an eye on the weather. So I'm going to go do that. Law Nerds, I appreciate you. I will see you back in court next week. Take care of yourselves. Take care of each other. And yeah, have a great weekend. Bye, guys. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.